Notices and Be seated, thank you. All right, good morning. Anything we need to address before we get started?
Your Honor, just how the court is going to handle the introduction of what we're going to be doing with Dr. Foley.
Okay, yeah, good point. Typically, the instruction given let's see. There's the deposition testimony. It doesn't say deposition, though. Members of the jury, the sworn testimony of Michael Foley given before trial will now be presented. You are to consider and weigh this testimony as you would any other evidence in the case.
Yeah.
That's good enough?
And if we could also maybe just introduce the fact that a certain portion of that testimony is going to be with Karina Flores reading a small section of the transcript.
Okay. That's fine. All right. Anything else?
Just in terms of form, I guess I'm asking, is the court going to say, okay, defense, your next witness, and I can say defense calls Dr. Michael Foley and then instruction?
Yeah.
Okay.
All right, you can bring him in.
I just have one. This is going to be for when we get to Michael Knox, just to supplement our prior argument. I spent some time yesterday going through his testimony, so I just have a little more argument about the admissibility of the mannequin photographs.
Okay, all right. We'll talk about that, I guess, at a break before we do him. How long is this?
It's about an hour 15, something like
Okay.
that, a couple minutes on the
Yeah,
introductory.
CV, okay. And who's going to read what?
Ms. Flores is going to be Dr. Foley.
Okay.
And I'll read the questions that I asked Dr. Foley
Okay,
in terms of the introduction.
Ready for the jurors, Your Honor?
yeah.
Jurors in the courtroom.
Good morning, ladies and gentlemen. Welcome back. Were you all able to abide by my instructions during the recess? All right, then we're going to get started. Thank you. All right, Mr. Michaels?
Good morning, Your Honor. Defense calls Dr. Michael Foley.
All right. Members of the jury, the sworn testimony of Dr. Michael Foley given before trial will now be presented via video. You are to consider and weigh this testimony as you would any other evidence in the case. And before we get to his video testimony, Attorney Flores and Attorney Michaels will be reading the portions of his testimony previously given, describing his qualifications. So Ms. Flores will read the part of Dr. Foley, and Mr. Michaels will read his part.
Thank you, Your Honor.
Go ahead.
Ms. Flores.
Yeah, you can come up to the witness stand, please. And the witness was previously sworn in the prior reading. So Ms. Flores will read it just as it is in the transcript.
Thank you, Your Honor. Dr. Foley, what is your present occupation, please?
I'm a diagnostic radiologist and a forensic radiologist.
What's a diagnostic radiologist?
So a diagnostic radiologist is a medical doctor whose job it is to read films of the human body. So whether they're x-rays or CT scans, MRI scans, we read those films and we make a diagnosis of what is going on inside of the patient based on the images.
And what is a diagnostic radiologist?
That one was just diagnostic radiologist.
Forensic?
Forensic radiologist is looking at the images with an eye towards whether the findings are new or old. So in other words, if they're chronic and degenerative or old, or whether they're new and acute.
And have you always been exclusively a forensic radiologist?
No, sir. I've been in practice for 34 years. I've worked at hospitals for 20 years. One of them right in Dade City Hospital, where I was chairman at that hospital for several years. And then I worked at imaging centers for multiple years. And then after those imaging centers were sold, I am now doing forensic radiology.
Okay, let's talk a little bit about your medical educational background. What qualifies you to be both a diagnostic and a clinical radiologist?
Right, so I guess I would start out with internship and so forth. Following college, I went to medical school at Northwestern University in Chicago from 74 to 78 and graduated with an MD degree in 1978. From there, I did a medical internship. And a medical internship, as the court is probably familiar with, is where a physician rotates through the 12 different specialty areas in medicine.
Where did you do your internship at?
I did my internship at the University of California, San Diego. And so it's a one-year rotation going through the 12 different areas. And it helps most physicians figure out what area of specialty they want to go into. So after doing that, I decided I wanted to go into diagnostic radiology. And I returned to my alma mater, Northwestern University, to do what's called a diagnostic radiology residency. So the residency is one specialty training in diagnostic radiology.
Is there some kind of hierarchy among residents?
Well, of course, the first year, second year, third year, and so forth. But in your last year, the professors in the program pick a chief resident. So one resident to be in charge of all of the other residents. And that person would also have teaching responsibilities to all of the other residents in the program.
And were you ever so honored?
I was honored with that. I was elected by the professor of the program to be chief resident at Northwestern in my senior year.
And are you board certified?
Yes, sir. So following completing the residency at this point, one is considered board eligible. It means you've completed a qualified program. But to become board certified, you have to take the board certification tests. And they consist basically of an 8-hour oral exam where you're tested in the 12 areas of radiology shown. If you pass that test, then you're invited back in about 3 months to take an oral board exam. Again, tested by approximately 12 different experts from throughout the country who show you unknown exams. And if you pass that test, then you are at that point board certified in diagnostic radiology. So I took that test in 1982 following completing my residency, passed both of those on my first attempt, and became board certified in diagnostic radiology in 82.
After becoming board certified, did you do any additional training in radiology?
I did. I stayed on at Northwestern University for an additional year to do what's called a fellowship. And a fellowship is an additional year of focused training. Following completing the fellowship, it qualified me to be able to take an additional board exam, this time in nuclear medicine or nuclear radiology, which has to do with using radioisotopes to image the human body, such as a bone scan, looking for metastatic disease or a kidney scan, liver scan, brain scan. And I took both of those tests, written and oral, passed both of those on my first attempt, and became board certified in nuclear radiology in 1983.
Now that's 2 boards. After that, did you continue your education and training?
Well, at that point, I did go out into practice. But while I was out in practice in 1996, the American Board of Radiology offered for the first time a separate board in interventional radiology. And interventional radiology is the minimally invasive aspect of radiology. So in other words, doing things with needles, guide wire, catheter, and bringing those things into the body and being able to carry out a therapy. So as an example, an angiogram and angioplasty, putting a stent in an artery, whether it's a carotid artery or a kidney artery, running a microcatheter up into the brain to dissolve a clot before the person gets a full-blown stroke, or to coil an aneurysm in the brain so that the person doesn't need to get their skull cut open and their aneurysm clipped. So I had been trained in interventional techniques at Northwestern University, but there was never a separate board for that. So once that became available, I decided to go ahead and take that test, and I passed that on my first attempt as well. So at that point, I had achieved 3 separate boards in radiology. diagnostic radiology, the nuclear radiology, and the interventional radiology.
Is that rare in your field?
It is. Most people seek to get board certified, but usually you don't see very many people with 3 separate boards.
Let's talk a little bit about your work history and the positions you've held. I know you spoke about being here in Dade City. Talk to me a little bit about your work history, the different positions you've held.
Okay, so when I left Northwestern after my fellowship in '83, I moved down to Tampa, Florida. I joined a relatively large radiology group in the Tampa area. I think I was the number 15th member in the group. That ultimately, over 20 years, grew to be one of the largest radiology groups in the state of Florida, with 55 men and women radiologists. I was on staff at 7 different hospitals throughout the Bay Area, on staff as a radiologist at Manatee Memorial Hospital in Bradenton, at the Brandon Regional Medical Center, at University Community Hospital, which is now called Florida Hospital University, Community Hospital Carewood, St. Joseph Women's Hospital, Dade City Hospital, and Newport Richey Hospital. Early in my career, I became assistant chairman of radiology at the Manatee Memorial Hospital in Bradenton. Then later, I was elected chairman of radiology at Dade City Hospital, right up here in the Dade City area. Served as chairman of that hospital for multiple years. Then following that, I was elected chairman of radiology at Brandon Regional Medical Center, where I served for about 10 years as chairman and also sat on the executive committee at that hospital for about 10 years.
Now, have you served on any committees or had any leadership roles in various medical organizations?
I have. I've sat on some national committees. One of them is called the Society of Interventional Radiology, and I was on that committee for several years. I have worked locally, I'm on the editorial board of Hillsborough County Medical Association Journal. I've also served as president of the Florida West Coast Radiology Society, which is a membership of radiologists up and down the west coast of Florida, wrapping around from the Panhandle all the way up to Miami. And this is an organization where we use the dues that we collect from radiologists to fly in experts from around the country to give us a lecture. And then we can sit with them after the lecture and compare how they're doing things at the Mayo Clinic or Mass General or UC San Francisco compared to what we're doing at our hospitals in the Tampa Bay area.
What's the American College of Radiology?
So the American College of Radiology is an organization that oversees all radiologists throughout the United States. And most radiologists do belong to the American College of Radiology.
Now, I understand that you are a fellow of the American College of Radiology. Is that true?
That is true.
What is that?
So a fellow is one of the highest levels that you can achieve in the American College of Radiology. Basically, one will need to be nominated and elected as a fellow, and it's based on your contributions to radiology, leadership roles in radiology, or publications and teaching in radiology.
Being the X-ray statement occurrence Reeves 2000, June 2015, both stimulated to body state. Dr. Foley, you've had an opportunity to actually download the information that we provided you into your own computer, is that correct?
Yes, sir.
And is that what we have here on this table to my left?
Yes, sir, it is.
If you would, please, with the court's permission, Dr. Foley, would you come down and let's take a look at what we have here.
Okay, very good.
If Dr. Foley is going to testify, share his back as court to the state, is there any way that we can hook up a microphone or something so that we can hear him, because he's really talking down into his computer away from us?
Just move the mic, I guess, down a little bit.
Okay, now, Dr. Foley, you've had an opportunity to look at both X-ray images and MRI, is that correct?
Yes, sir.
And what is the difference between an X-ray and MRI?
So, an X-ray basically is one of the oldest imaging studies around. X-rays have been known for over 100 years. An X-ray basically is a form of invisible light, and it was discovered that if one focuses an X-ray and shoots it through a body part, say with film underneath, it can record images of the human body. So basically, an X-ray shows us bones very well. It allows us to see if there is a fracture or a dislocation, allows us to see if there are arthritic changes of the bones. And it's a common imaging study even today. X-ray does not show certain things, though, like you cannot see the spinal cord on a spine study. You do not see the disc. You do not see the spinal cord or the nerve roots. So if we want to see those type of findings, we need to go to a higher imaging study, which would be an MRI, which stands for magnetic resonance imaging, sometimes referred to as MR, magnetic resonance. And it basically is not an X-ray study. It doesn't use ionizing radiation. It takes advantage of the fact that our body is composed of about 75% water, H2O, and it was discovered that the hydrogen atoms in water, when put into a magnetic field, give off a magnetic resonance, a signal that can be picked up by the MRI scanner, and it can locate each and every one of those signals of the hydrogen atoms in three-dimensional space and locate them in an X, Y, and Z plane. And so from all of this information, very accurate images can be constructed of the human body. So for the first time, we can accurately see the discs, the spinal cord, the nerve roots, brain tissue, all sorts of things that we couldn't see before on regular X-rays. So as you said, in this particular series of studies, we have X-rays and MRIs to look at.
Okay, and you've arranged them in kind of a logical order, is that fair to say?
Yes, sir.
And where are we going to start?
Well, we start right up at the top. I've got them labeled 1 through 11, and so we can look at, first of all, the hands.
Let me ask you something before you get there. If you could pull back a little bit, please. What is this writing we see on the image, up on the left and the right-hand side?
Yes. So let me focus in on this. So this is just all the verification that the pictures we're looking at are of the particular patient we're talking about. So in this case, it says the imaging center Rose Radiology, where the study was carried out. It says the patient's name, Curtis Reeves. It gives the date of birth, 8/31/42. States the patient is 72 years old. And then over here, this is telling us the date of the study. So this study was performed on 6/8/15, so June 8, 2015. So most of the images that we're going to look at were done on either June 8, 2015, or the MRI studies that we'll look at were done on June 9, 2015.
So what are we looking at here, doctor?
So these are views of the hands, the right hand and the left hand. And what we can see is arthritic changes of both hands. But I'll focus in on some of the findings so the jury and the judge can appreciate this. This is the thumb right here we're looking at. And all of these are bones of the wrist called the carpal bones. If we focus into this area right here, we're looking at what is called the radiocarpal joint space, and this is the first metacarpal bone. One of the things to notice is how close the bone is to one another. So in other words, if we use this as an example here, notice that we see a space between this bone and this bone. That's because cartilage, which cannot be seen on an x-ray, separates the two pieces of bone. When the cartilage is worn down or worn out, we get this bone-on-bone appearance that we see here. So this would be an example of degenerative change of the first carpal metacarpal joint, where we literally have bone-on-bone. Also realize that bone reacts by, when it develops degenerative change, by trying to thicken up the bone. And the thickening of the bone causes the bone to appear denser on the x-ray, and dense bone will look white. So if we look down here at the radius, so we're right at the wrist, this is the radius, this is the ulna. Notice that the bone is very white here. That is sclerotic bone or thickening of bone. Notice the bone right here and right here is very white, so that is more sclerotic bone. Even note where we have the wearing out of cartilage right here, we also have this white line of sclerosis, which is a sign of degenerative change. As we look at the other bones throughout the body, or throughout the hand here, and this is the right hand, we can see narrowing of the interphalangeal joints. So the interphalangeal joints are the various joints of the fingers, and that narrowing is degenerative change there as well. White sclerosis is degenerative change. So this patient has degenerative change, particularly at the so-called DIP, distal interphalangeal joints, which are the distal most aspect of the joint spaces of the hand. So, and the left hand has similar findings. If we go over here to the left hand, notice we have narrowing of the various joints of the wrist, narrowing and degenerative change of the first carpal metacarpal joint, and then as we go to the interphalangeal joints, we see arthritic changes with sclerosis and narrowing of those joints. So basically both hand films show degenerative changes, both left-sided and right-sided, involving the carpal bones and also involving the interphalangeal joints.
And so when you say degenerative changes, what are you talking about?
So degenerative change is sort of a broad umbrella term to refer to wearing out of the joint space. So we know as we age, we have been moving our body parts for years and years, and that can lead to those joint spaces and those various body parts to wear out. And that wearing out process is called degenerative change. So an analogy compared to like a tire of a car, if you just put a new set of tires on your car and drove the car for 10 miles and then checked the tread on the tire, it would be fine. Nothing much would be happening after 10 miles. But if you check those tires after 40,000 miles, the tread would be worn down to some degree. So that would be degenerative change in a way, or wearing out of the tire. Same kind of process is going on inside the human body, where we're slowly wearing out our various body parts over time.
Now, would you agree or disagree with me that those changes happen over a period of time and not overnight or maybe within the years?
But that's true. I mean, degenerative change in general takes years and years. So It's not something that pops up in 6 months or a year or something like that. It takes many, many years to get the kind of findings that we're seeing here.
Now, an individual with a similar x-ray, would it be consistent with somebody who, let's say, had trouble opening a jar?
Yes, well, particularly since we noticed that the degenerative change of the joints of the thumb are prominent in this patient. As we can see here, we see another nice demonstration of sclerosis of the bone. So typically, a patient with this kind of degenerative change in this location will have a weakness of hand grip, for instance. And one of the things that people tend to notice when they have that is that the jar, they can't open a jar. You know, you have a jar of pickles or mustard, can't get it open because the whole grip of the hand is not as strong as what it used to be.
And you talked about distal phalange, you talked about the fingertips.
So basically, right, that joint right before you get to the nail of the finger, this is where we're seeing degenerative change as well. So we're even seeing like this little osteophyte that's showing up right here.
What's an osteophyte?
So an osteophyte is basically a bony growth. Osteo means bone, and phyte means growth. So the bone, by constant rubbing, bone on bone, develops thickening of the bone and eventually turns into these bony osteophytes that we see.
Now, the x-rays we're looking at concerning the fingertips, I know not your term, the fingertips, would that be consistent with somebody who now has trouble maybe doing detail work with their hands, such as stitching, for instance?
Yes, when you have degenerative change in the fingers, we often notice we are not able to move our fingers as well, so sometimes that is reflected in their handwriting and, as you said, in any kind of detailed work that one might do.
Okay. And can we look at, I apologize, Doctor, can we just look at the image number just so we can put it on the record, please?
So that image number that I had was number 1, which was of the bilateral hands. That was done on 6/8/15. And so now we can move to the wrists. Take a quick look at that. So again, the wrists are this area of the hand, so that all of these carpal bones down here are part of the wrist. This is the radius right here, and this is the ulna. And again, basically it's showing us the same thing that we already saw in the hands, just a more focused down view. And we already saw in the hands, just a more focused down view. And it particularly nicely demonstrates the bone-on-bone appearance of the degenerative change of the first carpal metacarpal joint. So there's literally seeing bone-on-bone here with the dense white sclerosis of the bone, particularly involving the region of the thumb of both hands. And the next one we'll go to is the left shoulder. And the left shoulder is where obviously the humerus, the long bone in our upper arm, connects to or articulates with the scapula, which commonly layman's term might be considered like the wing bone, but in medical terms this complex appearing bone as outlined here is part of the scapula. And the scapula has a curved cup-like shape called the glenoid, and the humeral head articulates and connects into this glenoid area. This part that we're seeing here is the collarbone, and over here is the acromion, and this area right here. And if we look over here, this is called the AC joint or acromioclavicular joint. And what we're noticing is that the patient has osteophytic changes in this region as well. So this pointed piece of bone here and the pointed piece of bone here is arthritic change of the AC joint. If we move over here, we can again see some more osteophyte here and here. So the important point of seeing the degenerative change at the AC joint is to realize that the rotator cuff, the muscles, and then the tendons come through this region right here and connect to this area of bone called the greater tuberosity. So in this region is sometimes referred to as a critical zone. And so as someone attempts to lift their arm up, this muscle and tendon system works as a pulley to lift the humerus up from this edge, but the tendon tends to get scraped across these osteophytic changes that are right here, which can cause pain in any individual patient and can scrape the tendon to the point that the patient can eventually develop what is called a rotator cuff tear, where the tendon is actually frayed and kind of sawed through that area so that the tendon eventually becomes completely torn.
And what we're looking at, again, the same sort of question in terms of time period. Is this something that's degenerative in nature, happens over a period of time, and not something that is the result of an acute injury, for instance?
That's true. Again, all these degenerative changes that we're pointing out typically take years to form. This is not something that you get in a relatively short period of time. So this is the left shoulder. If we move over here, that was number 3 on this list, so number 4 will be the right shoulder. If we look at this, not surprisingly, we see the same kind of findings. So here is the acromioclavicular joint. This is the clavicle right here. And this is the acromion process of the scapula. The space in between is the so-called AC joint or acromioclavicular joint. Perhaps the judge has heard of AC joint separation. Sometimes football players get this kind of thing where the AC joint is separated. But notice again here, just like on the left shoulder, we're now looking at the right shoulder, we see this bony osteophyte right here. And the critical nature of something like that is, again, the tendon of the rotator cuff passes through here and attaches over here. So with this piece of bone now in the way, it serves as a mechanism where it can scrape away and saw away, if you will, at the tendons of the rotator cuff and can cause pain, can cause rotator cuff tear, for instance, in any individual patient.
Is an individual who has an X-ray like this, is it consistent with somebody who has difficulty raising their arm?
Well, it is because, realize again, the rotator cuff muscles and then the tendon come through this area and attach over here. I think we see it better on this, where it's the greater tuberosity. So if the muscle has to pull the tendon through this area, this tends to be painful. This often causes limitation in movement of the shoulders. It often causes the person not to use their shoulder so much because of the fact that it hurts when you do it. And so consequently, the muscles of the rotator cuff begin to lose mass and become what is called atrophy or shrink. So the muscles become smaller in size and become weaker. So it is not unusual when we see patients like this that they have limitation in range of motion, they have shoulder pain, the muscles in this region are often atrophied and have gotten weaker over time.
And in older patients, would you expect some atrophy whether or not we had such an acute, is that also called a bone spur?
Yes, sir. Bone spur is a typical layman's term, for instance, for an osteophyte, which is a medical term which simply means osteobone, phyte meaning growth.
So my question was then, even if we didn't have that bone spur, would we expect in an elderly patient to see diminished muscle mass?
Well, I think that's true in almost everybody. As we get older, we do lose muscle mass over time, even despite the fact that we try to go to the gym and work out and everything. It might help maintain some of the muscle mass, but we invariably do get weaker over time. We invariably lose muscle mass over time, despite our best attempts for most of us.
And might an individual whose x-ray looked like this have difficulty in picking up heavy items?
Well, that's true. I mean, anytime you have to use the shoulder, you're going to be affecting this area, and it could be difficult in any particular patient to lift heavy items up, to move the shoulder in general because of the limitations by the AC joint arthritis.
And is there anything else that we see that is of interest, Doctor?
I think those are the main findings on that, the type of degenerative changes that can occur. And so here, just to go through the anatomy a little bit, this is called the femoral head right here. This is called the greater trochanter. This is where tendons attach from the muscles in our thigh. Right here is the hip joint. And notice that we again have this finding of this dense sclerosis along the 11 o'clock, 12 o'clock, 1 o'clock region of the acetabulum. And again, the acetabulum is the cup-like shape of where the femoral head fits into the pelvis. So, and it makes sense that we would see something like that in this region because as a person is standing, they're putting a lot of pressure on the upper aspect of the acetabulum, and so the bone tries to add additional bone density, which creates a sclerosis, but is also a form of degenerative change. Also notice if one evaluates the vertical height between the femoral head here to there versus the vertical height of the femoral head from here to here, notice that it's narrower here, and that again is a sign of degenerative change of the hip. Same kind of other finding though, remember we talked about the osteoporosis, how we have some dense bone here, but lucent bone over here, lucent bone over here, lucent bone over here. This is all evidence of osteopenia, osteoporosis of the bone.
Anything else remarkable about the hip we're looking at, Doctor?
I think that's about it for the time being. We can go now to the left knee. And this again, we're still on 6/8/15.
I forgot to ask you, I apologize. The x-ray of the hip and the degenerative properties that you described, is that something that we would expect to happen over time, as in the other x-rays?
Yes. Again, typically degenerative change takes years and years to develop. So this is not something that just pops up in a year or two. It generally takes many, many years. I having gray hair, I kind of related to a person, how long does it take to get gray hair? Many times you're not going to be able to say, my hair went totally gray in a year or two. It generally occurs over a long period of time. So maybe in your late 20s or 30s, you have a few speckles of gray hair, and then your 30s and 40s, you got more gray hair, and now it's going from gray to white, such that by the time you get into your 60s, you have all white hair. So you could look at somebody like that and feel fairly assured that they didn't go from brown or black hair to gray hair in a matter of a year or two. It typically would take many, many years, whether it's 5 years or 10 years or 20 years, who knows for sure in that individual, but it would take more than just a year or two. And so the same kind of thing with degenerative change inside the body. It doesn't happen in 1 or 2 years. It takes many, many years to get that.
Onto the knee.
So we'll go to the left knee now, and this is 6/8/15. So I'll show the judge this one first. This is so-called standing views of the knees, with the person standing up and the x-ray plate behind their knees and the x-ray is shot straight through. So this is the left knee over here. This is the right knee over here, just to go over some anatomy. This is the femur, which is the long bone of our thigh coming down to form part of the knee joint. This round piece of bone is the kneecap, or medically called the patella, right here and right over here. The two bones that are seen that go from the knee joint downward, the larger bone is called the tibia. Commonly people call this the shin bone. Sometimes we accidentally run our tibia into the coffee table or something like that, and this is that major, larger bone. The smaller bone out to the side of our calf, both left side and right side, on the outer side is the fibula. And so these are the two bones of the lower knee joint. So the knee joint is actually this part right here, where the femur bone comes together with the joint space, and then the tibia here and the fibula here. And what we're seeing basically in this is that we're seeing the medial knee joint, medial meaning the inside of the knee joint is narrow. It should be wider than this. And if we compare to the lateral knee joint, it should have a nice vertical height like this, but right here it's narrowed both on the right side and on the left side. In addition, we see sclerosis, this white thickening of bone along the tibial plateau. This whole area is called the tibial plateau here. And we've already learned that the buildup or thickening of bone is called sclerosis, a sign of degenerative change, and losing the vertical height of the joint is also a sign of degenerative change. And so the patient has a pattern that's typical for developing degenerative change in the knee, and that is it's affecting the medial side of the knee joint. And the court may not know that in most people, it's the medial side of the knee joint that wears out first in almost all people, and that's because just the angle of the way the femur comes down, when we stand, we put most of our weight on the medial aspect of the knees, and thus we tend to wear out the medial aspect of our knees faster than the outer or lateral aspect. And so it's quite common not only to get the degenerative bony changes like we see here, but also to get tears of the meniscus, the cartilage that fits in between these two bones. So the court may have heard of medial meniscal tears being discussed in other patients, other cases, and this is the reason why, is this is the area that gets the biggest workout. If we look at the side view or lateral view, and again we're looking at left knee here, notice that we see this patella from the side, the kneecap, and notice that we see the patella lying very close to the femur, the femoral condyle, almost bone on bone. Now realize the bone of the femur is capped by cartilage, and the back of the patella is capped by cartilage. So when one has degenerative change, the cartilage wears out, and this bone-on-bone appearance begins to occur. And notice, if you want to see an osteophyte here, this pointed piece of bone right here is an osteophyte, bony overgrowth. So when this person is moving or walking, this patella would be rubbing bone on bone in this region, and this osteophyte would be scraping on the cartilage and on bone. A kind of finding that we all can get when we get in our 70s, just from the use of our legs and our knees over time. So that was the left knee. If we go to number 8, which is the right knee, again, we already went over this front picture, the standing view, where we see the medial right knee joint narrowed. But let's look at the side view for a second. And again, in this view, notice that the patella is high riding. That means we'd like to see this patella down more along this region. In other words, the top of this patella should be sitting down here more. And it's not, so one might question whether the person has had some previous injury to the tendons attaching to the patella. That would be the quadriceps tendon up here, attaching to the patella, and the patellar tendon down here. Nevertheless, we can see this bone-on-bone appearance, just like we saw in the left knee on the right side, a sign of degenerative change of the meniscus. So basically, we have degenerative change of both knees, involving the medial knee joint and involving both what are called the patellofemoral joint, meaning the patella and the femur are narrowed in that area, thus called the patellofemoral joint.
Would you agree with me that we can't see pain on an X-ray?
That's correct. We can see the anatomy on X-rays and MRIs. We cannot tell what severity of pain the patient may be in at the time, just based on the X-ray or the MRI.
But based on what we're looking at, would it be inconsistent with an individual that complains of knee pain, for instance?
No, not at all. I mean, it's quite common when people have degenerative change in their knees like this that they would have pain.
And you're calling it degenerative changes, so we're talking about these changes happen over a period of time.
Yes, sir, typically many years. We then go, so at this point we're going to go from the 6, 8 studies. We've covered all the regular X-ray studies, and now number 9, 10, and 11, we'd be covering the MRI cervical, MRI thoracic, MRI lumbar, done the next day on 6, 9, 15. Should we keep going and go to the cervical now?
Let's do that.
Okay.
And before we go to the cervical, I noticed there looks like 6 images. How does a radiologist actually look at MRIs? Do they do it just in still images?
Okay, well, I'll show you. And just as an example, I'm popping up this still image, and we'll go more thorough to explain it about what this side view or sagittal view is and what this axial view. But if you'd like, I can just bring up the whole study so that the court can see how one would analyze a study. Is that okay? So if we open up this study, basically we can see all the different images that were performed on this exam. We can see that 9 survey images were done, then 15 sagittal images, so-called T2 weighted, which makes the spinal fluid white, 13 sagittal or side view, so-called STII, STIR images, which allows us to see fluid signal particularly well, 13 T1 weighted images where the spinal fluid is back, and then 28 axial images. So to show the court how one might evaluate this, if we press on the sagittal images and make this larger so we can see it, notice when we first start looking at the side view, and just for orientation, this would be the person's chin here, and this would be the back of the neck over here. We're not really seeing any cervical spine yet, and that's because this initial image is taken off to the side, and then as we move forward, we're beginning to now cut into the cervical spine. Now we're into the mid-cervical spine, where we can see spinal cord, and as we cut through, we're cutting out of the cervical spine, getting to the opposite side of the neck. So just toggling through this, there's certain things that we can see. what we're noticing here, and if I zoom this up a little bit, this tall vertebral body in the cervical spine is called C2 or cervical 2. And then from there, once we identify that, we can count down to C3, cervical 4, cervical 5, C6, C7. One of the first things that we can notice is if we look at the back of the disc, we can see some discs are flat, like this disc at C23, and some discs are sticking out, like we see at the C5, 6, C6, 7 levels. So let's go now and look at an axial view. An axial is a cross-sectional view. And so if we look at that, we're now seeing, I'm going to bring this down a little bit. We're now seeing both the axial view and the sagittal view. The sagittal is the side view. The axial is the cross-sectional view. And if the court notices there's a line coming through the spine right here, and as I rotate this line moves. So this line is telling us what level we're cutting through which disc. So if we bring this line down to where the disc is the biggest, right here, and let's bring that over here, and let's adjust it a little bit like that. So what we can see here is that the disc is sticking out, coming very close to the cord, and the disc is sticking out here. Now I have a magnified picture of that so we can see it even better, which would be this view that the court can take a look at. And in this view, we can see that the disc is extending out and herniating out into the spinal canal. Now, just for orientation, this is the cervical spinal cord, this structure running up and down. The white is spinal fluid wrapping around the cervical spinal cord, and the disc sticking out shouldn't be like that. It should be flat like the disc above. If we want to talk about this disc, we call out the vertebral body above and below. So if I want to talk about this disc, I would say at the C5, 6 level, meaning the disc between C5 and C6, there is a disc sticking out, and it's approaching the front surface of the spinal cord there. If we want to look at that in the axial view, we come over here, and in this cross-sectional view, all of this is herniated disc material sticking out into the spinal canal and lying up adjacent to the cord. Realize this entire area here should be white. It should be white spinal fluid. Here's the spinal cord right here. So this disc is sticking out and coming very close to the cervical spinal cord. If we go to the next level down and analyze this from the side view, the sagittal view, notice the disc is sticking out here. It's extending upward and extending downward. So this means that the disc has literally herniated out of the wall of the disc with jelly material extending upward and downward. So that is called a disc extrusion. And if one looks at the front margin of the cord, notice how the cord has like an indent here. That means, and that tells us that as this person flexes their neck forward, the cord bends over these regions, and the herniated disc has literally caused an indent into the cord in this region. If we look at it from the axial view perspective, notice how close the herniated disc is to the front of the cervical spinal cord. There's virtually no white spinal fluid here separating the back of the disc to the front of the spinal cord. And so those are the two most important features on this study. However, there's a lot of degenerative findings. For instance, the court may not know that the disc should have a white-looking center like we see here. But notice all these discs are black, 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 black. All of the discs that are black like this mean that they've lost the water content in the disc. So all of these discs should have a grayish-white center to them. That loss of water content is a sign of degenerative change of the disc, where fluid has leaked out of the disc over time. And
Why is that important, Doctor?
well, it's just a sign that this person has multi-level degenerative disc disease changes up and down the cervical spine, really sparing the C4-5 disc, but all the rest of the discs are all degenerated. If we want to see a nice example of an osteophyte, here is a bone spur sticking out here, bone spur sticking out at this level, bone spur over here at C6-7 sticking out, and in the back we have these herniated discs sticking into the spinal canal. So these findings are very significant because in general it is thought that the cord does not like being touched by anything except spinal fluid. So when you have these findings sticking out into the spinal canal, touching the spinal cord and lying near the spinal cord, this can cause symptomatology for a patient. This can cause weakness of the upper extremities for a patient.
And when you say symptomatology, what do you mean?
Well, symptomatology meaning pain, tingling, numbness, things of that nature would be the kind of symptoms one can get.
Okay, what do we have next?
Okay, so we're going from the cervical spine, which was number 9, MRI cervical spine. We'll go to the thoracic spine. So the thoracic spine, as the court probably knows, the neck is called the cervical spine. We've got 7 cervical vertebral bodies. The mid-back is the thoracic spine. There are 12 thoracic vertebral bodies. These are where our ribs are attached to our thoracic vertebral bodies. So we know we have 12 ribs on each side, and we also have 12 thoracic vertebral bodies where the ribs can attach. The key finding here, so there's lots of disc levels in the thoracic spine because there's one disc between each of the 12 thoracic vertebral bodies. But notice at first glance, all of the discs in the thoracic spine are black. They're darkened. That's called disc desiccation. So every one of these discs are degenerated up and down the thoracic spine. Notice that we have prominent osteophytes at some levels in the thoracic spine. But here's probably one of the more important findings is we have a disc sticking out in the mid-thoracic spine right here at T7-8, and it is immediately abutting the thoracic spinal cord. We can see it right here, and if we go over to this view, we can see it right here. So this disc is sticking out and immediately abutting the thoracic spinal cord. Again, the importance of that is just like in the cervical spine, this can cause symptomatology such as pain, weakness, tingling, numbness. It can also be a source of overall weakness to the person's back because of pressing on the spinal cord at that level.
Now, we're looking at a still picture, a static image. Is that how it works in the body? The spinal cord just stays in one place?
Right, well, that's an interesting question. Just like in the cervical spine or thoracic spine, obviously we need still images to get clear pictures of the spine and vertebral bodies and the cord, spinal cord. But in real life, obviously, the neck flexes back and forth, the thoracic spine flexes and extends back and forth. So what happens is that this spinal cord actually moves and slides up and down within the spinal canal. And so the spinal cord itself can get scraped and roughened up by these discs that stick out. And we saw those 2 significant discs in the cervical spine and this one disc in the thoracic spine. So the point I think you're raising is that the spine actually moves, and so the spinal cord itself inside is going to be moving and scraping up and down against these discs and spur formation that sticks out. And that in and of itself can cause problems to the thoracic spinal cord and cervical spinal cord, leading to effects on the nerves that are contained in the spinal cord. So that's the thoracic spine, and then lastly, we have the lumbar spine, number 11. And this was fairly remarkable because of this finding. So here's the lumbar spine. So we've covered cervical, where we have 7 cervical vertebral bodies. We've covered the thoracic spine, the mid-back, where we have 12 thoracic vertebral bodies. Now we're into the lower back. And for orientation purposes, these are the vertebral bodies. This is the lowest one in the lumbar area. This is called L5, then L4, L3, L2, L1, and then this is thoracic 12 here. So what I put an arrow on is this finding right here. There is a cystic appearing fluid collection in the lowermost tip of the spinal cord. So if we back up a section, probably most folks that aren't medical people do not know that the spinal cord itself ends typically at about the T12 or L1 level. It doesn't run all the way down to the lower part of the spinal canal. So if we look at this patient, here's L5, L4, L3, L2, L1. It's ending in the typical location of many patients, where it's ending at around the L1 level. Some can end as low as T12, others go down to L1. But what we have is we have a fluid collection in the spinal cord. This is not normal. It's not typical. This is called a syrinx. And a syrinx is an abnormal fluid collection within the spinal cord itself. This can cause weakness because it affects the nerves running down the spinal cord. And we see this nicely demonstrated on the lumbar view at the T12 L1 level. And this is the corresponding axial view. And if you look at this for a second, here is the spinal cord. And this round hole, essentially, that we see in the spinal cord is the syrinx. So there literally is a cystic cavity in the spinal cord itself, which in general can cause weakness for a patient, sometimes incoordination of the legs, may even cause imbalance for a patient. Also, look at the disc. We've learned to look for disc desiccation now. Look at the disc here. It's black, 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 black. These lower two have a small amount of remaining fluid collection in the disc, so this is some residual hydration in the disc. But we have multi-level degenerative discs. These discs are not, even these down here, are not as white as what they should be. They should be comparable to the white spinal fluid, and they're not. So all of the discs have become desiccated to some degree. If we look at one last finding here, we're seeing what is called an annular tear, and the court has probably heard about annular tears before, where the outer wall of the disc, called the annulus, is torn, and this can be a source of degenerative change and may cause symptoms for some patients. So really, we took sort of a whirlwind tour up and down the cervical, thoracic, and lumbar spine and saw 2 large herniated discs in the cervical spine. We saw a disc sticking out and touching the cord in the thoracic spine. In the lumbar spine, we saw a cystic cavity in the lower spinal cord called the syrinx. We see multi-level degenerative changes up and down the lumbar spine, and finally we see this annular annular tear in the lower lumbar spine.
This syrinx, is this a common occurrence?
No, it's actually rather rare. They can be produced by trauma, and they can be congenital, but, if you lined up 100 people, you wouldn't hardly see it in one or two people of that entire 100-person population, so it's not a very common finding.
From the appearance of the syrinx, is this something that would take time to develop?
Well, it would, even if it's trauma related, it takes time to develop, but something like this likely has been around for many, many years.
Thank you. I don't have any other questions.
Okay, thank you.
Want to take your seat, please?
Yes.
One last question.
All right.
Now, the opinions you've expressed today, are they all within a reasonable degree of medical certainty?
Yes, sir, they are.
I don't have any further questions.
Thank you.
Yes, sir. Thank you, Judge. Afternoon, Dr. Foley.
Good afternoon, sir.
I'll go back a few minutes to the beginning of your testimony. You didn't hire by the defense in this case.
Yes.
Did you sign an employee contract with them?
No.
All right. And your hourly rate to be paid in return for your services?
It's $750 an hour.
And up until today, how many hours have you put into this case at $750 an hour?
Well, the total bills, I think we talked about before, adds up to $5,000. $2,900 of that was review of the films, which are just flat fee charges. And then I had 2 one-hour conferences and spent about 30 minutes loading the films on the computer and selecting out the images.
And then you have your time here today.
Yes, sir.
Which you haven't billed for yet.
Good night.
All right. Before we get into the individual x-rays and MRIs, you would agree that not everyone has the same pain threshold. That's a fair statement, isn't it?
True.
Prior to coming in the courtroom today, did you have an occasion to sit down with Mr. Reeves and conduct a medical history?
No, I want to make that very clear to the court and the judge that as a radiologist, I read the films of people, so normally I'm not sitting down, meeting the patient, talking to the patient, examining the patient. Basically, my exam of the patient, as most radiologists, is looking at the film, so we're not sitting there tapping on knees or taking a history, we're reading the films of the patient.
In this particular case, what was the years of the last films that you looked at prior to June of 2015 as far as x-rays of Mr. Reeves' hips, knees, shoulders, and fingers?
Those were all June 8th and June 9th, 2015.
Prior to that, what was the date and years of the x-rays that you used to compare with the x-rays of June 2015?
These were the only films that I had, so I read what I was given.
You have no way to go back, say, on January 13th, 2014, and tell this court whether or not what we saw here and displayed today was the same, substantially same, or even different than what was taken on June 8th, 2015.
Well, I think that's true to a degree. We know the findings are long-standing, that it takes many, many years to get those findings, but if no one takes an x-ray on a certain day, you can't, with 100% certainty, say what the film looks like on that particular day.
So what we were presented here today is simply a snapshot in the light of the medical history of Mr. Reeves on June 8th and June 9th of 2015.
That's true.
You cannot, to any reasonable degree of medical certainty, go back and tell this court that at the time of this particular incident on January 13, 2014, that Mr. Reeves' condition was exactly the same as it was presented by the x-rays today. You can't do that to any degree of medical certainty.
No, I would not try to do that because I'd want to have a film done exactly that day. But I'm not trying to say that the films looked exactly the same either. I'm saying those films show degenerative changes that likely took a long time, many, many years. So more likely than not, I could say that these kind of findings pre-existed the date of the incident.
But you cannot say to what extent they existed.
I agree with that.
And along those same lines, if we go back to January 13, 2014, it's just as consistent that the degree of the degenerative, what was the word after that?
Degenerative changes?
Yeah, the degenerative changes that you said have taken place over the years. You don't know to what extent on January 13, 2014, Mr. Reeves was aware of those due to any type of outward manifestations of pain.
Well, as I mentioned to the judge, I'm not trying to testify about what symptoms this patient specifically would have, because in order to find out symptoms, one would have to talk to the patient, interview the patient, and so forth. What my testimony was, based on the degree of degenerative changes, it's common for patients to have pain, but as you say, you could have two people that have the same degree of degenerative change, and one might say they have pain 3 out of 10, and the other person might say they have pain 8 out of 10. So there can be some variability among patients. I'm just saying that more likely than not, these findings pre-existed the date of the incident.
And along those same lines, on January 13, 2014, you cannot tell the judge as an expert to any reasonable degree of medical certainty exactly what Mr. Reeves knew about his physical condition, correct?
Right, I would have no idea. You would have to interview the patient to know that.
And you did not know that?
No, my job is to read what I see on the films.
Which were taken in June of 2015.
Yes, sir, that's true.
Okay. What I'd like to do is just very generally go through the different areas. All right. Maybe, I'm going to think about that in a second.
Okay?
We have a moment of counsel, Judge. Thank you. Thank you, Judge. No further questions?
Thank you. Any readers?
I apologize, Doctor, I forgot to ask you, is there another area of concern regarding the coaxial nerve in Mr. Reeves' MRI? You aware?
The
quite sure what you mean by coaxial nerve. Well, there's an opening where some nerves pass through. Yes. And are you referring to maybe spinal canal stenosis? Is that what you're talking about? Okay. Yes, sir. And did you identify any spinal canal stenosis in Mr. Reeves' images? Yes, sir. Several areas. And the court might remember this, where we see the large herniated discs at C5-6 and C6-7. When the disc is sticking out into the spinal canal, the cord is actually being pushed back in the spinal canal, and so that tightness that is wrapping around the spinal canal, because the disc is pushing into it, is narrowing the space that the spinal cord can come down, and that tightness is called cervical spinal canal stenosis. So stenosis means a focal narrowing, and there is focal narrowing of the spinal canal at C5-6, at C6-7, and then again at the mid-thoracic spine level, T7-8. And that would cause weakness, tingling? Yes, sir, that's true.
Judge, since you brought up a new subject, and I just crossed on that. Dr. Foley, as I had mentioned before, because you did not have any x-rays to compare, you cannot say as an expert to any reasonable degree of medical certainty that on January 13, 2014, that Mr. Reeves suffered from that condition to the extent that you saw an x-ray that was taken in June of 2015. You have no idea what his condition was in 2014.
I understand what you're saying, and I agree with you to the degree that without having a film done on that exact day, you can't say what it looked like that exact day, but I can say within a reasonable degree of medical probability that more likely than not, those findings pre-existed the date of the incident. So I would say the person did more likely than not have cervical spinal canal stenosis from the disc abnormalities that are present. But again, in partly agreeing with you, because you don't have an exact film on the exact day, I can't say exactly what it looked like on that day.
So to any reasonable degree of medical certainty, you can't quantify to what extent that condition exists.
Well, yes and no on that, because I testified that it takes many, many years to get the kind of finding that we're seeing here. So if the time separation was about a year and a half, something like that, between the date of incident and the date of the films, and my testimony is it takes many, many years to get these kind of findings, so I would say more likely than not, the patient had similar findings to what we're seeing a year and a half later after the incident, and those findings existed prior to the date of incident.
And as we discussed before, every individual's pain threshold is different.
I agree with that.
And so an individual who, and I'm just going to use A and B without, let's not make it too complicated. If you have a condition A and it gets worse to B, one person could have pain at A, but really another person could have no pain until they get to condition B, correct?
It's a possibility.
All right. And because you conducted no medical history of Mr. Reeves, and you have no comparison x-ray of Mr. Reeves on January 13, 2014, you cannot tell us any reasonable degree of medical certainty as to exactly how that impacted Mr. Reeves' daily activity and living on January 13, 2014, right?
As I said before, I've agreed with you on that point because my job as a radiologist is to say what I see on the films. I did not do any discussion for the court on what kind of symptoms this particular patient had at a specific date and time.
Thank you for your time.
Thank you, sir. One thing you can be certain of is we're looking at an individual that's aging. Yes, sir. That's true.
Probably a good time for a break. Let's take 10 minutes, ladies and gentlemen, and remember my instructions during the recess, please. And we'll see you back in a few.
All rise, court is in recess for 10 minutes.
You can be seated, thank you. All right. What do we got, Mr. Rosenwasser?
Your Honor, yesterday I was going through Mr. Knox's stand your ground and deposition testimony and looking at the pictures of the mannequin recreation that Your Honor has. So I wanted to supplement my argument with this. I'm not 100% positive if all these factors came out during the argument. As the court knows, with respect to simulation case law, it's generally frowned upon. I wouldn't even consider this evidence as simulation. I would categorize this evidence as irrelevant, completely irrelevant, for the reasons that I'm going to discuss. And again, even if it was relevant, the relevancy of it would be substantially outweighed by the prejudicial effect. Okay? So in looking at these mannequins, all right, so this is what Mr. Knox has done. He's taken mannequins. So let's just use it. It's going to sound funny when I say mannequin Chad, but that's how I'm going to refer to it. Okay? So if you look at mannequin Chad is not the same height as real Chad. Mannequin Chad isn't the same body shape as Chad. He doesn't have the same face, musculature, dimensions, shoulder. Basically, just to sum it into one big argument, mannequin Chad does not even get close to real Chad. So it can't be relevant to anything in this case. Then you have, I sound so silly when I say it, mannequin Nicole. Okay? Mannequin Nicole is not even remotely close to actual Nicole in any respect. Height, weight, dimensions, the way the body shapes. I mean, let's say that mannequin Chad is 2 inches, 4 inches, 6 inches off. That changes the whole quote-unquote perception that supposedly the jury's supposed to see. If Nicole Oulson isn't anything like Nicole Oulson, then the perception is totally off. It's not relevant at all, and it's so misleading for the jury because it's so inaccurate, it can't have any relevancy to the case. And that's just the very beginning of the analysis. So in the background, we have a movie that's playing that's not the actual movie that was playing at the time of the shooting. So the lighting in the pictures on the mannequin that doesn't represent Chad, that has to affect this perspective that the defense is putting out of the defendant. Then, let's just say for the sake of argument, which isn't the case here, that it was the movie playing. We do not know what scene was playing at the time. So let's say that they were in a car, versus they were in a house, versus they were at the beach. The scene lighting that we don't know would be different. You couple that with mannequin Chad that's not even remotely close to the dimensions of real Chad or even real Nicole. It can't get more misleading than that because we're having factors that aren't even at play in this case. It's not even like, well, maybe it's somewhat similar. There's nothing at all remotely similar to what's going on in this case. Coupled with that, this is what you have, and this is what I read from the deposition. In the deposition, the camera position is from Michael Knox sitting in the movie theater chair. It's not even as if the defendant was there for the recreation. It's Michael Knox sitting in a theater chair taking a photograph that now the jury's supposed to say, well, let's look at this picture taken by Michael Knox as Michael Knox is viewing it from a theater chair with mannequin Chad that doesn't even accurately represent real Chad against the backdrop of a movie that's not the movie playing, and the lighting conditions can't even be recreated because it's impossible. On top of that, the picture that was taken was from a tripod. The tripod was on the ground. So it's Michael Knox sitting, looking through a camera. The camera is on a tripod on the ground in front of Michael Knox, taking a picture of mannequin Chad that doesn't represent real Chad against lighting that doesn't replicate, nor could it ever replicate, the lighting at the time in the theater. It goes on and on and on. We don't know the distance. He has a picture of some random distance between the camera that's on the ground, mounted on the tripod, to this mannequin Chad. I'm not going to go through it 500 times about how it doesn't represent Chad, but it's just some random distance that we're now showing the jury, so the jury can say, wow, this is how the defendant must have viewed this. It's really so irrelevant because it doesn't help the jury at all, because it has nothing to do with what the defendant saw in the theater at the time of the shooting. And it's not has to do with the sheriff's office investigation, as we talked about the other day. There is no way anybody could ever recreate all those factors that occur in a movie theater. It's just not possible. That's why you have to rely on the video that's in evidence and eyewitness testimony, because that's the best evidence for the jury. There are so many different factors that I could keep going on about, but I think that the point really has been made, that there's just no way. I guess one of the other big things would be positioning. This was a dynamic event that happened. People are moving left, right, angles forward, backwards. This is a picture determined by Michael Knox, which is a snapshot in time determined by him in a chair at some camera level. That's his eyes, not even the defendant's eyes, but there's just no relevancy. It does not tend to prove or disprove how the defendant possibly perceived this event under the circumstances that he experienced it through. Because that's exactly what this whole issue is in the case. Did he reasonably believe that he was in imminent danger of death or great bodily harm? And really, only the people in the theater and the defendant himself knows that answer. This recreation or simulation, or however you want to characterize it, is simply not relevant, and any relevancy is absolutely outweighed by its prejudicial effect.
Response? No, wait a minute. According to the case law cited by the state in Brown v. State, first DCA opinion, the standard is the demonstrative has to be an accurate and reasonable reproduction.
And then, so my argument would be, this is not even remotely accurate, and it's extremely unreasonable based on all those factors.
All right, and so as you were arguing that, what came to mind was, the differences and likenesses that are pointed out, say, in Williams Rule hearings. You can enumerate usually a dozen factors on each side. So you went through a litany of differences. Obviously, in Brown, there was a glaring difference of, styrofoam versus a human head. But so with that context, Mr. Escobar, what can you tell me?
Your Honor, first of all, this is for demonstrative purposes. Mr. Knox is not going to get up there and say, well, ladies and gentlemen of the jury, this is exactly what Curtis Reeves saw. It is a demonstrative aid to have the jury understand backlighting. Mr. Rosenwasser wasn't here for probably 95% of the arguments that we had yesterday, so he may not know that. But this was a demonstrative tool to be able to show the jury what backlighting does when someone stands in front of another individual. If the court recalls, their own witnesses talked extensively about the issue of silhouetting. And we can't assume here in this particular case that every juror actually knows the effects of silhouetting. I find it ironic, and I mean this with all due respect to Mr. Rosenwasser, but I find it ironic that this investigation, the crime scene investigation in this case, was an absolute train wreck, totally incompetent by the Pasco County Sheriff's Office, because they didn't preserve the things that they should have preserved. They should have done all these things there at the scene. And because now they're not there, and we're trying to bring back some of that evidence, some of that experience to the jury, they're saying, well, if we do that, if we allow that to happen, then the easiest thing that the government can do and the sheriff's office can do from here on out is they don't take up any evidence. Because if they don't take up any evidence, then certainly, it's not going to hurt their case, because you're never going to be able to go in and now present evidence in a form that is necessary for this particular jury to understand backlighting. These mannequins aren't there for purposes of saying, hey, listen, this is the perception that Mr. Reeves had with reference to these two bodies that were coming at him. This is a demonstrative aid. And just like that styrofoam head didn't mimic what a human head in that particular case did, you got to allow some flexibility. That's the reason. That's the issue of reasonableness. You have to. I'm sure in the Brown case that they didn't measure how long was the nose and how far apart were the eyes of the mannequin. And the mannequin didn't have any hair, and so why not put hair on the mannequin? We can't get beyond the fact that this is a demonstrative aid. And at no time is Dr. Knox going to say, hey, by the way, I did this because I want you to see that this is exactly how Mr. Reeves viewed the backlighting situation.
All right, and just to kind of clarify for the record, I think, as I recall the testimony regarding the silhouettes, you said the witnesses used that terminology extensively. I believe it was your terminology every time. They just said yes, silhouette, yes. Was it what? Couldn't you classify it as a silhouette? Wasn't it a silhouette? Or did you think it was a silhouette? I don't want to be leading, but because I'm sure you weren't leading. But yes, indeed, that's how I remember the testimony. Primarily your terminology, but nonetheless, silhouette has been testified to, which is why I agreed yesterday with the defense on this issue. Now, what about, all right, so Mr. Rosenwasser, you're pointing out all these differences. And obviously, again, in the context of a demonstrative as opposed to substantive evidence, there is a little bit of leeway there, obviously. What about that?
I don't think if you change the name of it, it makes a difference when you're doing a relevancy or 403 analysis. If it goes into evidence, that's one thing, but if they're going to see it as a quote-unquote demonstrative aid, they're still seeing it as if it is in fact evidence. So it's just more a different word, really, than anything else. Now, when the defense says that we're using for backlighting, okay, I don't think the jury needs an expert to talk about backlighting. That was something that would be within the common sense purview of a layperson. People know what backlighting is, so we don't need Mr. Knox to come up and say, wow, here's an example of backlighting. Really, it's a perspective. That's what I submit they're trying to do. Okay? Silhouette. We don't have a jury full of kindergartners that don't know what a silhouette is. Okay? The silhouette is within the common person's experience in their lifetime. We don't need Michael Knox to come in and give expert testimony on it, because people hearing silhouette, backlighting, that's not terminology that requires any further explanation. It's in the common purview that people know based on their life experiences. Experts are used when there's information that goes outside the experience of what we'll say is a common juror. Backlighting doesn't do that. Silhouette doesn't do it. And I was thinking the same thing as the court. Our witnesses didn't get up and say silhouette. Now, you know, that's just kind of, this is what lawyers do on either side. So I'm not saying in the fault. It's a job of semantics, you know, and that's just what lawyers do. But really, we don't need anyone to explain this terminology because it doesn't require any expertise. To say, well, it's going to demonstrate backlighting, it's backlighting on a movie theater screen that doesn't even have the same movie playing at the same time. So we're looking at this white effect on these photographs. What happens if it was darker? What happens if it was a mix? It's completely inaccurate because nobody can ever recreate the scene. So I understand that they're saying that the Sheriff's Office investigation wasn't great. I'm admitting it wasn't great. I mean, any reasonable person would view this case and say it wasn't great. But no one in the world can recreate it. It's just impossible. Like I said, let's say they put the movie on the screen. You can't then say, here's where Chad Oulson was, and here's the angles, and this. You can't recreate it. It's just not possible, no matter who you are. So there's just no way to accomplish this. It doesn't mislead the jury, and this terminology is not outside a juror's common experience that requires this type of evidence anyway. And the best evidence will always be the video and the eyewitnesses that were there.
Your Honor, it was a lot more than it wasn't great. As we know, in the law of self-defense, we have to have the trier of fact stand in the shoes of Mr. Reeves. I'm glad that Mr. Rosenwasser thinks that he is an expert on what jurors know and what jurors don't know with reference to the issue. With reference to silhouetting, but we can't take that chance in a court of law. We never know what 6 members of a jury know and don't know. And I've been doing this for 37 years. I would never take that leap to just say, oh, well, they must. The trier of fact needs to stand in the shoes of Mr. Reeves, which means the trier of fact has to be thinking of themselves as 71 years of age at the time. The trier of fact needs to be seated in the same seat as Mr. Reeves. The trier of fact needs to be in the same darkness as Mr. Reeves experienced. The trier of fact needs to be in the same noise level that Mr. Reeves experienced. The trier of fact needs to be seeing the backlighting that Mr. Reeves was experiencing. The trier of fact needs to be in the same health condition as Mr. Reeves. The trier of fact needs to know the use of force and the danger cues that are taught to all police officers and even more for Mr. Reeves. All of those factors, the jury has to stand in his shoes and make a determination whether his assessment that it was reasonable for him to fear death or serious bodily injury, whether that was reasonable. And so how can not? The problem here is that the crime scene detective did not do a great job by any stretch of the imagination. And the detective, the lead detective himself, admitted on this stand that he didn't have the tools himself to investigate a self-defense case. And so now Mr. Rosenwasser is saying, well, we didn't do it. We didn't capture it. We didn't do all these things that really should have been done in order to assess Mr. Reeves' perspective of what was going on. And so, but we don't want you to present it as a demonstrative evidence so that we can aid the jury somehow in making that determination. Mr. Knox is not going to be saying that what's on the view of the mannequins is exactly what Mr. Reeves experienced. The jury is going to determine all of this based upon all of the evidence that we're giving them. This is a demonstrative evidence just strictly on the issue of backlighting and an individual in similar size as Mr. Oulson standing in front of that seat 9.
All right. Thank you. I would have preferred to focus primarily on the argument. The issue that I've asked about is the accuracy. Is it accurate? And within the realm contemplated by the case law, do we have any more guidance on that? I can't get into Westlaw.
Judge, I think I read the Brown case. I thought that it was a very good. It's a flexible, yes, accurate, reasonably accurate.
Accurate and reasonable reproduction.
Exactly.
And there's 15 cases that cite this head note. I would love to see some of them if I could log into Westlaw, but I can't. So does anybody have any of those that more propound a little bit better description of what
We can
accurate and reasonable reproduction? So obviously Mr. Rosenwasser has pointed out some significant differences. I'm not quite as concerned about the backlighting and the exact moment because the pictures that I saw had a variation. There was a pretty good mix.
And we did that on purpose.
Light and dark. So, and obviously there's not any sound connected with this, right? And they're not moving, correct? So what are we talking about, the differences with the the mannequins, how much different are they from the actual folks? And the perspective.
Your Honor, they're a human body mannequin, just like the head in the Brown case was a styrofoam head. You're not required to exact every description or every feature of a styrofoam head, just like you're not required to do that with in a human body mannequin. That's why I'm saying that I think that these distinctions, are not the type of distinctions that we can attribute to a 403 argument. They're just not the type of distinctions that we can put a level of prejudice on. And so that's been my argument all along. Again, if I was going to have, Dr. Knox come in here and say, this is what Mr. Reeves saw, I'd be with you. I'd be with Mr. Rosenwasser. I'd be saying, hey, listen, I can't do that. We're not going to do that with our other experts. And so this is purely demonstrative for one purpose and only one purpose alone, and that is showing what happens when you have an object in front of, for example, Mr. Reeves, and backlighting, and what that does to that process. And I'm not going to take the opinion that these jurors all have experienced that and know exactly what backlighting is when someone gets in front of them with a screen behind them emanating light.
If this is not to represent what Mr. Reeves saw, it's not relevant. I mean, really, that's it in a nutshell.
All right, well, to put my decision into context, obviously the state is asking me to exclude some testimony and evidence that the defense feels is very pertinent to their case. So clearly I need to get this right. And I'd like to have all the information.
Judge, if you give us 20 minutes, we can do this. I frankly thought this issue was done yesterday. Nobody called me yesterday to tell me, hey, listen, get prepared because I'm bringing this issue back up again. If not, we would have done it last night.
I did say it yesterday. We need to address the issue with Mr. Knox
Yes,
again
he
before he
did.
testifies.
He did. As I indicated, I'm sure we've all done plenty of Williams rule cases where you can have, the same sort of thing. How similar is it? And you can list 15 different similarities and then, maybe a few dissimilarities. And the case law is clear that it doesn't have to be exact, and typically it isn't. So you get that discretion in there. And Brown simply says, did the exhibits constitute accurate and reasonable reproduction of the objects
Right.
in
If I could, I presented Brown to you, and you have to look at what the demonstration was for. You can't have a live human and place a knife in the skull to show the position so the jury can know the angles. That's what Brown was. So the styrofoam head served the purpose in order for the knife to be placed so visually they can see the angle which was relevant to how something happened. So did it fairly accurately represent that? Yes. There's a human head that is proximate. We all have basically a nose, cheekbones there. It was there, and it was at an angle. That's what they said. It had to be fair and accurate. Here, we have none of that. It's not fair and accurate at all. And so that's how we distinguish Brown, is for what the purpose is. That was for the angle. This is what did the defendant see. And if you can't reproduce that, then it's not relevant. They were able to reproduce the angle of the knife in the skull accurately so the jury could have a visual representation. You can't do that here because of everything that Mr. Rosenwasser listed. And so it doesn't meet that standard.
Well, the argument in Brown was that, the defense argument was that there's no way to tell how deep the knife went in. There was no, that was an unknown.
But that wasn't the issue.
Well, it kind of was, whether he intended to kill her or not. And so they, wanted to know, it does make a big difference if it goes in deep or not. And so that's, like I said, just like with Williams rule, you can point out as many as you want. There's this and there's this on both sides. And I'm just not convinced to the point that all of these disparities are enough. I'm just not. So I would like to, if there is any more guidance, particularly if there's something from the Supremes, that would be beautiful. About like just some analogies to what is reasonable reproduction.
Judge, if I can just have a suggestion, if maybe everybody can go to lunch early, and during lunch we will do it.
10:45 at lunch.
What, maybe just do another witness instead? And then
We don't have another witness instead.
Isn't Bedard here? And then just as the...
Bedard's going to be huge, and now then we're going to have a break in the middle of Bedard. We could get, I think, Knox. Knox is not going to be that long. My suggestion would be we take a break, we do the research, and come back and start again.
All right, I'm gonna 10 minutes. I can go to my office and look this up on Westlaw in my office. I'll look at what we've got, and I'll give you my decision when I come back. That's what it boils down to. And I already indicated yesterday that I was going to deny the state's motion in limine regarding this, or I don't think that wasn't part of your Daubert, was it?
It was.
Okay, then
Because it has all to do with cameras and backlighting and whether it's
Okay,
accurate.
all right, that brings up the other issue. What about the camera? Where was the camera? How much difference is that?
The camera was positioned exactly where Mr. Reeves's eyes would have been, in his seat. There were measurements that were taken. I was there when that happened, and I can certainly speak to Mr. Knox and verify all that.
Mr. Rosenwalter, you disagree with that?
I do. I have a copy of his deposition. And let me find the exact page and I'll show it to the court.
Because there comes a point when a lot of small inaccuracies can overcome a reasonable reproduction.
And I have it right here. Okay, this is page 101 of his deposition. Did you, and Mr. Martin, question, did you measure the height of the camera above the floor at the time you were taking the pictures? Answer, I don't recall if I measured the height of the camera. I set it at my eye level as I sat in the seat. So I sat in the seat pretty much straight up and set it to my eye level. But it was a tripod right in front of my eye. Did you take measurements of what your eye level was? No, I did not. And then then he talks about how the tripod was put on the floor in front of the seat where he was sitting, where he took the picture of his own eye level.
And how tall is Mr. Knox?
I don't know, Judge. I have to ask him.
And
Yeah, I can tell you he's not
also
as
you have
tall
to take
as
into
my client.
consideration where he was sitting. Was he leaning to the left, like Joanna Turner said? Was he leaning back in his seat? There's so many different variables about the height of his eyes. I mean, it's just impossible to recreate this. I can't think, like when you ask the question, which is, what else is accurate or inaccurate? There's nothing about this is accurate other than the fact these pictures are taken in a cop theater in a seat. That's the only thing that's accurate. Every other variable is inaccurate.
Reasonable reproduction.
there is no reasonableness in it because there's nothing remotely accurate other than the fact it was taken, the pictures are taken in Theater 10, and they weren't even taken in the seat because the tripod's on the ground, so you can't even use that. The only thing that is reliable or reasonable or accurate is the pictures were taken in Theater 10.
The mannequins appear to be of human beings.
Okay? But human beings have 5,000 different variables. Probably my mannequin and we'll use Mr. Martin's mannequin look very different. So just saying a generic mannequin that looks like a human body doesn't mean anything because we're very different body styles.
Are they similar?
No, it's just a mannequin in a human form. And it really does matter. The broadness of the chest, the broadness of the shoulders, the head, the neck, all of that makes a person unique. This is just some generic mannequin, so it's not reasonable to have a generic mannequin, and it's not even reasonably accurate because all it is a mannequin.
Judge, again, whether you're 5'7", whether you're 6'1", it's the backlighting. That's the demonstrative issue here. It's the backlighting. He continues to try to gravitate, to trying to tie this demonstrative aid as saying, this is exactly what Mr. Reeves saw. That's not coming in. We're trying to show the effect of the backlighting when someone, in this case it was a human body, but you could have a backlighting and have something even smaller than this just go in front of you, and it's going to have some of that effect. So we're not trying to tell this jury that this is exactly what Mr. Reeves saw. It's to show the effects of backlighting when a human body comes in between the backlight and the individual that is viewing that. So if you're 5'7", it doesn't mean that the backlighting doesn't occur. If you're 6'2", it doesn't mean that the backlighting does occur. It's the body coming in front. He's trying to gravitate his argument to suggest this is what Mr. Reeves actually saw. I would agree with him. I would agree with him. Under those circumstances, you shouldn't allow it in. That's not what we're doing.
All right. Let me take 10 minutes.
Recess for 10 minutes. Johnson, I just shouted for the jurors in here for a moment and give them a little instruction.
Yes, please do.
knowledge on it.
Okay, thanks.
Finishing up. It's a slow printer.
Okay. All right, I did find a few cases of interest. Ultimately, I got to Chamberlain v. State, which is 881 Southern 2nd, 1087, Supreme Court of Florida case, which cites their previous ruling in another case. It was a recent ruling. Said in Chamberlain, the standard for allowing demonstrative evidence at trial was recently reiterated by this court in Harris v. State, 843 Southern 2nd, 856 at 863. That's a Florida decision, 2003, wherein we stated, demonstrative evidence is admissible only when it is relevant to the issues in the case. It is essential in every case where demonstrative evidence is offered that the object or thing offered for the jury to see be first shown to be the object in issue, and that it is in substantially the same condition as at the pertinent time, or that it is such a reasonably exact reproduction or replica of the object involved that when viewed by the jury, it causes them to see substantially the same object as the original. The person offering such evidence should be required to give a good reason for its acceptance into evidence, and this is particularly true if the object be not the original but only a replica or a facsimile. The determination as to whether to allow the use of a demonstrative exhibit is a matter within the trial court's discretion. So, Mr. Escobar, I believe
I've got a Supreme Court case from 2018 dealing with mannequins in and of itself.
all right, what is it?
I've got, it's called Lowe versus State, located at 259 Southern 3rd, 23. It's a 42-page opinion. However, I have outlined the areas that they deal with mannequins. I believe they start at head node number 5 through 11. I've only got half the opinions being printed right now.
So give me the site again, 259 3rd.
259 Southern 3rd, 23. So 2018 Supreme Court of Florida opinion. It deals specifically with mannequins. I'm handing that to the court. And my other pages should be here momentarily.
Teresa's right outside. She says, do you want her?
Can you see? Tell me what relevance.
Judge, I think that when you look at that particular case, they were actually using the mannequin for...
Wait a minute. Just tell me what the relevance is,
Oh,
please.
the relevance for our mannequins is the
Yes.
backlighting.
The backlighting is relevant to what issue in the case?
To what Mr. Reeves could have experienced, the backlighting, what Mr. Reeves would have experienced in the theater.
Okay.
Meaning not that exact mannequin, not that,
Okay,
but the
okay,
backlighting.
that's all I asked.
Okay.
One more.
Yeah.
So how is that issue relevant to Mr. Reeves' defense?
It's relevant, Your Honor, because it actually blocks the light that was coming from the theater screen, which actually causes shadows in the individual that is causing the backlighting. That's the whole purpose of the backlighting issue, is that phenomenon actually causes shadows when you're looking at.
Okay. What issue are you trying to bring forth?
I'm trying to bring forth the issue that this was Mr. Reeves's perspective, the actual backlighting. He actually experienced that during the actual shooting. And so because we have to stand in his shoes in order to be able to make that assessment, we need to have that factor, just like all the other factors that he was experiencing that day. Backlighting was a factor that clearly, because Chad Oulson stood up.
Okay, okay. All right, and in this Lowe case, has the state had the opportunity to review anything to do with the Lowe case?
I have, and if it's okay, because I'm reading it, to argue from a seated position.
You may.
The mannequin was used by the medical examiner in order to demonstrate to the jury the trajectories of the bullets. And in the Lowe case, and I'm looking at head note, not head note, I guess it is head note 5 in the body of the opinion, it indicated, quote, the medical examiner then used the mannequin, which was slightly taller and thinner than Burnell and had valves inserted into it, to demonstrate the relative trajectories of 3 bullets that entered the victim's body. The medical examiner testified, because he could not state what position Burnell was actually in when she was shot, he could only give anatomical, not spatial trajectories, and that the trajectories had a small degree of error. And the court, in overruling the objection, actually asked, what would be the difference if it was off a few degrees one way or another? Because the analysis was, as the court was indicating, is it reasonably accurate? Is it a reasonably accurate reproduction? And that was why, in the Lowe case, that mannequin was able to be used. In this case, Mr. Escobar just indicated exactly what our argument was. He wants to argue that this is the defendant's perspective. And there is no way that this camera, held by a tripod on the floor in front of Mr. Knox, sitting in his seat, could possibly replicate the defendant's perspective. The only person that knows the defendant's perspective is the defendant himself. So that's exactly what we thought he was trying to admit it for, to say this was the defendant's perspective of the backlighting. It can't be any more misleading than that. Only the defendant can have, it's his choice whether he wants to testify or not. I mean, Michael Knox can't say, based on a picture I took using my eyes, that this is what the defendant's perspective was.
No, he can't say that. But
That's what their argument was just now. This is being shown because you asked him what's the relevance, and his argument was the defendant's perspective of what the defendant saw regarding backlighting.
Your Honor, the issue is backlighting itself, not what is shown on those mannequin photos, because Mr. Knox can't say this is exactly what Mr. Reeves says, but the phenomena of backlighting is what's important to us. And something that's very interesting in the Lowe case, they used those mannequins for a far more intricate forensic analysis than what we're using it for. And by the way, our mannequins are 5'9", so they are going to err on the side of conservative, because if they were 6'6", okay, they'd be arguing, wait a minute, is blocking, more light. our doctor actually did it far more conservative at 5'9". That's the relative size of the mannequin. And so I would say that what we're using it for is strictly for the backlighting effect.
All right, a couple of things of note. In the low case, it points out the fact that the mannequins were not specifically identifying or made to look like the individuals involved so as to perhaps evoke an emotional response from the jury. So I didn't see any issue with that in these mannequins. And so obviously, it would not, according to the Supreme Court, it would not be a good idea to use mannequins that are, more identically patterned after the individuals involved. Secondly, I lost my train of thought. The overall impact, the size, as you indicated, Mr. Escobar, I believe in Chamberlain, which I cited earlier, the state used a much larger version of the weapon.
Asp, it was an asp.
Yes, and the court found that that was okay. In this case, as you indicated, this is a smaller mannequin. I understand the distinction there. Obviously, if you used a much larger one, that would be subject to further scrutiny, but in this case, as you indicated, it's more conservative. This is within my discretion, and in considering all of the aspects, the case law, the reviewing the photos that were provided to me, I am going to overrule the state's objection to this demonstrative, and we'll get to it.
Your Honor, could we have just a limiting instructions? I don't know the best way to craft it. Maybe something to the effect of this testimony is being offered only to demonstrate the concept of backlighting.
Judge, I'm going to go outside with the court's permission in a little while and instruct Mr. Knox, to stay within the parameters of his opinion, and that's only as to the fact that backlighting is created when an object comes in front of that backlight to create the shadow. That's going to be his testimony. He's not going to say anything beyond that. He was never intended to do anything else.
All right, so if there was a limiting instruction, such as Mr. Rosenwasser indicated, I don't see any harm in that either as to that portion of his testimony. Say it again.
This testimony is being offered only to demonstrate the concept of backlighting.
All right, I think that's fair as to that portion of his testimony. So can we
I would agree with that.
pause?
And Judge, I would agree with that. I don't have any problem with that. That was our intent from the very beginning.
All right, so we can pause briefly before he begins that portion, which will include the PowerPoint.
I will make sure that that happens.
All right,
Can I go and
let's-
talk to Mr. Knox now?
Yes,
And
please.
try to get that,
Before you go. Just one thing, the fact that they used a mannequin, I mean, it is kind of interesting to demonstrate the backlighting. So I intended to ask him, and I don't know how you want to handle it. I don't want to open the door into, Pandora's box, so to speak, that, in this case, he chose to use mannequins. He could have used any object at all, but he chose a mannequin.
I mean, Judge, he chose a mannequin because of the fact that if he would have chosen a TV like this and it would have been, very, very dark, then we would have gotten an objection. The reason is a mannequin is a human body. human bodies have arms, they have areas of the neck that are a little bit.
Okay.
That's why
So
we use it.
Mr. Knox can certainly answer that without opening Pandora's box.
Okay.
Just that simply.
I will talk to him and make sure that he is.
Okay.
Kind of give you an idea of what Mr. Knox said about why you use a mannequin and not a board or something, if that's what the court wants.
I don't care.
Okay.
If Mr. Rosenwalser wants to bring that out on cross, I'm sure we'll hear. It's not that I don't care, it's just, at this moment, I don't care. It's okay. And that's up to Mr. Rosenwalser when he does his cross, but as I indicated, that's not going to open the door for every other thing to come in.
Yes, Your Honor.
It'll be answered accordingly, and we'll go from there. All right, let's bring the jury back in, please.
Jurors in the courtroom, Your Honor.
Okay.
Jurors may be seated. Jurors are present and accounted for, Your Honor.
Thank you, ladies and gentlemen. Were you all able to abide by my instructions during that brief break? Hopefully. All right, thank you. We're going to get started again. Mr. Escobar?
The defense would call Dr. Michael Knox.
Walk around this way. Mr. Escobar. I'll walk all the way over here or we can see the clerk. Listen to that right hand, raise your right hand, face the clerk right.
Do you solemnly swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Come on, now, let's just sit down and see the chair.
Good morning, Dr. Knox.
Good morning.
Doctor, would you please pronounce your name and spell it for the court reporter, please?
My name is Michael Knox, and first name is common spelling, last name is Knox.
Dr. Knox, would you please, I'd like to review a little bit about your educational background. Let's start with your educational background, if you can. Your college experience, obviously.
Sure. I have a bachelor's degree in mechanical engineering from the University of North Florida, a master's degree in forensic science from the University of Florida, and a PhD in criminal justice from Nova Southeastern University.
Let's talk a little bit about each one of those degrees that you received. First of all, your associate's degree. Let's talk about what the areas of concentration were for those.
For associate's degrees, I actually have two. One is an associate in arts, just a general education, and then I also have a associate of science in criminal justice technology.
Okay. And when you went to get your bachelor's, what was your, I believe you indicated your major there was engineering?
Right, mechanical engineering, that's correct.
And explain to the ladies and gentlemen of the jury what that all entails.
Well, mechanical engineering is the branch of engineering that deals with the design and operation of machinery. So in a engineering degree, you're doing heavy math, doing all the calculations to calculate things like stresses and strains in a machine, and heat transfer, fluid flow, and all sorts of things like that. So it's very math intensive, a lot of physics and mechanics involved, and you're dealing primarily with things that would involve moving machinery. So that's sort of the area of engineering.
You also received, as my understanding, a master's degree. Is that correct?
That's correct.
And that was in forensic sciences. Explain to the ladies and gentlemen of the jury what forensic sciences are.
So the forensic science program at University of Florida, they have different tracks, but the one that I did is the general forensic science track. So it's sort of a variety of different courses related to forensic science. Some of them are just general forensic science concepts, statistics, and various things like that. And then I took courses in things like bloodstain patterns, forensic entomology, which deals with the collection of bugs at a crime scene, and the utility that they have. Forensic biology and forensic chemistry, all different things like that. So sort of a general overview of the forensic sciences with a lot of detail on the technical side and the application of it.
You then also received your PhD in criminal justice. I know there was a focus of that PhD as well. Explain to the ladies and gentlemen of the jury what that PhD entailed.
So the PhD in criminal justice is primarily a research degree, a scientific research degree. So what you're doing there is applying a scientific method to criminal justice related problems and looking at various types of data. So you would be looking at things like it might be a particular criminal justice program to treat an offender. Does it work? And then you'd have to do the statistics to be able to figure out, is it actually effective or does it not change the outcome? You could be dealing with all different sorts of problems, whether or not a particular laboratory procedure was effective, just by applying, again, statistics and a methodology to that. And then I had a concentration within that of behavioral science, and I actually did my dissertation on the crime scene behaviors of school rampage shooters within that.
Let's talk a little bit about your law enforcement career. Tell the ladies and gentlemen of the jury when you first started your law enforcement career.
So I started as a police officer with the Jacksonville Sheriff's Office here in Florida in December of 1994. And I was a police officer in uniform for about 5.5 years. And then I went to the crime scene unit. So at the Jacksonville Sheriff's Office, all of the crime scene investigators are sworn police officers. So after you've done a certain amount of time as a police officer in uniform and patrol, then you can transfer to the crime scene investigations unit, which is part of the detective division. And so I spent 7 years there as a crime scene investigator, training coordinator, and then I left that unit in 2007 and spent 3 years as a traffic homicide investigator before I left the agency, took an early retirement in 2010.
Let's talk about those years as a crime scene investigator and tell the jury, if we can, what is a crime scene investigator?
So as a crime scene investigator, your primary role is to document and collect, preserve, and in some cases analyze physical evidence from crime scenes. So your primary focus is on the physical evidence, and your job is really to secure everything and to first document and then to assess it and apply appropriate procedures for being able to collect, process evidence, for example, processing for fingerprints or collecting samples for DNA or doing things like that, as well as doing other things, maybe documenting bullet trajectories or bloodstain patterns or things like that.
So 3 of your years in that department was as a major case crime scene investigator?
Actually, I was a major case crime scene investigator for almost the whole time that I was in that unit.
So for the entire 7 years?
Yes. So what happens is you come into the unit, and once you've gone through training and you've gotten sufficient amount of experience that they feel comfortable letting you be the lead crime scene investigator in major crimes, which would be homicide cases, serious sexual battery cases, ones with injury or things like that, or police-involved shootings, or there's certain enumerated offenses that would be classified as major case designated, and you have to be designated as a major case investigator to be able to be the lead crime scene investigator on those.
And that's what you were for Jacksonville?
Yes.
And you also, I believe you indicated you had a title of training coordinator. Tell the ladies and gentlemen of the jury what that training coordinator position also entailed.
So from 2003 until I left that unit in 2007, I was in charge of training everybody else in the unit. So that meant I was providing a lot of the training to other people, new people that would come in. I would give them training, as well as do ongoing training with those people who were already in the unit. And then also I made sure that if there was any outside training available that people were able to go to, that, kind of organize that and send the appropriate people and those sorts of things.
Now, it's my understanding that you also had some coursework, some work within your department, for example, in the Institute of Police and Technology. Let's go through some of those if we can. Tell me what you did for that particular institute.
Well, I did went to a lot of training courses there over the years. So it's the Institute of Police Technology and Management, which is a training center for the University of North Florida. And IPTM trains police officers from all over the country, but even internationally, in a lot of different fields. They have a forensic science, forensic investigation section. So starting from the late 90s on forward, I took a lot of courses there in traffic accident reconstruction and things like that. And then probably starting early 2000s, crime scene processing and homicide investigations, crime scene reconstruction, bloodstain pattern analysis, and a lot of other courses related to crime scene work, use of alternate light sources and things like that. And so I took, I don't know how many, but probably at least 15, 20 different courses from IPTM from the late 90s up until about the mid-2000s.
Some of those courses also included lighting optics, is that correct?
I've taken the course on lighting optics and visibility for forensic investigator. That was actually not IPTM, it's another training company that put that on. taught by a lighting engineer, person who had a background actually designing lighting and systems and stuff. And that course dealt a lot with the documentation side, how to photograph lighting conditions and how to be able to take measurements and things like that.
There was another course you took, lighting and visibility for the forensic investigator?
Yes, that's the course I was talking about.
Okay. You had a Glock Advanced Armorers course. What's that about?
So I've actually gone several times up to the Glock factory up in Smyrna, Georgia, and they put on what they call armorer training. So basically an armorer is a person who is certified by the company to work on their pistols. So if you go through the Glock armorer training, then you're certified to work on all models of Glock pistols, which includes diagnosing if there's something wrong with it and changing out parts if the parts need to be changed, things like that.
You also took a course called Street Survival Seminar, is that correct?
I actually took that one twice, way back in the 90s, actually right before I went to work for the Jacksonville Sheriff's Office, and I took it again in, I don't remember exactly what year, but early 2000s.
What is that course about?
So there was a company called Caliber Press that they publish a lot of books and things that's training literature for police officers. Most of what they deal with is, tactics for police officers to survive armed encounters and things like that. And so I've been to that training twice. First time because I was becoming a police officer, and second time because more from the investigative side of staying current on what was being taught to police officers for them to do, so that if I went to police-involved shootings, that I could, stay current to that information and know what type of evidence to be looking for.
You took a course on digital photography, is that correct?
Yes, I've actually had several different courses. IPTM has a digital photography course that's digital photography for law enforcement. I've taken that one twice. And then I just a couple of years ago actually took a couple other digital photography classes. One on autopsy and injury photography, and I'm trying to remember the other one.
You also took your courses on homicide investigations in general?
Yes.
And how many of those did you take?
I took one 40-hour class at IPTM that's on homicide investigations, and then I took another one on it's titled Injury and Death Investigation, which was at the Police Academy in Jacksonville in the 90s when I took that class.
Certificates that you currently hold?
I've had multiple different certificates. I actually was certified by the International Association for Identification, which is a forensic institute that has a crime scene certification program. I held their crime scene reconstruction certification for 10 years, but they decided several years ago not to continue that particular certification. So for those of us like myself whose certification expired toward the end of last year, they didn't offer a renewal. But I did hold that certification. I had to go through the process of getting that, which is you have to meet certain requirements, and then you have to take a test and then a practical in order to be able to get it. And then I did another test and practical 5 years later to renew it.
And you that lapsed when? You said last year?
Just the end of last year.
So in 2014, you had that certification, is that correct?
I did, yes.
At some point in time, you left law enforcement, is that correct? Tell the
That's
ladies
right.
and gentlemen of the jury why that happened.
I started doing consulting work as a part-time, and I began to get too busy when basically was working 2 jobs. And so I was able to take an early retirement, invest my time, and leave and still get a pension, eventually. So I made the decision to leave the Jacksonville Sheriff's Office and then go full-time into the crime scene reconstruction consulting business.
And what is your specialization in your consulting work?
So crime scene reconstruction would really be what I would call my specialty, with other things that go underneath that, with a particular focus on shooting incident reconstruction. So the majority of the work that I do is reconstructing shootings or firearms involved incidents. And of course, that includes doing things like bloodstain pattern analysis and bullet trajectory work and things like that.
Members of associations?
Primarily, I'm a member of the Association for Crime Scene Reconstruction, or what's known as ACER, which I've been a member of since, 2008 or 9, something like that.
Are you still a member of the American Society of Mechanical Engineers?
I did not renew that one, I think, in the last year or two. Primarily what I've decided is, in terms of focusing on professional organizations, is that's related directly to my field. So ACER would be the one primary organization.
Have you been published in the past?
I have.
And let's talk about some of those, and we'll probably go from the, I'll give you just a few. Forensic engineering applications in a crime scene reconstruction. Did you author that paper?
I did.
Okay, and was that paper also peer-reviewed?
It was.
And would you explain to the ladies and gentlemen of the jury what that means, being peer-reviewed?
So a peer-reviewed paper, technical paper, or scientific paper is one where you submit it, and it has to go through various steps of approval, and one of those steps is that it gets sent usually to 2 reviewers who are experts in that field or that have the appropriate background, who will then review that paper and make a determination as to whether or not it meets the scientific rigor for whatever publication or whatever conference it's being published at.
Another one that you did, the forensic engineering analysis of ejected cartridge case patterns for reconstruction of firearms-related incidents. You wrote that paper as well?
Yes.
And was that paper also reviewed?
Yes.
Forensic analysis of an accidental firearm discharge due to a blow to an exposed hammer spur. You did that one as well?
Yes.
Forensic engineering analysis methods employed for the purposes of determining the location of long-range shooter based on terminal bullet trajectory. Did that one as well?
Yes.
And I won't go through all of them. Okay. Books. Tell us about books.
Well, primarily, I was involved in, and an associate of mine had written a crime scene processing manual, basically on A to Z's of processing a crime scene. And then for the second edition, rather than updating the book, we took the entire book and turned it into an online format. It was delivered on a DVD so that somebody could put it in the computer, and that allowed us to actually include not just the text and the photographs that were in the book, but add videos and multimedia stuff to be able to sort of explain and demonstrate all different kinds of crime scene processes. So if a crime scene investigator needs to know how to document a footwear impression, we had that in there, explaining how to do it, and had videos actually demonstrating the process. If they needed to be able to take measurements of something, then we had it in there to be able to explain that. So we sold that for probably about a 10-year period. I don't think that there's been any sales on it in the last couple of years, but for a while it was published not just by us, but also a third-party company that sold forensic equipment and supplies carried it in their catalog.
Teaching, have you held some teaching positions?
Yes.
And would you tell the ladies and gentlemen of the jury about your teaching positions in the area of crime scene investigations, and specifically in forensics?
Well, the main teaching that I do is for the Institute of Police Technology and Management, where I am an adjunct instructor, and I am the lead instructor for shooting incident reconstruction classes. So I teach that class every year in Jacksonville, and then we teach it periodically on the road if an agency requests it. So I think the last time I taught it out of town was in Sacramento, California for the California Highway Patrol. And then I've also have taught as an adjunct instructor. I taught a forensic. It was a forensic science class for Kaiser University, and then I also taught a class on crime scene and forensic investigations for Flagler College.
Have you also taught and lectured abroad?
I have.
And would you explain that to the ladies and gentlemen of the jury?
So I taught a shooting reconstruction class in the Republic of Georgia, not the state of Georgia, the Republic of Georgia, over next to Russia, and that was under contract with the U.S. State Department for the Georgian police. And then I've also taught a couple of courses, general crime scene courses for a company called Searchy Fingerprint Laboratories, which is a company that manufactures and sells crime scene equipment and supplies. And I taught that course in Dubai, in the United Arab Emirates, for the police and their forensic science laboratory there. And then I've taught that class twice to different groups of prosecutors and medical examiners in Peru, in 2 different cities in Peru.
And have you been qualified as an expert in the field, in your particular field?
Yes.
And can you tell me if that was in crime scene reconstruction?
Crime scene reconstruction, shooting incident reconstruction, bloodstain pattern analysis, and several other related sort of subfields of the crime scene reconstruction.
Let's start out about talking about how is it that we engage and investigate a crime scene from the very beginning. What do you do as a crime scene investigator? What are you required to do as a crime scene investigator when you first take on that responsibility?
The first part of whenever you get there is just what I call data collection, or collecting information, essentially. That's going to start with information where you're going to get at least some idea of what's the nature of what happened, and then you'll begin to assess things like what's the extent of the scene, where did this all take place, what kind of physical evidence is present, and you begin documenting that. So initially what you're really trying to do is just document and collect everything and gather all the data that you can gather without really making any decisions on anything. You're not trying to figure out really at that point exactly what happened or who was involved. You're trying to figure out what evidence is there and what information do I need to collect, what do I need to document, and what's going to give me the information that we're going to need to be able to start piecing everything together. And then as you document through photography, through measurements, through actual collection of different types of evidence and various different types of processing, depending on what you're looking for, then you would move into where you start to piece things together and figure out what it means. So now I have information and I know this, and so what does that mean? What does it tell me about what took place? And then you begin just steadily and methodically working through all that to be able to eventually get as complete a picture as you can of what actually took place and what is it that you need to find out.
So are you telling me then, well, let me ask you this question. Does a crime scene investigator just go into a crime scene and allow the crime scene technicians to do whatever they want to do or whatever they feel is appropriate to do? Or is the crime scene investigator heavily involved in the entire process of the investigation?
You should be heavily involved. So but basically what you're going to have is in a situation like you have here in Pasco County, where you have non-sworn forensic investigators and you have a detective that's assigned to the crime scene whose job it is to oversee what's going on, then the biggest piece of what's happening here is communication back and forth between the detectives that are doing interviews and that are finding out different pieces of information and making sure that that's communicated with the forensic investigators who are actually doing the evidence collection and documentation. Because you have to have some idea of what's going on to really know what to collect, to know what evidence to process, and to know what's important. If you don't really know anything, then you wouldn't know what's out of the ordinary, what's part of the scene that's ordinary and isn't really part of what took place, and those kinds of things.
How critical is that aspect of doing a proper investigation? Knowing what others are gathering in the form of information.
That it is, you really couldn't overstate the necessity for that. You have to make sure that you're communicating, that you know all the information that's coming in, because you can find out things in a crime scene where somebody, there may be something that's related, and you have no idea that it's related because that hasn't been communicated. So you have to find out not just what's there in terms of physical evidence, but every piece of information that you may know about a crime. Even when you have a crime where nobody witnessed anything and you have nobody alive to tell you what took place, as a crime scene investigator, I still need to know what information is known, things like when were people last seen alive, or what's the parameters of what took place, where might things have happened, where did this person go, what do we know about it. So there's a absolute necessity for communication going between the detectives that are doing all the interviewing work and the crime scene investigators and technicians that are documenting and collecting all the evidence.
Obviously, there could be two types of cases. One is who did it, right? And the other one is what?
That's right. Basically, you can understand physical evidence in two terms. What we call associative evidence, which is evidence that tends to associate things with people or things with other things, or maybe things with a location. And associative evidence typically goes toward the question of answering who. Who was involved, who did it, so sort of the classic of that would be like I was giving the example of a homicide. You get there and there's a body. And what you know is that this person's been killed, and that's all you know. Somebody found them. When you go to a scene like that, your primary focus is on associative evidence. What am I looking for that's going to help me identify who was here to try to figure out who actually committed this crime? The other type of evidence that you deal with is what's called reconstructive evidence. So that's evidence where you're using it to figure out what happened, not necessarily who. Now, you can be doing both in some cases where you're looking at associations and reconstruction of what took place. But certain cases, and this would be one of them, where the who is not really a question. So the real focus is what happened, and what you're doing with the physical evidence there is going to be centered on determining what took place.
So the dynamics of what happened is critical in the gathering of relevant evidence. Is that a fair statement?
Yes, I think that's a fair statement.
And so how do you go about then gathering the information that you're going to use to try to preserve evidence of what happened? How do you go about that?
It begins with having, you have to know and understand what's the extent of your scene and where your evidence is going to be found. Because then you know where to search, you know where to what areas to document, what stuff to measure, what things need to be collected, and what's the area that you focus on. But you can also have things that you're looking at that aren't necessarily like a piece of physical evidence that you're trying to find, but documenting things like if you have an incident where you have a number of different witnesses, then you could be also needing to identify where were these people and what were they looking at when they saw or heard or perceived various things that they've discussed or have told the detectives, so that you can document from their perspective. And there's a couple purposes on things like that. You're actually documenting where they were so that it's known, but looking at things like how far away is the person? What's the line of sight for that person? And you can also get into what's the lighting, what would they see under the lighting conditions, things like that. Because the idea is, one, to be able to test what anybody says for accuracy. Is it correct or not? And two is just to be able to have a record of that later as to, from this perspective, you could see this. So that's why you're communicating back and forth, and then you're looking at everything that you need to document, collect, and in a particular scene.
Obviously, you know this is a self-defense case.
Right.
And so how important, we're just going to get back to the witnesses in just a second. How important is it for the crime scene investigator and the lead detective to determine whether there has been contamination that may have taken place there at the crime scene? How important is that?
That's something you'd want to make sure you knew as much as you could about what happened in terms of the scene. And by contamination, you can have a lot of different things that can take place. One being is whether or not physical evidence is moved or touched or anything has happened to it between the time that the incident took place and the time that you're arriving there to document. If anything got moved, then you need to know that it got moved, and you need to know where it came from and try to get the best possible evidence as to where it originally was. Where did it come to rest when everything ended? As well as making sure that all the evidence is handled such that you don't destroy anything that might potentially be important. Because it could, even though you have a shooting scene where you're really focused on reconstructing what happened, there can still be important associations and associative evidence that you could be looking at, trace evidence of things, maybe DNA or fingerprints or things like that, that could tell you what events took place. One I get on a not infrequent basis is where somebody's, say, struggling over a gun, so we need to know that there's some type of struggle that took place with the gun, because we could be looking at DNA or fingerprints from the people who were struggling over the gun to try to verify whether or not they actually were struggling over the gun. So that's really the importance there.
So we talked about contamination, obviously, with evidence. Is there such a thing called contamination of witnesses?
Yes.
Explain to the ladies and gentlemen of the jury what contamination of witnesses entails.
Well, the biggest thing with witness contamination deals with not wanting witnesses to talk with one another about what happened, so that each person that you interview and get information from is giving you their recollection of what happened. And they're not getting pieces put in it from conversations that they had with other people. Because what you want to know is what does that person know? What did they actually see or hear? You know, where were they? And you want to understand how certain they are about it. Whereas if they've talked with other people, then they may have had additional information added to what they recall, to the point that by the time you interview them, that those things can no longer be separated.
Would you agree or disagree that individuals that sometimes listen to others actually start believing that they themselves may have seen or heard what they've been contaminated with?
It happens frequently, yes.
And tell the ladies and gentlemen of the jury how dangerous that is in our criminal justice system.
Well, the biggest problem with that is that you're not getting that person's actual knowledge and recollection of what happened. And see, when you're doing crime scene reconstruction, I can't take what a person tells me and then I don't have some magic way of knowing whether it's true or not. What I have to do is take what they say and compare it to the physical evidence to see whether or not what they say is possible or not possible, whether it's consistent with or inconsistent with physical evidence. And so you have to be able to assess those factors within what a person tells you that are reliable pieces of information and those pieces of information that aren't reliable. When people begin to talk to one another and begin to adopt things that they've discussed amongst themselves, then you begin to have multiple witnesses telling you things that perhaps if they had been separated and they had not communicated with one another, you would get a piece from one witness, and you might get a different piece from another witness, and then maybe a different piece from another witness. And that helps you to be able to separate what people actually know and saw and heard, as opposed to getting kind of the chicken soup at the end, where multiple different people's recollections are kind of thrown into one bowl and you can't really tell who actually saw and heard what.
And so the issue of separating witnesses, is that a concept that you learned early on in your law enforcement career?
Pretty much a day one concept. Yeah, pretty much.
Meaning your initial training as a police officer, the police
Right.
academy, I should say.
Right.
They teach you this concept of you come to a crime scene and you do what? Witnesses are there. What do you do?
Yeah.
Separate them, right?
Yeah, you're in police academy training, you would, as a patrol officer, would be taught your first priority when you arrive at a crime scene is safety, making sure that there's nobody that's about to be hurt. Second priority is making sure that if there's an outstanding suspect and somebody that may potentially be dangerous, that person is dealt with. Your third priority is secure the scene and make sure nobody touches anything and does anything to change the scene beyond what it is right now when you got there. And that you're very close to that would be your priority of separating witnesses and getting people off the places where you'll be able to interview them and get their recollection of what they actually know about what happened.
And so you've talked about the dangers of contamination. What happens when you come onto a scene and you realize that multitude of witnesses are talking to each other? How do you handle that problem, if you can?
Well, if you've already got where people are beginning to talk to one another, you want to separate them still as fast as you can, because they may have talked about certain things, but the longer you let them stay together, then the more they're going to talk about what happened. So as fast as you can, you need to separate them. But then what you would do is, in that process of interviewing people and figuring out what they saw, you need to sort of understand, if you came up and there are people that are talking to one another, keep track of who's talking to who, so that you'd know that these people were in conversation with one another. And you ask them too in an interview. You can ask the person, have you talked to anybody else at this scene? And then you can also start to look at things like when you have multiple witnesses telling you the same thing, to question them about, did you actually see that, or did you actually hear that, or is that something that you heard from another person? Because sometimes the person will tell you, they'll say, oh no, I didn't actually hear that, so-and-so told me that. And then you're able to clarify, okay, that person doesn't actually know, they're not actually a witness to that, they were told that that's secondhand information. So you can deal with it. Obviously you can't unring the bell of anything that they did hear, but you can at least try to get a handle on what they heard and what contamination may have happened.
Would you agree or disagree that becomes even a much greater problem if you have an emotional scene, for example, in a shooting? And if so, why?
It is always, one of the biggest problems with dealing with scenes, especially in the initial few minutes of arriving at a scene, is that there's a lot going on, a lot in terms of what's happening. If you have a lot of people there, then you have a lot of emotion going on, you have a lot of things happening, and you have to separate people, not just from the standpoint of them not communicating, but it also helps calm the whole thing down. Because when you let people sit quietly and reflect quietly on something, then they'll have a tendency to calm down more than if they're talking to one another, and perhaps conversations can get people going. You sort of want to get them thinking of what they remember and kind of get calm in that, and it'll be easier to interview them once they've had some chance to calm down.
The process of trying to investigate those witnesses that have been contaminated, would you agree or disagree that part of that process is actually testing their recollection, meaning where were you seated? How far were you from the seat 9? Taking them back actually at some point in time into the crime scene. Is that something that should be done when you realize that there is contamination in your crime scene?
It's good to do even without contamination, but to take a witness and actually interview them at the place where they were. You can interview somebody in a separate location, get preliminary information, go through their account of what happened, but it's a really good idea to take that person back to where they were to walk through it, because a lot of times it'll help them to sort of trigger their memory, where they remember things, because now they're actually seeing. So they're looking out there, and they're actually sitting there looking at the seats in the movie theater where they saw things, and they're able to sort of get an understanding. And sometimes you get witnesses where you take them back, and they've told you stuff, and then you take them to a location. You say, okay, now was the person over there? And they'll stop and look and go, I remember this being over here, or this. In other words, they realize that there was something faulty about the way they recalled it, and now seeing the scene and being back in that environment, they recall it differently. So it's a good idea to do. Plus, as I said before, if you take a witness back to the location where they said they were, you can determine whether or not they could have even seen what they said they saw. Sometimes what happens is you take a person back, and then you realize that there's a line of sight problem. They couldn't even have seen it, or there's something in between, or there's some type of issue that maybe they couldn't really have seen what they said. So it's a really good idea to get them to show you, and not just go back in and look at it, but have them demonstrate it. Where were you? Okay, you were sitting in the chair. Well, how about having a seat back in the chair? So you turned and you looked over your shoulder. Okay, can you show me how you looked over your shoulder? And go through that whole process with them.
And do you document that, and do you preserve that process as well in a crime scene diagram or in some other form, so that others like myself at some point in time can see that?
Yeah, the primary ways that you can document that is photography is one, and by that you could photograph the area where the person was, and then take pictures from where they were back in the direction of where they were looking to see what they saw. You can include them in a diagram. So that's quite typical, would be to put a diagram together and then show each person's location on that diagram. Measurements. You could collect a measurement from where they were, say just a straight line measurement, over to where they were looking, so that you have some record of how far it was. And then you can also, during the process of interviewing them, you can audio record it, or you can even video record that interview with them, so that it's all completely documented and recorded for any need later on.
Let me ask you a question about recording, which is maybe somewhat interesting. Law enforcement officers don't have to tell the individuals that they're interviewing that they're recording them, right?
That's correct.
Perfectly legal, right?
That's correct.
You don't have to, spook anybody that you're recording them. You can put the recorder in your pocket and fire away.
That is correct.
Is that correct?
Yes.
Okay. Is that a tool that's used quite often by law enforcement?
It is. It is. A lot of times if I was interviewing somebody with in person at a scene or something, I would have a recorder out. I would let them know that, but I would by no means required. In fact, depending on the particular location and stuff, you can even record people without you being present. So, for example, the backseat of a police car. It was not uncommon that we would have a recorder in the backseat of a police car, primarily where you had maybe two people that you believed were involved in a crime, and you could put them in the backseat of the police car, turn the recorder on, or some of the units now even have wireless microphone systems, so the officer can stand outside and listen. And then they have a conversation, hey, tell them this. Then you know that. And so then you're able to challenge them with, well, you said this, but you and your buddy just made that up in the backseat of the car, didn't you? So you freely record certainly any conversation that you're a part of.
What we've been talking about, and I'm going to call it verifying a witness's statement or refuting it through forensic processes. Is that more important in scenes where you have the incident occurring with limited lighting?
That's one of the biggest issues, really in a lot of scenes, but certainly something here, like in a movie theater where you have atypical lighting conditions. So not like we have in this room where we have fairly, fixed amount of light that's steady throughout the room and it's pretty consistent throughout the room. Obviously in a movie theater, while you have something playing on the screen, the lighting conditions not only are quite a bit darker than normal lighting like this, but you have lighting that's constantly changing because of what's on the screen. So that is something that becomes really important to understand how that would affect what anybody saw or perceived, and you'd want to be able to document those things.
Would that likewise be important when you have a scene where, for example, in this case, previews being played loud?
Sound also, yes, is an issue because particularly where you have people that are reporting things that they heard, that you want to make sure that they could hear it and that there wasn't going to be any interference with what was playing, and that in fact everything that they were hearing was coming from what was going on in the movie theater as opposed to what was being played on the screen.
Would you agree or disagree that two of the most important senses that we have as human beings are your sight and your hearing, right? Why is that the case? Why are they so important?
Well, in most of the time when you have somebody that is what we call a percipient witness, a person who perceives something related to that's going to be, they either saw it or heard it or both. It's not uncommon where we'll have shooting cases where a person never actually saw anything, but they heard something. Sometimes you have cases where they don't hear anything. Maybe they're inside a house and they're looking outside and they see it, but they don't hear it. But obviously, if you have a shooting incident that takes place in a room and there are people there, then potentially they're going to both see and hear it. That's probably about the only thing they're going to really perceive, but they will certainly see and hear based upon what they're looking at and what they're able to hear.
And that influence of light and noise, could that have an impact on the accuracy of what they're saying?
It could, because, again, just like talking about line of sight and going to where the person was, the lighting conditions can affect what they could see. I can obviously see a lot better in this room with lights on than I would be able to see in it if all the lights were turned off. So you'd have to really, you want to know that. You want to understand what could a person actually see based upon those lighting conditions and how it's going to affect what they saw.
Would you agree or disagree that there are tools that are available to preserve lighting conditions and noise conditions?
Yes, there are.
And would you tell the ladies and gentlemen of the jury what tools forensically are available in order to preserve both lighting and noise conditions?
Lighting conditions can be documented with photography and can be documented with taking a light meter and actually getting readings of how much light there is. And then sound similarly can be documented. You could record it, and you can also use a sound level meter to see how loud this particular sounds are.
Would you agree or disagree that in a self-defense case, the perception of the accused is extremely important?
It is important, yes.
And so, would you agree or disagree that the individuals that are investigating a self-defense case should certainly have the competence to know how to deal with those particular cases, correct?
Yes.
And so if you had arrived at a crime scene and the lead detective in the case clearly did not have the competence to understand and investigate a self-defense case, tell the ladies and gentlemen of the jury what you would do.
Well, one of the things you have to do anytime that you're investigating any type of a crime scene is know your limits. Those limits can be based upon your own knowledge and training. Those limits could be because you don't have the equipment. Those limits could be because you just don't have the experience with it, and you're not comfortable in terms of having enough practice, basically, with a particular process or something that you need to do. And so you have to consider your outside resources. The biggest thing with a crime scene is that once you get there in law enforcement, you can control that scene as long as you need to. There's not anything that legally prohibits you from holding a scene. You may have to get a search warrant, or you may have to get, go through some hurdles, but those are easy hurdles to go through. And I have worked crime scenes where we've held a scene for 5 days, and potentially longer if you needed to, because once you let it go, it's gone. You have to assume that whatever evidence you wanted is gone, because even if you went back and found it later, the argument is you didn't preserve the scene. How do you know that that's the evidence that was there? So you have to do that step. You have to document all these different things, and if it requires getting outside help, that outside help is available.
And where would that outside help be available if you need it?
Well, the first place that, being a police officer in Florida, the first place that I would look to for outside help would be the Florida Department of Law Enforcement, because they have forensic science laboratories at various different regional laboratories throughout the state. And so they have a lot of different people and provide a lot of different forensic services through their laboratories. If FDLE is not able to provide that service, then your next step would be looking at other law enforcement agencies, perhaps federal, FBI, Bureau of Alcohol, Tobacco, and Firearms and Explosives. They have their own laboratories and their own experts in various things. There could be other ones. And then past that, if you can't find it in a forensic science laboratory, a government laboratory, or law enforcement agency, then you look to private sector people like myself that do stuff. And I actually have done some cases where I've been called by law enforcement and brought in to help them with whatever particular issue that they were dealing with, in order for them to figure out what happened and be able to make a decision as to whether or not to arrest somebody.
Would you agree or disagree that if you have the lead detective who is not well-versed in the issue of self-defense, would you agree or disagree? Just speak to the rest of the detectives, right? Find the detective that does have that experience. Is that a difficult thing to do?
No, in most agencies, you got somebody in the agency that's got some background with that. So, yeah, the detective that gets there may not be the one that's got a lot of background in it, but if there's other detectives, and typically when you're at an agency, you already know. I mean, there's people you work with, so you know who it is. That I would get calls because I had kind of had a specialty in doing shooting reconstructions and stuff, where detectives would come to a scene, there'd be another crime scene investigator there, and the detectives would, next thing I know, I'm getting a phone call from my supervisor saying, hey, the detectives on the scene have asked for you to come out there. Because they recognized that I was able to do things that maybe the ones that were out there didn't have as much experience with. So, you could easily, between your own agency and other law enforcement agencies, and then worst case, the private sector could find the assistance that you need.
Let's continue on this road of perception if we can for a bit longer. Is the environment of where a shooting takes place, is the environment important, and if so, why?
Well, the main issues that you have with respect to environment, it's always important. There's always going to be something about it that you need to understand. But you need to be able to understand the constraints within a particular environment, meaning what things limit what could have taken place. So, here you're talking about a movie theater and you have people sitting in rows of seats. I mean, we pretty much all, anybody that's been to the movies knows what that's like when you go in and you sit down, and especially if you're not at the end of the row and you're in the middle of the row and you have to go from the end of the row to where your seat is, those kinds of things that create constraints as to what could take place. There's a lot of chairs in the way. You have a very limited space between there. You also, in a movie theater, you have things like step down from one level to the next level. That's not, normally if you're in a room like this, it's all at the same level. In the movie theater, it's not. So you have to be able to document all those things to know how is that affecting what could happen and what somebody could see or perceive.
Let's talk about some of those issues that in the environment could possibly affect perception. Would you agree or disagree? I think we've talked about lighting. That's an easy one, right?
Right.
And we've talked about noise. That's an easy one. Is that correct?
Yes.
Physical layout. How does physical layout sometimes affect one's perception?
Physical layout really more than anything has to do with, like I said, the constraints, the ability to move, the ability to see what's there and what could, affect how you perceive something, as well as just the general space. How does it affect movement? How does it affect the way somebody can move or react to something that's happening? Things like that.
Now, in this particular case, we had video cameras, surveillance cameras in this theater. Is one going to get the same perspective that the accused has if he's sitting in seat 9, back row, as you get from a video camera that's up 30, 35 feet up in the air?
No.
And explain to the ladies and gentlemen of the jury why you don't get the same perspective.
Multiple different reasons. I mean, not the least of which is that the video camera is not really giving you the same perspective. Even if I had a video camera sitting right next to my eye right now, the camera and what people would see watching that video would not be identical to what I see. But the location of it is significant. In fact, one of the training, whenever I teach a shooting reconstruction class, I talk about video quite a bit because, especially nowadays, it shows up so much in the cases that we work. I have an example case that I use where there's two different in-car, it's a police-involved shooting, there's two different cameras, police cars that have in-car video cameras that record the incident.
Objection relevance to the question that was asked.
It's very, very relevant. He is explaining that process and that problem.
And what happens there in this particular one is one of the reasons why I train on exactly this topic is that the first video camera, you play it, and the way that the shooting looks is it basically looks like a guy's walking away from the police and they shoot him in the back and kill him. And even in a room full of police officers, you play the first one and most of them like, wow, what was that? And then you show them the second car, and in the second car you see the guy pull an object out that looks like a gun, point it at one of the officers, and there's a lot of information that's not captured. So whether you have multiple cameras or even multiple witnesses, wherever I am, I'm seeing something that even somebody that may be close by me doesn't see exactly the same way I saw it. And certainly a camera is the same way. If I've got a camera that's way mounted up on the ceiling over there, it's not seeing this incident the same way my eye sees it at the time.
So what do you do with that? That's a problem. How do you try to compensate for that?
Well, the main thing there is to document as much as possible from the viewpoint of any given person that you're dealing with, whether it's a witness or whether it's the person that's actually involved in a shooting, to get their perspective. So if you have, say, a shooting like this, where you have a person that's in a movie theater seat and shoots somebody, I would want to go back to that movie theater seat and have them show me, just like I would with any of the other witnesses out there, I'd want to bring that person back in, put them back in that movie theater seat, and have them explain everything from that perspective, and then look at it. They say, I saw such and such, okay? Can they see that from their positioning? What kind of lighting? And you can go through really in detail with them. What was the lighting like at that point? What could you see? And get the details of it, and then document that the best that you can with photography and the video if possible, and those kinds of things, to be able to know and one, keep a record of it, but also to sort of test the veracity of what you're being told.
And if you're in a theater like the Cobb Theater, and would you have the ability to go to management and say, I want you to turn that lighting to big one?
Certainly. I mean, as long as that the movie theater's cooperative, which in this case it was, then you could simply ask the management I myself went to the movie theater and did exactly that and said, show me the lighting level. And they explained the different lighting levels, and they set the different lighting and things like that. And of course, if you needed them to replay whatever was on the screen, things like that, just ask them to do it and see what you're able to document and do with that.
And if they refuse, you have subpoena power and you have search warrant power, right?
That's right. Investigative subpoena, which basically, as a detective, all you got to do is go to the state attorney's office and ask them to prepare an investigative subpoena. And then you can also, if necessary, get a search warrant. Draw up a search warrant, take it to the judge, have it signed, and then and at that point the theater doesn't have a choice.
Dr. Knox, in a situation like that happening in the theater, would you yourself, as the crime scene investigator, would you sit in that theater and have the lights dim to mid-level one and have the previews played?
Objection, relevance.
I'll overrule.
Would you?
I would, yes. I would routinely in shootings look at those kind of things. And in fact, I even teach it when I teach a shooting reconstruction class and talk about documenting lighting conditions and things like that.
Why would you sit yourself there and have those parameters for you? Why would you do that? Why is it important?
Well, several things. Part of it is that you're documenting, because you don't know what questions are going to come up later on. You don't know what issue may arise later on as you go through an investigation, so you want to document what's there. But also, more than that, is because here's a scene where you're trying to reconstruct what happened, that's at the center of reconstructing it, is knowing what are the conditions, everything in terms of the conditions at the time that would affect what a person saw and perceived and what they're responding to.
In you mentioned bringing the accused to sit there in the seat What sort of information would you want from the accused in your questioning of the accused in order to give you a good perspective over what the accused was possibly seeing and knowing at the time?
Well, you really want to understand, with whether it's the person that's the shooter or any person, the witness or anybody, you want to know what it is that they say that they saw, and you want to test it. Because obviously if something that a person is telling you is inaccurate, particularly if they're the person involved in the shooting, you want to confront them with the fact that it's inaccurate. So you might find something that as you bring them in, you test it, and they've described something, and then you realize that's not possible. So then you would confront them with, well, that's not possible, so, explain to me why you say this, but this couldn't have happened. Because, one, you're giving them the opportunity to correct if there's something wrong in their recollection, or you're trying to see what a person may be doing. So if a person's being deceptive, for example, you keep testing them on those things, and then you just find that they keep changing their story, and that would tend to lead you to, think that maybe they're not being truthful. So it's not just about coming in and then just taking what somebody says at face value. It's about testing what they say to make sure that it's true and accurate and it's correct.
Obviously, you have participated in police-involved shootings in the past. Is it important to know, in a police officer shooting, for example, the body of knowledge that the police officer has?
Yes.
Yeah, I'm going to object to that. May we approach?
Yes, you can approach.
Dr. Knox. To the crime scene investigator. It's a self-defense case. And you know that the person that's accused is a retired police officer. Would you want to know the body of knowledge that that police officer, former police officer, had in threat assessment and realizing the cues of danger? Would you want to know that if you were the crime scene investigator and the lead detective?
You would. Primary reason is just that you understand from a person's training and background, things like their knowledge and ability to handle a gun, how would they handle it. So if you've been through training, for example, law enforcement training, then there's certain ways that you shoot a gun that you're trained to do that somebody who's never had that training would not necessarily inherently do. But also you want to look at what it is that he's looking at and what he's aware of in terms of cues and indicators to him that may have led to the decision to fire. So as a crime scene investigator, I'm primarily looking at trying to identify those things and then figure out, what is it that he saw? And that's going to be within the framework of his knowledge and training, not just that he saw something, because what does it mean to him? And so then you know better how to document that. So what do I do to document that so that it shows what he's perceiving and whether or not what he's describing to me matches up with what he's saying. So again, it's a matter of let's figure out what he made his decision on, and then we need to document all those factors to the best of our ability to be able to show that, if there's a particular decision that he made, was it made on, was that a reasonable conclusion from his point?
I object.
So let's continue with this perception factors that we talked about. I think we left off with physical layout. Video surveillance, we talked a little bit about that, did we not?
We did.
Okay. And so how important is it to a crime scene detective or crime scene investigator to realize, first of all, whether there's video around?
Video is,
I'd object only because I thought this was asked and answered. We went through the video already, but I don't have more, but.
All right, to the extent that it's been asked and answered, sustained.
Go ahead.
video is important to document it, to be aware of as a crime scene detective, because one, it can potentially show you very important evidence. One of the biggest things we get out of video in terms of reconstructing, particularly in a shooting, is timeline. Because when witnesses are telling you about something, you don't really know exactly how fast it happened. You just know what their approximation. So if you ask somebody, well, you heard this and then a shot is fired, how long in between those things, they're giving you an estimate. But with video, you can often go to it and know exactly between an event to another event. Sometimes we get video when you have multiple shots fired. We can know exactly the cadence and the speed with which those shots are fired because of what's recorded on the video or audio. So you need to look at it. You need to know and be aware of it because until you know it, until you've seen it, until you've had a chance to really analyze it and look at it, you have no idea what it's going to tell you.
And so, if you go into a theater and you see that there's a surveillance system, you just tell yourself as a crime scene investigator, I'll see it tomorrow or the next day.
No, it could, because like any other type of evidence, you need to secure it.
Immediately?
You need to secure it immediately, because you need to make sure as fast as you can that just like any other evidence, that nothing's going to happen to it. And then you also need to see it as soon as you can, because that can affect how you process a crime scene, what evidence you're collecting, because you may see things on the video and realize, oh wait, that's involved, or I need to look at this item, I need to look at this location, I need to do things because you just saw it on the video. And so it was not uncommon for me, even in smaller things. I'd go to a burglary scene or go to a robbery scene and see that they have a surveillance video, and I'd ask them, can I see that video? Because if you had, say, an armed robbery, it was an excellent tool for me as a crime scene investigator to watch it happen on the video, so I could say, okay, well, the person went over here and touched this, and they went over here and touched that, and now I know areas to process, and I know what kind of things to do.
And so, tell me, what if the company says, you're not getting it?
Well, the first thing is secure it, because you don't want them to be able to do anything with it. And then go get a search warrant. And then once you have a search warrant, they can tell you you're not getting it all day long, but they don't have a choice. That's signed by a judge. It's, an order for you to go get the evidence. And so, that would be the step that you would take. You would not let that just go and then rely on somebody else to provide it, because you don't know what they're going to give you and what's been contaminated in the process.
So law enforcement controls the process of securing it?
Absolutely. Once you're there at the scene, then you take control of all of it.
Would you allow an entity just to kind of help you out to preserve it?
You wouldn't, obviously there's going to be probably some level of assistance, even if it's just, can you show me where the DVRs are? Have them take you to the room, those kind of things. But you're not going to let them take care of it and just trust that they'll provide you with the video, not just because of a fear that they may do something to it and contaminate it, or that they may not cooperate with you, but more than that is that you don't know what level of training they have in handling that type of evidence as a forensic matter, and they may do something inadvertently to contaminate that evidence that you now have to deal with. And so, that could be problematic. You need to secure that as fast as you can.
Do these departments, for example, the Pasco Sheriff's Office, do they have cybercrime units that are competent individuals in order to properly preserve video evidence?
Most reasonable-sized law enforcement agencies have at least somebody within their, usually in the detective unit or technical support unit, that's able to do that. And if the agency itself doesn't, Florida Department of Law Enforcement does, and it's just a phone call away.
What about seating? Not only the seat that the accused person was sitting in, but seating in general. Is that an important factor to consider?
Yes. Whenever you have a case like this where, a person is seated and they're dealing with a person who's on another seat in front of them, you have introduced, as I was describing before, constraints. You have stuff in the way between the two people. And also, obviously, things change. Perspective changes. All sorts of things change based on, if I'm sitting down as opposed to standing up.
So what do you do with those seats? Do you measure them?
Yes.
Do you examine them to see what type of seat it is, whether it's a very deep cushion or firm?
Yes.
Do you measure the distance between the seats?
Yes.
Do you measure the height of the seat?
Yes.
Do you measure the height of the back of the seat?
Yes.
Do you measure diagonally as well, if need be?
If need be, yes.
And while you're doing those measurements, what do you do in order to memorialize what you're doing?
Well, you can do several different ways to keep track of that. You could draw sketches or diagrams and diagram and show all the different measurements that you've collected. You can photograph them. You can put, a measuring device down and then take pictures of each measurement to be able to show it. So there's several different ways you could do that.
And the reason that you're preserving all those measurements is for what reason?
Well, primarily because from a standpoint of reconstructing, you need to have the measurements of the area so that you know what kind of distances you're talking about. But also, in the initial portions of it, you're just documenting everything to have it documented so that you know the locations, distances, and all those sorts of things, because a question may come up later on during an investigation, and you don't want to have to go back and try to get those measurements.
Mr. Escobar,
Yes, Your Honor.
we need to take a lunch break.
Okay.
So, ladies and gentlemen, we're going to take an hour for lunch. If you would be back at 2 o'clock at the jury pool room. Please remember my instructions during the recess. Don't do any independent research. Don't talk about the facts of the case amongst yourselves or with anyone else. Don't watch any news. Thank you. Enjoy your lunch.
I'll ask for the recess for 1 hour.
Do we have our jurors all?
I think we do.
Okay, good. We ready? Yeah. Bring them in, Tina. Thanks.
Hey guys, you ready?
Thanks, Terry.
Ready for the jury, Your Honor?
Yep.
Jurors in the courtroom. Jurors may be seated. President accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, thank you for returning. Were you all able to abide by my instructions during the recess? All right, good. We'll get started again. Dr. Knox, you're still under oath. Go ahead, Mr. Escobar.
Dr. Knox, I think we left out, we were talking about some of the things that you do as a crime scene investigator involving cases, specifically also in self-defense cases. What about the distance between the shooter and the deceased? Is that an important factor? And if it is, why is that an important factor?
Well, it's definitely an important factor because obviously the proximity of two people together goes to things like what they would perceive in terms of level of threat, what kind of interaction they could have, whether or not a person is within range of being struck or things like that. So that would be an important thing to document.
And so what do you do in that circumstance to memorialize that distance?
Well, the location itself you would look at so that you could document, for example, here you have seating which affects distance. Then, of course, you also could have things like if there's any physical evidence that would point to where people were located, documenting that and measuring those distances and looking at any other evidence, whether it be video, whether it be autopsy results, anything like that might also help you to know what kind of distances there might be between people.
What about the relative physical size of the two individuals? How do you memorialize that?
By taking actual measurements. So in the case of a person that's deceased, they get measured at the time of autopsy. In the case of anybody that's living, you can go measure them. So it's not uncommon in a shooting case, for example, to take the person that fired the shot and then get some measurements of their body in order to have those measurements to know things like how far out could they have extended their arm and what kind of reach, how high they would be sitting, those kind of things.
Getting back just briefly to the issue of interviews, and in reference to the location of witnesses and the accused and the deceased, how intent are you in trying to make that determination as far as distance is concerned? How important is it to try to be as exact as possible?
No, I object to the relevance of how important it is to this witness.
In crime scene investigations altogether.
All right, with that clarification, sustained, and we need that clarification. Thank you.
So that's one of the things that you are really focused on when you're doing crime scene investigations and reconstruction with respect to a shooting, is because obviously the distance between two people is very significant as far as what they could do to one another, as far as what the person would see and perceive, those sorts of things.
Your Honor, we would tender him now before we start getting into what work he actually did in this case as an expert witness in the field of crime scene investigations and reconstruction.
I would object to the format of the question.
Approach. As to the crime scene reconstruction
An investigation.
and investigation.
Matt, don't drive, real quick. May I approach, Your Honor?
You may.
Dr. Knox, I'm going to show you what's been marked as defense exhibit number VV and ask you if you recognize that exhibit.
I do.
And what is that an exhibit of?
This is a PowerPoint presentation that I've prepared in this case.
And does it include photos that you took and photos that you've also analyzed in this particular case?
Yes.
And do they fairly and accurately depict those photos that you considered in your work in this case?
Yes.
Your Honor, we would, at this point, as a demonstrative evidence, ask to publish VV.
Renew prior objections.
No, Your Honor. Yes, I do, Your Honor. I'll prior objection, sorry.
All right. It's the same ruling sustained, but, I mean, overruled.
Yes, Your Honor. Okay, let's go to the next screen, please. Mr. Knox, if you... Your Honor, may I ask Mr. Knox to step down, please?
Okay.
Mr. Knox, I'll give this to you. If at any point in time you want to point something out or it's available to you. What is this particular photo in your PowerPoint? And I believe it looks like it's, there's a little number 3 down here. I'm not sure if that stands for it or not. But what is that photo that we're seeing?
So this is an overall photograph just showing the outside of the movie theater, just for reference purposes, that this is where we are at this particular scene.
Okay, next, man. And is this showing the Theater 10 lone survivor area of the entrance of the theater?
Yes, so you can see there are multiple theaters with different signs. Number 10 is right here, kind of in the middle of the photograph.
Next one, man. And this photo right here, did you take this photo, or was this a photo that was provided to you?
I believe this is one that I took.
Okay. And so let's talk a little bit about you going to the Cobb Theater. On how many occasions did you go to the Cobb Theater?
Twice.
Okay. And let's talk about the first instance that you went to the Cobb Theater. What was your purpose in going to the Cobb Theater during the first instance?
So the first time that I went to the Cobb Theater was to see it to get photographs and measurements and things like that, as well as I had the management show me the different lighting levels and stuff so that I could become familiar with those things.
Okay, and so this is a photo that you took there?
Yes.
I think you took something like, I think it was over 200 photos. I'm not going to go through all of them, don't worry about it. We're only going to go through a few. What is this particular photo showing?
So you can see this is sort of a wide angle showing most of the theater with the house lights on. And then this yellow circled area here is just showing the area where the actual shooting took place.
Next one, Matt. Okay, what is this particular photo showing?
So this one, and you can see that there are annotations showing the actual seats where Mr. Oulson and Mr. Reeves had been sitting.
Now, as part of your investigation in this case, did you get a large volume of documents that our office provided you, police reports, for example?
Yes.
Depositions, for example?
Yes.
Lab reports, for example?
Yes.
Forensics, for example?
Yes.
Okay, so you had a large volume of information that was being provided to you even before you went to the Cobb Theater.
That's right.
And did you analyze all of those documents in an effort to be able to do what you were asked to do in this particular case?
Yes.
Okay. Go ahead, ma'am. And so this is a picture that you did not take, obviously.
Right.
Tell me how you used this particular photo and why this particular photo was of interest to you.
Well, this shows the area. This is one of the actual ones taken by the forensic investigators with physical evidence still in place. And this particular photo it's a good view looking down because you can see the two rows of seats and see where the things are on the floor and around the area.
Okay, next. So in your measurement process, let's go back to that last one so that he can talk a little bit. In your measurement process, what is it that you wanted to do? Show the ladies and gentlemen of the jury what was important to you to document, to measure for your assistance in this case.
Well, the main thing is just to have photograph or measurements of the different dimensions of the seat. So things like the seat bottom, where is it when it's pushed down and somebody's sitting in it? How high is it? What's the width between the arms, and what's the distance between this seat and the seat in front of it? Those sorts of things.
Okay, Matt, next one. And so you go about doing that, is that correct?
That's correct. Yes.
Okay, and as you're taking these measurements, how are you memorializing it?
So you can see here that what I'm actually using is a tape measure that has large numbers on it, show up in the photograph. And so these measurements are all photographed, and then what I've done is added annotation so that you can see what that actual measurement is.
Before you use those measurements, do you take any precautions to make sure that the tools that you're using are forensically correct?
Yes, yes. So this particular tape measure that you see here, this is actually, it's what's called a pocket rod, but it's sold by forensic supply places as well as places that sell surveying equipment, things like that.
Okay. And so tell the ladies and gentlemen of the jury what measurement you're seeing here at 1 foot 7 inches.
So this would be the measurement just with the seats in place, nobody in them, from the basically the end of the armrest on the back row of seats to the back of the seat in front of it.
Okay. Next one, Matt. Okay. This is a little different. Tell the ladies and gentlemen of the jury what measures 1 foot 3 inches.
So you can actually see here that this seat back has some recline to it. So when a person's sitting in it, it actually can push the seat back a little bit. So what we did is pushed it back as far as it would go, and then did the measurement again, and it reduces to 1 foot 3 inches.
Okay. And so you're doing the variables for preservation of evidence. Is that what you're doing by pushing that seat back?
Yes.
Okay. At the time of this incident, you don't know if the seat was back or if the seat was not back. Am I correct?
That's correct.
but you're providing those variables for someone like myself to understand.
That's right.
Okay. Next one, Matt. What's this measurement?
Here, this is a diagonal measurement from the top of the seat in the back row to the top of the seat in front of it. Again, seat just in the static position, not pushed back. So this particular diagonal is.
You want to just have to go here. It's red. You should be able to.
Yeah. So this particular one, you can see the measurement goes, it's 3 feet 8 inches, so measuring diagonally from here to here. And what that's basically doing is showing you how much distance you have moving from the back of the seat at the top of the seat over to here along that diagonal.
Next one, Matt.
And then this is a similar measurement, except instead of measuring at the top of the seat, measuring to the back of the seat. And you can see it's a little bit shorter distance, but it measures 3 feet 2.5 inches from here to this top edge of the seat.
Okay, go ahead, Matt. Okay.
And then here measuring the from the back of the seat on the seat itself straight across to the back of the seat in front of it. And of course I've included a measurement here, so 1 foot 5.5 inches, 5.5 inches from the back of the seat to the front edge of the seat, and then 1 foot 3.5 inches from the edge of this seat to the back of that seat, and then the total distance from here to here being 2 feet 9 inches.
And is this something, this is a procedure that you would do in every crime scene investigation that you would perform? Is that correct?
Right, you take measurements of whatever's around there. So sometimes you're working a scene and it's in a bedroom, so you're measuring where all the furniture is and things like that. Here, because it's the movie theater and the seats are what are of interest.
Is this the same process that you teach your students as well?
Yes.
And law enforcement throughout the country?
Yes.
Okay. Next, Matt.
And this is showing the width of the seat at the top of the seat back. It's 1 foot 8 inches.
Next one, Matt.
And then this is showing the distance between the armrests on the seat, which is 1 foot 10 inches.
Why is that particular measurement of importance, the width of the seat?
To show how much room a person that's sitting in the seat has to move around. So how far can you move one side or the other?
Next one, Matt.
And then here, this is showing a height measurement. So coming up from the floor to the top of the armrest, right here at the front of it, at the cup holder, just slightly over 2 feet, 1/2 inch.
Next one, Matt.
And then this is showing going from the floor to the seat bottom where you would be sitting on it. And you'll notice there's a hand here. Somebody's actually pushing the seat down because, again, just like the seats that recline back, the seat does go up. And so we want to make sure it's pushed down the way it would be loaded if somebody was sitting in it.
Next one, Matt.
Okay, and so this is showing the distance here between this seat bottom and the top of the armrest, which is 8.5 inches.
Okay, Matt.
And then this is just showing some measurements showing the height of the wall here. So this wall, this tape measure behind her is actually on the floor, and you can see that this wall behind that seat is just over 5 feet.
Okay. That's your close-up.
That's the close-up that actually shows you the measurement, 5 feet 2 inches.
Okay, next one, Matt. Okay, let's stop there for a second. You took far more measurements than what we've showed here today, is that correct?
That's true.
Okay. You took measurements throughout that particular theater, is that correct, at the different locations throughout the theater?
I did. I took quite a few different measurements.
Okay. Now, Matt, let's go to the next one. The documentation of of items there at the theater at the time of the shooting, is that an important thing to do?
Yes.
Okay. And now that you've taken measurements of certain areas, are you able to certainly understand a bit better where those particular items may have been, as far as distance is concerned?
Yes.
Okay. And so what do we have here in this particular photo?
So this is just showing, again, going back to that overhead looking down on it, this is the evidence, the way it was documented by the forensic investigators. But you can see where there's a popcorn bag on the floor here, and of course popcorn, and this is the seat that Mr. Reeves was sitting in, so this would be right, basically between his feet, and then this would be off by his right foot.
Okay. Next one. And that's documenting?
That there's a cell phone right here on the floor.
Okay. Same documentation?
Just a different vantage point with the camera, but yes.
Now, what is this photo, what is that depicting?
This is all showing the same area, just a different angle, and I point out that the fired cartridge case from the pistol is documented right here.
Now, this photo was taken by their forensics, is that correct?
That's right.
And some of these identification marks are, that one's hard to read, it looks like. Is that depicting the actual seat, number and row?
Yes, that's the way I understand it.
Okay. And so, if I can read it clearly, this would be the seat that Mr. Reeves, according to their depiction, that Mr. Reeves would have been seated. Is that correct?
That's right.
Next, Matt. I think there's a better one. I may be wrong. There was a fired cartridge case that was found in this case.
Yes.
Was that the general location of where it was found?
Yes.
And Matt, could you give us the next one? I believe it's a easier picture to see. Is that a photo depicting the cartridge of the bullet, or spent casing, I should say, not cartridge? Goes to show you how much. Casing of the bullet, that's where it was, right?
That's right.
Okay. Next one, ma'am. Before we get to the next series, did you also see the autopsy photos and the wounds of Mr. Oulson?
Yes.
Okay, and did you also see the wounds of Mrs. Oulson?
Yes.
Okay. I don't think we need to go through those. Let's go through the next series. Okay, so now let's talk a little bit about, and I want you to stay standing here before we ask you a series of questions on this. Describe to the ladies and gentlemen of the jury what...
I object.
Okay, so let's talk a little bit about backlighting and explain to the ladies and gentlemen of the jury what backlighting is.
So backlighting is basically like the name implies, backlighting being lighted from the back. Excuse me. So, if you, most of us probably taken a picture of somebody outside with the sun, there's a bright sky is behind them, and you take the picture, and then you look at it and you see nice bright sky, and the front of them is dark, and it looks more like a silhouette. So that's an example of backlighting. And so, what we're interested in any kind of crime scene is just what sort of lighting conditions could be there and what sort of backlighting may be present that could affect how somebody sees it.
And so we're going to go through a set of photos here. You are not telling this jury by any stretch of the imagination that what they're seeing here in this backlighting is what Mr. Reeves actually saw on the day of the incident. Is that correct?
That's absolutely correct.
You're trying to show the actual effect of backlighting in certain positions when someone is in front of that backlight.
That's correct.
Okay.
Counsel, just over to the side.
Okay. Mr. Knox, just hold a second. Court's going to be reading an instruction that's appropriate during this period.
Ladies and gentlemen, this testimony is being offered only to demonstrate the concept of backlighting, and that's what you're to consider it for.
So let's talk a little bit about how you set these photos up in order to show the backlighting effect. This individual that we have here, what is that?
So that is it's a forensic mannequin.
And you use that mannequin and you place that mannequin where?
So the mannequin is placed on not the back row, the row in front, standing in front of the seats facing back toward the back row.
Okay. And at the time of placing the mannequin there, did you have a camera?
Yes.
Okay. And at the time of placing the mannequin there, was there backlighting, and where was the backlighting coming from?
The backlighting, as you can see, this is actually coming from the movie screen right there.
Okay, and so you place the mannequin in various positions in order to do what?
To show the effects of that lighting. So,
Object, Your Honor.
Okay, Dr. Knox, we're going to be going now through a series of photos of the mannequins in different positions. Is that correct?
That's correct.
Okay, go ahead, Matt. Go ahead, Matt. Go ahead, Matt. That's it. Okay. You can take your seat. Sorry, Your Honor. I made you come all the way over here, but just... Dr. Knox, you agree or disagree that I presented you with an issue concerning two items in this case, one being a light that was either reflective or emanating, and there were two items that I wanted you to consider in telling me what that light source was, correct?
That's correct.
Remember that? That was in the video.
Yes.
Is that correct?
That's correct.
Yes.
Dr. Knox back to the reflective or illuminating source. And you remember taking one of Mr. Reeves' shoes that we had obtained from court order?
Yes.
And you remember taking an iPhone?
Yes.
iPhone. And you remember going to the theater at, do you agree or disagree, what, 2 o'clock, 3 o'clock in the morning that we went there?
It was about that, that's right.
And did we bring Mr. Koenig and Doug Lacey from Beck Tech with us?
Yes.
And you agree or disagree, we did that in order to try to replicate and find out what the source of that illuminating or reflective light was that we see in the video?
That's correct.
And you agree or disagree, when we went there, the entire system had been changed?
That was my understanding, that's correct.
And you agree or disagree that we could not perform that analysis because of that reason?
That is correct, yes.
I have no further questions.
Thank you. Cross,
Thank you, Your Honor.
are we using the screen anymore?
I can move it.
That'd be great. Thanks.
Can we move it up?
Yeah. That's good.
Good afternoon.
Good afternoon.
I'm assuming you were billing in this case.
Yes.
Okay, and what's your hourly rate?
For this case, I think it's at $250 an hour.
Okay, and you charge for travel?
I do, yes.
And how much on top of the 250 do you charge for travel?
Well, the travel I charge at half rate, so for actual travel time.
So 250 an hour, and then for each hour that you travel, $125?
That's correct.
All right. And how much have you billed so far in this case?
I really don't know the numbers for that. I mean, I've obviously done a fair bit of work, but I don't know what the numbers are.
Okay. You keep records of that, I'd imagine?
I do.
All right. And you've testified, I think you said, in other cases?
Yes.
Okay.
Yes.
And I would imagine that when you testify in other cases, one of the first questions the opposing counsel asks you is how much you've billed in the case, right?
Sometimes I get asked that.
Okay. Well, wouldn't you say it's a great majority of cases? Because that's something that people normally bring out with the opposing people that are testifying for the other side, right?
Sometimes yes, sometimes no.
Okay. Well, my question to you is, don't you think it's a majority of the time?
I don't know. I mean, I've never really thought about it, but
I mean, for almost every deposition you've taken, people ask you, right?
no, I mean, not always. No, I get quite a few cases that's not really the.
Right. I'm not asking you about all the time. I'm just saying most of the time.
Yeah, I mean, I don't know. I couldn't give you the numbers. I don't know if it's most of the time, half the time, or what.
Okay, we're going to move on. The only reason I'm asking you is I would think that you would anticipate that question would be asked of you today so that you could come to court prepared to answer that question.
Yeah, I don't really look at the money numbers much at all.
And he doesn't object because he could have subpoenaed Justice Tico if he wanted that question asked. He's giving some indication that there's something wrong with it.
I'd object to the speaking
All right,
infraction.
Overruled. Move on.
The measurements that you testified to that we saw up on the screen, those are just basically measurements. You're not presenting them to this jury saying that these were where people were at any particular time, correct? They're measurements of the seats.
Right, measurements of the seats, just showing the different variances and so forth, yeah.
Okay, so like what I was saying, it's not supposed to give this jury the impression that's where anyone was in any particular point in time.
That is correct, you're correct.
Let's just talk just a little bit about backlighting. Now, just to make sure this jury understands, because this is important, the presentation that we all just watched, the only purpose of that was just to demonstrate the concept of backlighting.
That is correct. To demonstrate the concept, I'm not trying to demonstrate that that's what anybody saw in that theater that night.
Okay, and the object you chose was mannequins, because I guess it made sense, but in reality, you could have chose any object to demonstrate what the backlighting was?
Yes, I mean, I use mannequins because you have at least a human-like figure, because some of the issues with lighting is things like shadow. And so
Right.
obviously the shape of your face may cast shadow differently than another
Right.
object might.
And again, we weren't using those mannequins to say that was Chad's shadow or anything at all like that, right?
That's correct, that's correct.
And when you say backlighting, like in the photo that you showed to the jury, there was a white background, correct?
That's right.
All right. And you're not telling this jury that that was the background that was going on at the time of the shooting, right?
That's correct.
All right.
That's correct.
So really that picture doesn't depict what was going on at the time of the shooting, like you already indicated.
Right, right.
And when you talk about backlighting, obviously the nature of that is it's the back, right? I mean,
Right,
you
right.
saw the screen in the background is what I'm getting at.
Right.
Now that doesn't account for the overhead lights that were on, correct?
Well, when those pictures were taken, the lights were set at mid-1, which is the setting that they would have been at the time of the actual shooting.
Okay. And there was also the screen though itself would be moving and having a different light form.
Right, right. What was played at that time was just, it was a different trailer. It's not the same trailer, so I don't know that exactly what was on the screen at the moment of the actual shooting.
Okay. And you would agree with me that the camera lens cannot adequately represent what the human eye sees.
Yeah, that's correct, because for one thing, it's a two-dimensional image as opposed to the three-dimensional that you'd see, but you're correct. It is a picture of it, not what your eye actually sees.
Right. If there's no technology out there in reality, there may be in the future probably, but as of right now, there's no technology that can replicate what the human eye sees.
That's correct.
All right.
That's correct.
So we're just looking at a picture that's demonstrating some light in the background that wasn't the movie at that time, correct?
That's right.
May I have a moment, John?
You may.
Nothing further. Thank you.
Good. Thank you.
Any redirect?
Not necessary, Your Honor.
All right, thank you. May this witness be released or
Yes.
on standby?
Stand by.
All right, Dr. Knox, you're free to go, but if you get called back, you have to come back. I'm sure they'll allow you plenty of advance notice if need be. Thank you, sir.
Thank you.
Who's next?
Your Honor, before we call the next witness, we have some legal housekeeping matters regarding the next witness.
Okay, will 10 minutes do it?
I think so, Your Honor.
I hope so. Ladies and gentlemen, I'm going to let you take a short recess. Please remember my instructions during the recess, and we'll call you back pretty quickly. Thank you. Okay, so what do we got? Stuff on Dr. Bedard?
Yes, judges. The next witness is Dr. Bedard. I know that certainly had a Daubert hearing. The ruling was that he can testify.
Speak up a little, please.
Yeah.
We had a Daubert ruling. Certainly the ruling was that Mr. Bedard, Dr. Bedard, would be able to testify as to his expertise in the field of defense tactics, use of force, and human factors. And I know the order says something to the effect of subject to the normal rules of evidence, so I know that the state approached me with some concerns. One of the concerns was because, the deposition...
Let's be quiet in the galley, please. We're trying to hear.
The deposition was very wide-ranging, and I understand Mr. Martin's perspective. Dr. Bedard didn't write a report, so he just wanted to find out what his knowledge of is, and then potentially what he would be testifying to. And so one of the issues was a kind of a narration of the video. We agree that Dr. Bedard is not going to narrate the video in any form.
Okay.
Another issue, as I understand it, was that there was some discussion as to whether Dr. Bedard thought that Curtis Reeves acted reasonably. He gave his opinion because he was asked. I think he prefaced it with something to the effect of, I can't say that in front of a jury. Certainly, that's not going to be brought out in his testimony. One of the issues is I think it's an objection as to cumulativeness, because we had Dr. Cohen testify as to age-related kind of self-efficacy. A person realizes they're vulnerable and all that. And so I know that that's something that one of the things Mr. Martin wants to address. So the court knows what my perspective is. It's true Dr. Cohen did testify to a limited degree about a perception of vulnerability. However, we stopped short of allowing her to do a threat assessment. In fact, that was one of the things that was objected to. So when it came down to making certain choices of doing things because of that perception of vulnerability, she wasn't allowed to do that. So it's not cumulative in that Dr. Bedard's going to testify that that's a factor in terms of threat assessment and risk assessment, which Dr. Cohen was not able to testify to.
Okay.
Judge Lewis's order, as you know, indicates as to whether any specific facts or data underlying Dr. Bedard's opinion or any specific testimony will be admissible at the trial will be a decision for the court at the time of trial and subject to any objections on that ground. So I have numerous objections
Okay.
to numerous parts of his testimony, and it includes not only what I presented in my previous motions that have been thoroughly briefed and you've had a benefit to read, but also statements that he made in the very lengthy deposition. So I'm going to begin with the issues that I brought forth in the motions that I filed.
Okay.
And if we could just be able to address one at a time.
Yes, one at a time.
Mr. Martin has,
Yes.
looks like many.
Yeah. Okay. One at a time.
Judge, one of the things that has always been a concern is the use of the video by experts. When an expert testifies, even though there's a jury instruction regarding the jury can accept or reject any testimony, including the expert, anytime a person comes in and says, I know more than you because I have specialized knowledge, it carries some weight, and some people go, okay, I give up, I'm just going to go with he says. So it's important that I ferret out exactly where we're going with the expert testimony. I'm going to deal with the use of the video to start with. I understand that there's not going to be a running narrative of the video. But this is how the video was used by Dr. Bedard. He used the video to interpret, he used the content of the video in making certain interpretations. One, he used the video solely for his conclusions regarding certain points of interest. You might recall I listed out about 6 points of interest, and they included whether or not Mr. Reeves was hit with an object before the tossing of the popcorn, the relationship between the parties, the number of attacks, whether or not Mrs. Oulson was holding him back, was Mr. Oulson leaning or standing over, and whether or not Mr. Reeves uttered the words, throw popcorn. all of those points of interest were his analysis of that was solely based on the video. So when we start talking about, well, I determined this or I determined that, he could be interpreting the video, and there's no way around it. So my objection is that those points of interest, that's for the jury to decide based on the video. He can't come in and say, okay, my review of the video, Mrs. Oulson was or was not holding her husband back. See what I'm saying? So if he comes in and goes through those points of interest, relying solely on the video, well, that's for the jury to make the interpretation, not for the expert. You can understand the weight that would carry, and that's the problem that we have. So that was the thing with the video, not the running narrative. But if that in fact is proffered, or he does that analysis based solely on the video, then that's for their determination.
And that's not a problem, Your Honor. Our intent is not to have Dr. Bedard comment on what he saw in the video or make any kind of conclusion, base any kind of conclusion based on the video except for one. The only issue is going to be there is he's going to testify as to perception reaction time. And so the issue is going to be just the timing of the video. And I spoke to Mr. Martin. He's not opposed to this. You know, the question will be not did he watch the, you know, how long and all this stuff. I can give him time references and say between this time and this time was the firing of the firearm in response to the throwing of popcorn. And I think that Mr. Martin agreed with me on that yesterday. And that's the extent of his use of the video in terms of being able to testify to that. And that's all we're looking to use it for. Not that, oh, I saw, you know, from my view, I saw Mr. Oulson coming across the seat at 13:25:36. That we've shown that video. We put photographs in. And the court has seen it as well. You know, the first attack. He's not going to say there were 2 attacks and all that. If he's pushed, if somebody's going to ask him, well, how did you come up with this or that? Then you know, they're opening the door for him to say that. But I'm not eliciting that. That's not my purpose in having him testify.
What about that portion? I remember that portion pretty clearly, that, you know, the breakdown of how many seconds it takes to do this, or milliseconds, and
Yeah, we've had that testimony.
not here in the trial yet, have we? Where was I? If that,
No, we have not. And so to keep him from going as
That witness did it last time. Yeah, at the previous hearing. You're right.
Oh,
You're
okay.
right. It wasn't off.
Okay.
You're right.
in terms of having.
Look, that's alluded. I can handle that on cross.
Yeah, I'm just-
okay, so that part is okay. The frames from the popcorn toss to the shoot is what he's going to talk about, the timing.
The whole grabbing, all that.
Right.
And Mr. Martin has agreed that I can lead him to get him through that, so that we're giving him points of reference, so.
Okay, so
he
we don't
doesn't
go
run
beyond
astray
that.
of That's
Okay,
right. That's
okay.
all we're looking to do.
Right.
Okay, so that one's all right. So Dr. Bedard is not going to interpret the video.
Right, it's not gonna be like one of those civil police shooting cases where he's gonna say, I looked at the video and I saw this force being applied, or that sort of thing that you typically see in civil cases. That's not
Right,
what he's
I've
doing.
read some of his.
And frankly, if you ask him the question, he would refuse to do it because he understands it's the province of the jury in a criminal case, so he's not gonna do it.
Okay, go ahead.
The other issue was that based on his examination of the video, there's missing frames. There is no expertise on that. We've already had the testimony of experts, and so even if you would agree that he has the expertise to make that determination, it's cumulative. So I would object to that, and that was in his second deposition.
What about that?
Well, because I think the context of that again was, you know, you have one attack 12 seconds before the popcorn attack, or what turns out to be a popcorn attack. And so, you know, his hypothesis was potentially, well, I don't know what's happening there. Maybe the camera's not capturing something, but we know that maybe it is or maybe it isn't, because I heard that testimony. He's not going to testify in terms of what if that could be happening and this could be happening. You know what I mean? So the only time that would come up, the state asked him, well, you see nothing happening before that, it's just a popcorn, how can, I mean, they're not gonna ask that question. So I'm not, I know.
All
So
right.
I'm not gonna ask them, about missing frames. And that's, we've seen that there is there are parts of what happened missing because of the inadequacies of the temperament of the cameras and how they were set.
Okay,
So that's not a problem.
all
He
right.
also indicated in his second deposition that he has watched the video, and his interpretation of the video would be most consistent with what story Reeves has been telling. So to compare that to his statement in any way.
Right, I remember that.
That's not a problem. He answered the question that he was asked. It was elicited of him. And again, I'm not faulting the prosecutor. He's, in his words, bobbing for apples. I get all that, but that's not the intention. That's not proper. Dr. Bedard isn't going to testify to that. And again, because of his integrity, he wouldn't if you wanted him to.
Okay,
So that's not coming in.
all right, so that's not coming in.
He also speculated and interpreted what he did not see in the depot. And as an example, it's all in the first deposition, I learned that there's a lot we can't see, so it's hard to validate what Mr. Reeves says or invalidate it. He also says Oulson standing up and striking Reeves with something, perhaps a fist with a phone. We can't see any of that. And then at the previous hearing, Reeves testified to a segment of what I've heard. He says, I don't see that. So when we're looking at what Mr. Reeves said previously at previous hearings, and then on the video, he's commenting, interpreting, and either giving credibility or not credibility. So that's just improper for him to interpret the video and then say, well, I can either confirm or deny Mr. Reeves' statement. So I object to that.
And again, Judge,
He did a lot of that, as I recall. That was his method of validating things and,
Yeah, the null hypothesis.
Thank you.
Because those questions were asked of him. I know you want to read, maybe, the whole,
I
there were
did.
hours and hours of deposition.
I did. I read
And-
hours and hours of stuff.
I know. And so, Mr. Martin is very good at asking questions. There's various ways of asking the questions. So it became a almost a philosophical discussion between Dr. Bedard and Mr. Martin. And so he said those things, but again, it's not our intent to present him to say that he finds Curtis Reeves credible, or that he finds him credible because he can see it on the video. That's,
Okay.
that's obviously not for him to testify to. That's for the jury to
Okay.
look at and decide. So
All right,
he's not going to do
that's-
that.
That's, because that sort of dialogue did concern me as well, him commenting about Mr. Reeves, basically, in a nutshell, about Mr. Reeves' credibility.
And I understand.
And there was a lot of that.
And I wish the rules of evidence allowed me to do that, but I know they don't, Judge. You have to testify.
Okay.
Judge, the last thing regarding the video is this 6 to 8 second gap that you've heard that term used, throughout the trial so far. And what I'm objecting to is, again, he's commenting on what's not in the video. And this is the way he does it. And this is in the deposition. I don't think so. I would have, again, some of what's missing is the initial attack that Mr. Reeves described. That would have been a point of interest. It's still a point of interest, but it seems to be not captured. So again, he's going back and giving credibility to Mr. Reeves that 8 second gap, giving credibility and saying, yeah, believe Reeves, what's that? So again, it goes to the credibility, and so I would object to that. It goes on, it's just a personal opinion about all the things that may or may not occur, but that's the most important thing, because he specifically says, I believe Mr. Reeves.
And again, Judge, we're back to the missing frame things. I have my hypotheses of what occurred during those missing frames as well, but I know that certainly, if I were to testify, I couldn't do it, and I don't think that Dr. Bedard intends to do that. He's not going to talk about the missing frames. He's not going to hypothesize on what may or may not have occurred, or that he expected something to occur or not to have occurred during that time frame. So that's not a bone of contention here.
All right, so let me just clarify real quick about these missing frames. Are we talking about the blue and the black?
Yes, Your Honor.
Unrecorded.
Unrecorded
Right.
because there was no detection of movement.
Or because the sensors were set in the camera was pointed in such a way as not to detect movement. There are several reasons given as to why that.
But there's, all of
Sensitivity.
which are basically because it wasn't the greatest system in a short way of saying
system
it.
worked as it was designed.
But there's no indication that somehow, as I didn't hear anything from the expert witness about the missing frames. It's not like somebody came and altered it.
It was an unartful way for me to make that statement. I should have said the unrecorded.
Okay,
It's my fault.
thank you.
Right, and the expert explained that it's because of the sensitivity, the settings of the camera. The expert also testified, well, we'll never know what those are because we never got the hardware and all of that. But, that's what we're talking about,
Okay.
those unrecorded frames. I think
Okay.
the court's correct
Unrecorded
in
moments.
Judge, the next one is a little more complex.
Okay.
Because we're dealing with this self-report method to prize coping, self-efficacy. It's along the same lines as Dr. Cohen testified to. She even testified that that individuals will in fact make decisions based on what they know their limitations were, whether it be mental skills, physical skills. That's the way we go through life, and as we age, those parameters may differ, but our decisions are based on what we know about ourselves. So when we talk about self-efficacy, which is what Dr. Bedard wants to testify about, he read my section in Daubert about that and all the literature. Okay, I don't need to go into that, but here's the main point. First is cumulative to Dr. Cohen. Second is that in order for that to be admissible with an expert under 702, it has to be helpful to the juror. And this is what Dr. Bedard said in the second deposition on pages 28 through 30. Do you agree or disagree that it is common knowledge of adults, if you will, who have certain life experiences, that in making a decision that they will weigh their individual limitations in making the decision on how to complete a specific task? That's pretty common knowledge to everyone, isn't it? Yes, I think so. So we have a situation where we're putting on an expert who has acknowledged that he candidly says, yeah, that's basically everybody knows that. So that would be the cumulative would be the second. He's already acknowledged that it would not aid the jury. And then I'll get to the right page. We talk about the self-efficacy. He identified certain things, that Mr. Reeves knows. But again, he acknowledges, just like he did when we had a brief discussion about it, that this is all common knowledge. It's when you make a decision, we take it in our limitations. So I would suggest to the court that we not only have a cumulative argument, but we also have, as an expert, doesn't aid the jury. So I would suggest to the court that you consider that and whether or not he's going to go into this litany discussion about self-efficacy and decision-making process, go on and on, when we've already had one expert very succinctly say, yeah, that's the way it is, and now we're going to do it again? No, that's just cumulative. And he already admits, everybody knows.
All right. I remember much of Dr. Bedard's testimony about this. And there was definitely separate over and above, if you will, beyond what Dr. Cohen testified, more in the context of combat almost. You know, can I take him, or should I take him, or am I able to take him, or something along those lines. So what about that? What about Mr. Martin's objection?
Well, number one, you know, in terms of cumulative, it's not cumulative because it's definitely in a different context. Certainly, Dr. Cohen was brought up short of being able to put it into context. In terms of the objection, sounds like a Dauber-like objection that it wouldn't aid the jury because the person questioned saying that that's pretty common to everyone. But again, it's within context. We all know probably that if it's dark, it's more dangerous. We all know that if it's loud, we can't hear as well. If it's dark, we can't see as well. But what we don't understand is that put together, these factors can have different meaning to somebody who is trained properly. And that's where the whole risk assessment thing comes in, right? You have the threat assessment, so you identify the threat. Risk assessment dealing with human factors, and this is one of those human factors. So really it goes more to weight than admissibility, because really that's what we're talking about in Dauber. This isn't something that's so far within the realm of common knowledge. I mean, Dr. Bedard, I don't know what he thinks about the common person. What we tend to do in this profession as well, we tend to think that people know what we consider very simplistic ideas in our profession. For instance, objection. I see lawyers do it all the time. They'll come into court and they'll speak to prospective jurors as if they know what we're talking about. Some of them do, that's true, but not everyone. So just because his opinion at that time was, well, it's pretty common knowledge, we have to look at it in context. So I don't think, it's definitely not cumulative, it's in a different context. And secondly, it will aid the jury in understanding the concept, the human factors concept of risk assessment.
All right, so what you're saying is that you want him to testify about threat assessment and risk assessment in the context of someone who's been trained?
Yes, Your Honor.
All right, and
That's not this issue. I mean, training, I'm not talking about training, I'm talking about physical limitations and
okay,
self-efficacy.
but in the context of someone who has this training, that's what I'm getting at.
I'm sorry.
Because if not, then I tend to agree to some point that it is common knowledge. So, in other words, what I'm hoping to avoid is that you're not going to just regurgitate or have him repeat everything that Dr. Cohen indicated.
If I could address that, Your Honor?
Yes?
There's no amount of training that can change the infirmities that come with age. So it doesn't relate to training. It has nothing to do with training. We're going to get to this point in our lives and we make decisions based off where we are. That's not any type of professional training. It's apples and oranges.
Well, I'm speaking about what I've gleaned from Dr. Bedard's testimony, that's what he's indicating, that because of his training, he's going to react this way, or a police officer would react this way.
I think that's threat assessment. That's another area.
Well,
No, it's more, they kind of bleed over to each other. Threat assessment, you're looking at what's presented to you as a threat. Risk assessment, you're making a decision based on, in this case, your own limitations, whether that be physical, whether it be psychological, and physical includes not only being older, but not necessarily. I mean, that was Dr. Cohen's testimony. Physical assessment of oneself could be that I'm not that strong. I mean, I don't have to be 71 years old to know that if I'm a 92-pound weakling that I'm not going to be able to take somebody. So it doesn't necessarily have to do 100% with age. It has to do with size. There are a lot of different things. So, part of the training is you have to assess your situation, including your own limitations. So I think that, for that reason, put in context, the jury should be able to hear that. That's part of the the program that's being taught by Dr. Bedard.
All right, so let's keep it from not being cumulative to Dr. Cohen. And,
Right, well, we're not talking about, the aged in particular, we're just talking about physical limitation.
all right, and before you move on, Mr. Martin, before I forget, I remember multiple times an exchange between you and Dr. Bedard about what you would say, so you want to tell this jury this, and Dr. Bedard would say, I don't want to tell them anything. I'll say what I was asked. I'll answer what I was asked. Can we avoid that to some extent? Just
I don't know, because I don't know if I ever got to what he's going to be asked, because the analogy is I was bobbing for apples. I have no idea.
well, just rephrase. Is it your intention to testify if asked? Because it was clear to me what the dialogue and what the offense was in Dr. Bedard's eyes, that he took offense that you indicated he wanted to he wanted to tell the jury things. So
okay.
that I saw no less than 5 or 6 encounters like that in the reading, and we can't afford that type of banter. But I'm not trying to limit.
It's a depot, Your Honor.
I know, and I'm not trying to limit. Obviously, you have your strategy, and maybe that's part to raise the ire of the witness. I don't know, but let's try to not do it
I apologize.
multiple times.
I have no idea where the court's going with that. That's not going to come up in the courtroom. That's deposition. That's not proper cross. That's not any.
Right, because if he says something like that in the courtroom, he might not like the answer that
Yeah,
the
I'm not
witness
gonna
gives
say
him, so
that.
if he wants to say it, have at it.
Okay, maybe it was an awful way to try to figure out exactly what was going on, but that's not courtroom stuff.
All right. Well, that's what you want to tell the jury. You want to tell the jury. You want to tell the jury.
No, that's.
Okay. All right. Okay. Great. You need a break now?
When we're done with this,
Okay. I'll give you a break for sure.
Judge, one of the things when we were talking about the talking points and that did not relate to the video was that Mr. Bedard did in fact interview Mr. Reeves. And I don't know if they're going to attempt to get in it. There's a whole different argument.
We're
about
not, he's not talking about an interview with Mr. Reeves and his opinion based on that interview as to what occurred or didn't occur.
Okay.
This is not a forensic psychological examination of Mr.
Okay.
Reeves.
But one of the issues that came up that I'm concerned about, and I don't want to get blindsided on it without discussing it in court, is that for the first time, Mr. Reeves said, oh, by the way, I heard patrons in the theater say the words throw popcorn. Very first time that's ever come up. And so then Mr. Bedard goes through this litany of if he said that, and then he says basically, he goes into his reasoning about, well, that might make sense, that not make sense. See what I'm getting at? If we're not going to talk about anything about the devil, then this doesn't come in. If this is coming in, then we got a whole other argument. So
Are you talking about the part where he said, he comments on the statement you threw popcorn and how the timing of it?
No, Mr. Reeves says he heard patrons say that. He didn't say it. That's what he told Bedard.
Okay.
That's the first time that's ever been said. So I want to know if that's an issue that they're going to bring up, because it is, and we have other arguments.
Sounds like hearsay to me, but I
Well, it does to me too.
I didn't think of trying to get that in.
All right.
All right. Anything
I
else?
think it's a valid theory though, but I can't elicit it from Dr. Bedard.
Judge, there's the one about, he has a section of knowledge that we discussed dealing with people involved in a stressful situation and artifacts that may indicate and verify that the event was in fact stressful. You might recall that in the definition. We talked about artifacts. Those artifacts being reaction time, different perceptions, cognitive perception differences, television, remember he had a list of all those things. Then what he says is, and I asked him, well, did you see any of that, Mr. Reeves? And very candidly, he said no. He said, I didn't see a lot of this. As a matter of fact, the only thing I saw was some memory issues. I think that demonstrates that at some level, fragment memory also occurs under high arousal. But he also says that that he did not see any of those except maybe fragment memory that went to in the law enforcement manual, I don't recall. If he didn't see any of that, that's what he testified at the depot, then it's not relevant. You just don't put something before the jury and say A, B, C, and D when it doesn't apply to the defendant. So if it's a non-issue, why would we go through and educate the jury on something that doesn't exist in the case? So it's not relevant, and I would ask that that be excluded because Dr. Bedard very candidly said, I didn't see any of that.
So I'm trying to wrap my head around this. On the one hand, the prosecutor said, we can't use the interview because that's not legitimate to use in this sort of trial. It's not a forensic examination, my words, but we cannot use that interview. We can't say what Reeves said. Now they're saying, well, based on that interview, and again, we don't know how complete it was, we don't know exactly what questions were asked of Mr. Reeves, that somehow we're going to decide that these artifacts of stress, in other words, what happens when an individual is under stress, again, that Dr. Bedard not only trains others in, but has studied extensively, that he can't educate the jury on what these stressors are and what the manifestation of those stresses are. That makes absolutely no sense. The jury can decide if Mr. Reeves was under that stress or not, if he suffered some artifacts of stress, if they want, but certainly it's not irrelevant, it's relevant to the whole idea of human factors, the whole idea of risk assessment and making those choices. So, the jury can decide to apply or not. This would be different if the presentation was, these are the manifestations of stress, and these match up with ones that Reeves had or that he didn't have. We're not doing that. We're educating the jury on the use of force, the training of the use of force, and certain things that have been studied. Again, we're not going to cite studies. I know we can't cite studies, but in this individual's experience and his teaching that describe kind of the human condition under these situations. And I don't think that's out of bounds at all, especially since we can't say, well, Reeves didn't say this in his interview with Dr. Bedard, and so therefore it's irrelevant.
Okay, maybe I didn't artfully say that either. Dr. Bedard looked at the law enforcement statement and the prior hearing testimony, right? He also talked to him, that's true, but in using all of those, he did not find any of those artifacts. And if we go to the deposition that was taken on November 19th, it's basically page 101 through 104, where it's kind of lengthy. When I asked on page 103, okay, I want to turn to the residual effects that we've been talking about. And then on page 104, so the artifacts, when I usually look for them, and let me preface my answer by saying I didn't find a whole lot of artifacts. I guess I was surprised. And I think, partly during the deposition why I wanted to interview, and that's when he talked about that. He said, here's the problem with Reeves, and I can tell you, see, he knows all of these things. And I mean, if he wanted to fake it, he's aware of tunnel vision, he's aware of auditory exclusion, he's aware of, I can't pronounce those, vast audulation and vast constriction.
So he basically said, I didn't see any of it.
Well-
He never either in the law enforcement interview or at the previous immunity hearing, anywhere did he say anything that would suggest that he had television or narrowing reaction. So if he's done it, he's said everything, he talked to Reeves, looked at everything, and said, I don't see anything, except for the fragmented memory. And so it's not relevant.
And I don't know that if this prosecutor misspoke or not, but when he quoted the deposition, he said that what Dr. Bedard told him was, I don't see a whole lot of artifacts. In other words, he's not saying I didn't see any that was presented to the court. And frankly, if he's going by that interview, well, we know about the interview by now. It wasn't the greatest interview in the world. Probably Dr. Bedard, if he's asked, would tell you that when an officer is involved in a shooting, usually they wait a day because of these issues. So, you know, I don't see where the prosecutor's coming from in terms of not being able to at least
All
discuss
right,
stress.
from what I'm hearing, I'm going to overrule as to the artifacts of stress. Okay. We need to wrap this up.
Okay, so now we get to what I've been marching up and down, wearing out the carpet about. It's how we treat Mr. Reeves as, and dealing with the issues and decision-making. Is he a law enforcement officer or is he a civilian? And we're going to have the testimony from Dr. Bedard indicating that as a law enforcement instructor, he's aware of how law enforcement is taught. He's aware of the teaching tool known as a force matrix model or force continuum. And I know that might be a foreign concept to you, so may I approach, and I'll show counsel what I'm going to hand you. Because I think it's helpful.
We can do this.
Can I approach? Judge, there was a time when these type of models were prevalent in the public, in the agency's policy. I've had this discussion with Mr. Bedard, so I'm kind of parroting what he told me to. It's no longer in the basic recruit manual as of 2007, I believe is what he said. But they were used as a teaching aid. The court recalls that since 1989, law enforcement's use of force has been governed under the Fourth Amendment, under constitutional law. And so someone came up with an idea of how we're going to try to explain these concepts to law enforcement. Now we use simulators, we do a lot of other things, but back then, this is what came out. So what he has done, since when he teaches civilians, to help them understand certain parameters to give guidance, drawing the line in the sand, when you're going to shoot or not shoot, he uses these models. As an example, look, if A happens, you can respond this way. And you might be in pretty good shape. If B happens, you can respond this way. You'll probably be in pretty good. It's just a tool visually to help understand so people in their own minds can draw the line in the sand when they are or not going to use a particular type of force. It is not appropriate to use it to educate the jury. And the reason for that is the way he explains it is that the reasonableness of the action is linear. And you go straight across or up or down, whatever, and if you do A and B, that's reasonable. That's what he's going to tell the jury. And that is not the case. And you recall in my discussions in the pleading, we talked about even in Grant, where objective reasonableness is, you can't decide it in a mechanical way. And that's exactly what this attempts to do. And you can understand why agencies would do it. All right, they want to hold accountability somewhere for the officers or whatever, but that's not the court of law. Our jury instruction will be given 3.6 per F. You're going to give that to them, and in no way does that concept apply. It's a reasonable man standard. You just don't go, put pigeonhole it here, therefore this is it, and then you don't have to think about it. And that's where we get into the misleading part, when he starts talking about force continuums and matrix, because that's how he explains what is, and I know we're not going to talk about reasonable, but I don't know what's his testimony is going to be. So I don't know what's good, just like we've had some things come up that we didn't want. I have no idea. So I need to bring this to the court's attention that I object to any explanation whatsoever as to what's reasonable, how to determine what is something reasonable. He can go, look, these are factors for threat assessment, this is factors for situational awareness, here's all the information is, here's the facts, or whatever, but we don't pigeonhole it with this force matrix and continuum, because that's the way he likes to explain his testimony. So, Mr. Reeves isn't a police officer, he's not on duty. This isn't like the officer Potter with the taser and the gun. We're not in that situation. We have a civilian here. That doesn't apply. Of course, the Fourth Amendment doesn't apply to Mr. Reeves. We're nowhere near that. So all this would just be totally confusing to the jury when they get your final instruction. So I object to that as being how he explains how one decides how to respond to a certain response. Because if we look on his second deposition on pages 553 to 554, I assume about the subjectivity of it, and of course the one that can answer the question would be Reeves. I'm aware of what Reeves said, so taking Reeves as true, I would be able to comment on the subjectivity of it and put those behaviors of Mr. Oulson in categories of threat and show the straight line appropriate response. And that would be going back to the objectivity and hindsight. See what he wants to do? That is totally inappropriate. So I object to that.
But that's not what I want to do. Frankly, in terms of that portion of use of force from Dr. Bedard, it's going to be very similar to what the state elicited in the Draker trial. It's going to look a lot like that. There he drew what was essentially a force continuum on a piece of paper. He's going to probably do it on the whiteboard here. He didn't make any comments as to whether it was appropriate or not. And in fact, in this case, it's relevant because we got to remember that Curtis Reeves was a former police officer who was trained. So I think it's important that the jury understands his training in terms of talking about the Fourth Amendment or objective reasonableness or something. Those issues are not coming up. He's not here to tell the jury that's objectively reasonable under the standard for law enforcement. He's not going to say that it's subjectively reasonable for Mr. Reeves because of his training in law enforcement. That's not going to happen. He wants to be able to explain, number one, that there's certain categories of use of force, and number two, that there's certain levels of use of force. That's what he wants to show this jury.
So tell that Mr. Rosenwasser address that issue.
Yeah, the only reason that we brought, obviously I prosecuted the Draker case. So the only reason we brought it up was in the defendant's interview, he was using those terms. He was the one, meaning Draker used the terms force continuum and force multiplier. So Dr. Bedard was brought in just to explain those terms so the jury understood what possibly the defendant was referring to.
Mm-hmm.
The chart that was drawn was only because that's what the defendant was referring to. Now, in this case, you have the defendant, and the chart really wouldn't apply because if you're a police officer, you can one-up level to get compliance from someone, but a citizen can't do that. That's more law enforcement, which is then when you get the bleeding that Mr. Martin's been talking about, that we can't put Mr. Reeves in the position of a law enforcement officer that can, because law enforcement officer can draw someone down at gunpoint. Now, obviously, if a citizen does that, that's an aggravated assault. So you can't mix and match those two things because the defendant's not a police officer in this case, he's just a regular citizen, so that chart wouldn't apply in this case.
It's to show the jury, to get an idea of Mr. Reeves' training. And one of the issues we have here, frankly, Mr. Reeves was never asked. So let's say, using the state's example, let's say the detective questioned Mr. Reeves as to his knowledge of the force continuum. And then he says, yes, I'm aware of the force continuum. So now we get to use the expert because Mr. Reeves used those magic words to show that he either did or didn't know what the use. No, that doesn't make any sense. And I appreciate that the prosecutor is, it's creative to say that we're using it just to define these terms, but the court may have seen the testimony of Dr. Bedard or may not have. But frankly, he wasn't just up there to say, no, that's not what force continuum means. He got up there and drew a chart to show exactly what it meant. So it had a dual kind of effect on the jury, I'm sure, but we're doing it strictly for the purpose of educating the jury as to what law enforcement is taught by Dr. Roy Bedard, who is a police trainer.
Why does it matter what he's taught? Because you can't use that chart in civilian life. I mean, I don't disagree with the fact that they can say he's got law enforcement experience. But that and this issue are completely different.
Well, can't that be brought out on cross as opposed to excluding it altogether?
I mean, the reason that I would say not is because it really is, like, we all understand this because this is what we do for a living. I think for a lay person to understand that is going to be very difficult. And, for that reason, it really would be confusing. They don't understand force continuum, the chart, the difference between what police can do and what citizens can do. And we don't really need that mixing and matching because he's a civilian in a civilian case.
So if I understand that argument, it's confusing to give the jury information. It's not confusing. It's somehow more enlightening to tell the jury in this vacuum that Mr. Reeves was trained for all these years as a police officer, and although he's not being judged by the standards of a police officer, we can all agree that's certainly part of his belief as he was, and I know that the court heard a million times, standing in the shoes and sitting in the seat, but it's true. And so, that's why this is necessary, just to give them a glimpse of the, you can't just say, well, this person was a professional dressage jumper. Well, they may or may not even know what dressage jumper is, and certainly they might not know what it feels like to be on the back of a horse or to get the physical training or anything like that. So I just don't see how we cannot tell the jury about Mr. Reeves' education and give them a glimpse of what it is. We're not saying this means that Mr. Reeves acted. That's for argument. They can argue, and certainly they can cross-examine, as the court suggested. This is about gatekeeping, and certainly he's going to be there for cross-examination. If they have a problem with that, they can go after Dr. Bedard and say, hey, what you showed applies to police officers only, doesn't apply to civilians. Let's see how he answers it.
Well, I know it's going to end because civilians don't have a model. I adapt it and I tell civilians this is what the law is. That's what he's going to say because I've asked him in the depot. And I don't want that in front of the jury. So am I going to ask that question? No. So here's the problem, Judge. We're not saying he can't say, I know behavioral cues. I know reaction time. I know to keep my distance. I know. He can say all of those things, but when you take all those factors and then pigeonhole it in a chart and have him say straight line across, that's where the problem is. I'm not trying to prevent them from saying he doesn't know how to judge whether or not something is a threat based on his training. It's the chart that says if you do this and this, it is okay. That's where I have the problem. That's why the chart doesn't come in. That's why there's no mention whatsoever of force metric model or force continuum. They can talk all they want about all his behavior cues and how he knows when there's threat and all the things they look for. You just can't put it up there and say linear across, this is okay, because that's for the jury to decide.
And I don't think he says that it's okay in a linear fashion. He says this is what you're presented with. These are the decisions.
What's the relevance of the use of force continuum?
To show Mr. Reeves' education and part of his training.
And the matrix?
Just a way to explain it in a visual way to the jury that there are different categories of use of force and that there are different levels of use of force. I mean, that's essentially what it's being used for.
How is that relevant?
See, there is no national standard for civilians. So he is a civilian. So this is based on Fourth Amendment considerations. And contrary to what Mr. Michael says, clearly he said, Mr. Oulson, I would be able to put Mr. Oulson in categories of threat, different levels on the same, and show the straight line appropriate response. That is just totally wrong.
He's not asking to do that. We're not asking him to do that.
I agree, that's not proper. So, I'm gonna agree with State on that.
So tell me then what he can do. Certainly consider different levels of force.
I knew you were gonna ask that.
Well, I don't want them jumping up. I've only been able to say 3 words in 3 weeks here without them jumping up.
There is no level of force that are, quote, standardized for civilians. Therein lies the problem. What is unique between the law enforcement officers are the cues. How, if you look and saw A, B, and C in a person, posturing, leaning forward, aggressive, those are all common between civilian and law enforcement. They can go into all of that, that's fine. As far if you're going to take, if you look at, say, A, B, and C, then maybe you'd be aware and it would heighten your awareness and you would want to be more cautious. That's fine, but to say, okay, based on his training, he got this, and I'll call it archaic because it's not taught anymore, and it doesn't apply to civilians, and there's no national standard for civilians, then that's inappropriate because that's what he wants to do, straight lines. All the behavior cues are consistent.
Right, okay.
No straight line.
Right, so my question is, the court ruled no straight line. So I'm saying, can I say, are there various categories of use of force? Are there very levels? He won't draw a chart if that's what they don't want him to do, and he'll just say that, and we'll go into the cues and all those other things they talk about.
How is that relevant? Because you're going to go through the different levels. Okay, yeah, if I'm just mouthing off, it's non-aggressive. Okay, non-aggressive, then you can use a pepper spray. See where I'm going? The levels, no. We're getting back to the same thing. We're just orally describing the force matrix. The civilians have no levels. It's either reasonable or it's not reasonable based on their subjective perception of what they saw, period.
Of reasonableness of which civilian? A civilian who has no police training, or a civilian who is extensively trained in the police department? That's
All right, so there's got to be a happy medium here.
I'm sorry.
Go ahead.
Sorry. As of right now, we don't have really any evidence of his extensive training. The only evidence is in his taped statement. He just says he retired from the police department. There is no evidence, because the defendant hasn't testified, about some extensive amount of training. Zero.
Well, Your Honor, I think the court may remember there was a big motion regarding all the certificates and all of Mr. Reeves' achievements. So I think the court is well aware of his extensive training going all the way back to the late 60s. And so I don't know that.
I don't know that's an evidence. In fact, I know the answer is not an evidence.
You're absolutely correct. As we sit here right now in this trial, there is no evidence. That's correct.
Well, that sounds like an issue for later on, either argument that the evidence didn't come out, or the question of Bedard about what he knows.
Okay, so I'm going to glaze over that right now. The happy medium that I'm talking about is I believe that the defense is able to elicit testimony regarding how, police training. But that's about it. He can't project that over to Mr. Reeves and how he acted and why.
He's not going to. We just want to know the training. So is the court all right with me saying, we're going to hear about his extensive training of police forces from United Emirates all the way to Barbados and everywhere in between. And so I can ask him if he trains these police forces and various security forces in the field of use of force, right? I can do that. And he's going to say yes, right?
Is that to imply that because Curtis Reeves is a police officer, where Bedard trained him? I mean,
That's silly, but anyway, Judge.
well, right, but I'm saying, what was the point of what you just said?
Because he has he trains police officers.
Well,
Mr. Reeves is a 27-year police veteran. That's going to come out. The court can be assured. If it doesn't come out, then guess what? Now they have something to argue in closing. Why did they put this guy up here? He doesn't have anything to do with it. The same thing I argued in terms of opening. I shouldn't have argued, but I did argue a bit in opening in terms of, the prosecutor's opening statement. So, I mean,
It's funny because I brought it out, and then I'm trying not to make it personal, but Mr. Michaels then said that was silly, but he actually agreed that's what the argument was he was making. Bedard does all this training, Curtis Reeves is a police officer, they're trying to overlap the circles that now we know what kind of training Curtis Reeves has. We don't. There's no testimony or evidence at all, other than the fact he's retired police. That is completely all the evidence right now.
experts make opinions over information they're given every single day of the week. We had Dr. Foley in here earlier today giving his opinion over some x-rays that were presented to him. There was no evidence presented prior to this that he had arthritic knees or anything else. That evidence came in because that's an expert's opinion. So I don't see how. So now we're going to exclude. It sounds like what they're saying is we're going to exclude Dr. Bedard now, even though we have a court ruling that he can testify subject to evidentiary issues.
Judge, on this issue, I did discuss it with him, and he said, basically, I'll paraphrase a little bit, Bedard admits he does not know the law enforcement curriculum Reeves received at the Tampa Police Department. That's the first deposition, page 133, lines 18 through 20. Specifically, he does not know the curriculum Reeves received involving use of force or threat analysis. The first deposition, page 133, line 21 through 25. Bedard acknowledges in the 1970s, when Reeves received his law enforcement training, a standard curriculum was only in the developmental stage, and academies were free to develop their own curriculum. That's the first deposition, page 134, line 1 through 9. Bedard finally admits he does not know the specifics of Reeves' law enforcement training. Again, the first deposition, page 134, lines 15 through 19. In response to not knowing the specific of Reeves' training, he stated if Reeves was an instructor, he would know the material. But again, he doesn't know the curriculum of what that was. He candidly testified, I have no idea. So what he's saying is, okay, I have no idea what he was taught. And back then, there was no curriculum. Tampa PD, they had their own academies back in the 70s. St. Pete PD and the agency theater, we were at the Votech Center down in Pinellas County. So everyone had their own thing going. They could write whatever they want. So there's no way that Bedard knows exactly what training he received because nothing was standardized. Not until later on when we finally get FDLE involved and they write the curriculum. He admits he does not know the training of Mr. Reeves.
Which is wonderful for cross-examination, but not a legal reason to exclude this testimony. I have a good faith basis to ask Dr. Bedard, and he has a reason for his testimony, and so the state can certainly cross-examine him about that, and that's kind of where we're at. It's not a reason to exclude the evidence.
The good faith basis is the deposition where he says he didn't know?
The good faith basis, frankly, Your Honor, is knowing that my client has served 27 years at Tampa Police Department, that he's had training from the very beginning, that he's trained other officers, that he started the SWAT department, that he has extensive training in the use of force. He's trained men in the use of force. So that's my good faith basis, Your Honor.
If he testified and all that came out, maybe it's a different story.
That's different than good faith basis. He knows that.
There is none. There's no good faith basis. His good faith basis is because they know Curtis Reeves and they know his background. That's good faith. The witness doesn't know it.
Again, that's
That's a
cross-examination.
story. It's not cross-examination because he doesn't know it. I can't put it any simpler than that. He just doesn't know it. There's no foundation.
Back then, when he was doing all that, there was no standard curriculum. Tampa PD could do whatever.
So what are you
they want.
arguing now?
Huh?
What are you arguing now, that he can't testify at all?
No, he just can't testify to his police training because he doesn't know it.
It went back to that, we were talking about how the
matrix
matrix, and then they said, oh, I just won't draw the matrix. And we're like, no, it's all about the whole concept of the matrix. And that's how we went to, he should be able to testify to the matrix because he is a trained law enforcement officer. And then we segued into, there is no testimony about his training, and that Bedard doesn't know it at all.
That's not, I don't know where they got that from, and I'm sure the court feels like I do, I'm dizzy. I just said that Bedard's going to testify that he trains police officers in the subject of use of force. Right? He's not going to draw a matrix. So that's how this whole thing started. I think that he can testify to that.
All right, the matrix is definitely not appropriate, I think. No chart.
No levels. I mean, we're getting visualization of the chart.
Yeah, the levels are, with the argument that I've got before me, I think the levels are not appropriate either in light of the fact that it appears from prior testimony that Dr. Bedard is not aware of what Mr. Reeves' training is, or that in the years that Mr. Reeves was trained, this wasn't applicable. So I think it's irrelevant.
Well, can I have Dr. Bedard interview Mr. Reeves right now if you give us a 10-minute recess so that he has that knowledge, Your Honor? Because frankly, I mean, I don't understand the state's argument. I don't understand it.
Well, how does that solve the situation? It still doesn't reverse your rulings at all as far as orally talking about levels and responses and matrix. It doesn't matter.
It's really just back to running the defendant's testimony.
What I'm looking at in this chart is stuff that, if this is what Mr. Reeves taught and used every day, might have some relevance. However, the relevance is tempered with the fact that he retired 20 years ago, plus. So, but the fact that we don't know that he was trained in this and that he used this and this is like riding a bike to him, then I don't see the relevance. So
Then I can ask this, Your Honor. You know, I know, that he trains police agencies, police officers in the use of force, right? That Roy Bedard does. And part of his training involves something called a force matrix, a force continuum. And he says yes, and then I move on and we talk about other things. Just so later on, should we have the testimony to back that up, now we can link it up, and at least we've had Dr. Bedard say, yes, he teaches that.
We're back to, it doesn't apply to civilians. This is a tool to teach law enforcement.
all right, I got that. That can come out in cross. I'm going to allow that limited area of questioning regarding the continuum and the matrix under the circumstances. And then you can ask, clearly that doesn't apply to civilians. So I'm done. We're done. We're done talking about this.
That's what,
It's been over an hour, and we're getting nowhere fast. So that's that. All right. Done, right? We're done, that's it?
you told me I was done. I'm not saying.
What else do you have, Mr. Martin? What other objections?
Not objections. I know what his response is going to be because, yeah, it does, because there's no standard model for civilians, so we use this. So I'm not going to be able to ask that question. I'm not answering that question.
All right,
So that
then that's fine.
That's his answer.
Okay,
So
Okay.
It's just not helpful.
I think the court's asking if Mr. Martin has any further objections other than the ones we've already spoken about. Do I have that right?
Correct.
Okay.
All right, then let's take 10 minutes ourselves quickly, a fast 10 minutes.
Well, Judge, after these rulings, I need some time to
I
be able to
know.
sit down with Dr. Bedard. I don't want, something to happen that shouldn't happen.
Well, don't sit down, just stand and tell them. How about that? Let's get that straight. And obviously, we're not going to finish with Dr. Bedard today, but we're certainly not quitting at 4 o'clock.
Judge, can I, on another note, just real quickly introduce the actual pictures that, from the thumb drive? Remember I told you I would introduce the
Yes.
thumb drive?
Yes.
And so this is just VD1.
Okay. Good enough.
That's an easy one.
That's an easy one.
VD1.
seated, thank you.
Thank you, everyone, you may be seated.
All right, are we ready? I'll take that as a yes. Okay.
You're in the courtroom, Your Honor. Jurors may be seated. All jurors are present and accounted for, Your Honor.
Thank you, Deputy. Ladies and gentlemen, were you all able to abide by my instructions during the recess? Thank you. Thank you for returning. We're ready to begin.
Thank you, Your Honor. The defense calls Dr. Roy Bedard.
Please come this way for me, all the way around this way for me, okay?
Stand right here, raise your right hand and face the clerk, please.
Do you solemnly swear or affirm that the testimony you shall give in this call shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Go ahead, Mr. Michaels.
Please state your name.
Roy Bedard,
Spell your last name, please.
Bedard.
And what is your current profession?
I am a law enforcement trainer.
And how long have you been a law enforcement trainer?
Oh, I think 35 years.
And we're going to get into that a little bit more. Let's go over your education. I called you doctor, so you have a PhD?
I do.
And where's that from?
It is from Florida State University.
And what is your PhD in?
Educational psychology. My major is sports psychology.
And what was your dissertation?
It was on decision-making under pressure specific to law enforcement officers.
Now, you have a bachelor's degree from where?
Also Florida State University.
Okay. And I see an MSc degree?
My master's is also from Florida State University.
And what's your master's in?
Also in educational psychology.
Okay, now you listed on your CV something called Lively Law Enforcement Academy. What's a Lively Law Enforcement Academy?
So it doesn't exist anymore. When I went to the police academy, it was run by a vocational school called Lively. And the Law Enforcement Academy was one of the divisions and curriculum of that vocational school.
Okay, so let's talk about police academy. So were you a police officer?
Yes.
Tell me about your history as a police officer.
I began as a police officer in 1987. I worked for the Florida State University Police Department. I moved to the Tallahassee Police Department in 1990 and continued in full-time service until 1996. I went into the reserve status in 1996 and continued with the Tallahassee Police Department until 2015. I retired from the agency, and then in 2019, I believe, I became an administrative reserve for the Tallahassee Community College Police Department.
Okay. And so you're still active in that particular role?
Yes.
Now let's talk about this Lively Law Enforcement Academy. There were certain affiliations you had with that academy. For instance, I see one that says CJSTC. What does that mean?
So in the state of Florida, the Florida Department of Law Enforcement commissions a group of commissioners to govern criminal justice. So the CJSTC is the Criminal Justice Standards and Training Commission that writes curriculum and otherwise interacts with basic level students, as well as agencies for in-service requirements. So they sort of oversee law enforcement. They also issue the standards by which law enforcement officers are permitted to be employed.
And when you say curriculum, are you talking about manuals, books, that sort of thing?
Yes.
And you were an instructor?
Yes.
Okay, so at the Lively Law Enforcement Academy, you were instructor?
Yes.
Now, you also instructed CJSTC as a general topics instructor,
Yes.
as a firearms instructor.
Yes.
You also instructed in the field of advanced injury and death investigations, correct?
Correct.
There's several more that include interviews and interrogations, is that right?
Yes.
And a handful more. Now, tell me about the Florida Criminal Justice Executive Institute. What's that?
The Florida Criminal Justice Executive Institute is also run by FDLE, and it is a executive institute that mostly does advanced and specialized training to administrations, to executives within law enforcement.
Okay. And were you an instructor there?
Yes.
And so one of the things you instructed, I see elder abuse investigation. Tell me about that.
That actually was a class that I took from that. I did not teach that one. It was precisely as the title says. It was about investigating elder abuse.
All right, so that was a class you took there.
Yes.
Now, you currently, in addition to being consultant, do you own a marketing business as well?
I do.
Tell me about that.
I have a company that is called Rapid Rotation Baton. It has a flagship product that is a police baton with a specialized holster. I also make other types of equipment, including handcuffs and other holsters and belt systems and things like that that police officers, correctional officers, and military folks wear. The corporation is a DBA, RRB Systems International, which is the DBA for Rapid Rotation Baton, which is what I mostly consult under.
Okay, now, you're a consultant, so prosecutor always likes to ask, so let me ask you, are you getting paid for your time here by the defense?
Yes.
And how much are you getting paid per hour?
$300.
Okay. And let me ask you this, we're going to get there, but you testified as an expert for the state of Florida, right?
I have.
Not too long ago.
That's true.
This same very office.
Yes.
In fact, one of the prosecutors that's here was involved in that case.
Correct.
And did you charge the state of Florida for your services?
I did.
And what was your fee?
Same fee.
Now, let me look at some of your other experience. I see 2005 to present, Lazarus Mining LLC. Tell me about that.
This was a mining corporation. I was hired to provide consultation and actually boots on the ground services for in terms of their security. It was actually in not the city of, but the country of Colombia. It was a alluvial mining operation.
And so they requested your expertise?
Yes.
In what, training, security? Tell me what you did there.
Actually involved in setting up a security system, which did involve training as well as various security analysis of that particular area.
And was that to protect the assets as well as the individuals working
Exactly.
there? Now, you have a title in your CV called Achievements and Titles. So when I see subject matter expert in instructor techniques assigned to reviewing and updating state general instructor training curriculum for FDLE, what does that mean?
So the Florida Department of Law Enforcement Criminal Justice Standards and Training Commission assembles a group of subject matter experts from throughout the state of Florida who sit together and design curriculum. At times they update curriculum, and it's an ongoing process, a work in progress. And I am one of the identified subject matter experts for the state of Florida for developing police and corrections curriculum.
Okay, and so that's general instructor training. What about this? I see same FDLE subject matter expert assigned to updating state defense tactics curriculum and state instructor defensive tactics. Same sort of thing, helping?
It is. There's been many iterations. I've been doing this since the 90s, and so as the state either updates or sometimes completely tears down and redesigns courses, I'm often called for assistance with those projects.
And it looks like those are from 2014, 2013. You have several more instances where you were tasked with aiding Florida Department of Law Enforcement in creating and updating curriculum. Is that correct?
That is correct.
I see one from 1999 to 2003, FDLE again, Florida Department of Law Enforcement, subject matter expert in defense tactics. So again, you were assigned to drafting state defensive tactics curriculum and state instructor curriculum. Similar sort of thing?
Yes, that was under what we called a CMS curriculum maintenance system that was used back in the late 90s and early 2000s.
And part of your consultation career has not only to do with being a consultant for litigants in court, whether it be an accused in a criminal trial or the prosecution in a criminal trial or civil litigants. In addition to that, you also did some instruction and consultation and presentation internationally. Is that fair to say?
Yes.
And I see you've listed, there are several listed on your CV here. Internationally, I see 2019 Dubai Police Department in the United Arab Emirates, non-lethal technology for law enforcement. You're a presenter.
Yes.
Now, how do you end up in the United Arab Emirates?
I work with particular equipment, and oftentimes if there's an order on that equipment, for example, with that one, it was the pepper ball system, I wrote that training manual. So I went and presented it to them in a course that involved field applications.
And I see you presented in Spain, Poland, the Virgin Islands, Israel, Colombia, Madrid, Brazil, Germany, and Scotland. Also, Jamaica, St. Martin, and England. So you've been around the world, have you not, in terms of sharing your expertise and training people?
I have.
Now, you also trained here nationally as well, right? Locally
Yes.
and nationally. So let's look at some of these. 2018 Allied Universal Security Services. You were the curriculum writer for Use of Force and Defensive Tactics program for the largest private security provider in North America.
That's correct.
Tell me about that.
So there's a large corporation that employs many different security officers throughout the United States and abroad. And their Use of Force and Defensive Tactics program, I was commissioned to write that for them.
Okay, and in your notes here, you have between 150,000 employees and over 20,000 sites.
Yes.
You've also been a lecturer at the FBI National Academy graduate meeting, right?
Yes,
Daytona Beach, there you lectured on Stand Your Ground.
that's correct.
You also did a Florida High Liability Police Trainers Conference for the Florida Public Safety Institute. What's the Florida Public Safety Institute?
So that is a organization that is now at the Pat Thomas Law Enforcement Academy in that same location in the city of Tallahassee. And the Florida Public Safety Institute is providing services to law enforcement agencies throughout the state of Florida, as well as other states that may come do training in that area.
Okay. You've also presented to the Florida High Liability Police Trainers Conference, Investigating Stand Your Ground, a presenter there as well.
Yes.
Now, I see Florida Public Safety Institute. That's up in North Florida.
Yes, that was the one we just talked about. That is there in Tallahassee. It's actually in a city called Havana, but it's just at the outskirts of Tallahassee.
And I think up there, because I went to school there, they call it Havana.
That may be so.
Now, that says lead instructor, FDLE, CGSTC, Defensive Tactics Instructor course. What's that?
To be a defensive tactics instructor in the state of Florida, you have to go through a course called the Florida Defensive Tactics Instructor course. Now, I've both obviously been through that course, and I am certified by the CGSTC as an instructor, but I've also provided that course in many different occasions.
Okay. And you also educate, for instance, the Public Defender's Office.
Yes.
Looks like in Fort Myers, self-defense and combat stress.
Correct.
You also spoke to these lawyers in 2012 in Naples, Florida Public Defender's Office. You were a presenter for the self-defense, defense, stand your ground, and castle doctrine.
Yes.
These are all pages of when you presented and some of the instruction you provided, so I'm just looking through them. We went through the the fact that it was international as well as national. So it was not only in Florida, you also have conferences in St. Louis, for instance, all throughout the U.S.
That is correct.
I see something that says karate competition resume. So tell me, were you involved in the martial arts?
I was, for most of my life, still am.
Okay. Tell us about your competitive career in the martial arts.
My competitive career, when I was 18, I earned a place on the United States karate team and began traveling with that team throughout various parts of the world, competing in various competitions. And I think I have those listed as well.
And in this case, you also, I should say on your CV, you've also listed some publications and productions that you've been involved in. Publications, you mentioned your dissertation already. I'm looking at one that says Florida Criminal Justice Standards and Training Commission. That's that FCJSTC we've been looking at, right?
That's correct.
And it says Instructor Curriculum, Defensive Tactics, Use of Force, and Survival Stress. Tell me about that. What did you do there?
Again, this is the curriculum that every police officer in the state of Florida and correctional officer has to go through to be able to get their police standards. So I was on the subject matter expert team in writing that curriculum.
Okay. Now, you've helped write the training manual for ground defense for FDLE.
Yes, you're talking about the ground fight course?
Yes.
Yes, that was a corporate course. I have presented it throughout the United States.
Okay. Now, you have been qualified previously, have you not, in the field of use of force,
Yes,
defense tactics,
yes,
human factors,
yes,
okay, among others, right?
yes,
And have you testified in state and federal courts?
I have.
And both for both sides?
Yes,
Now, let's talk about use of force. Use of force is something that you train police officers on.
yes,
Both police officers that have experienced police officers.
yes,
Do you also train, for instance, I don't know if rookies is the right word, what do you call it when you're recruits?
recruits, yes.
And in fact, right now, did you come here breaking away from some training you were providing somewhere else?
Yes, in Seminole County.
What were you doing there?
I'm teaching actually a legal course to what we call a crossover class. These are officers that are currently in corrections but are crossing over to get their license for law enforcement.
Now, let's talk first about this, the subject of use of force. Can you give me a three-word definition for use of force?
A three-word definition for use of force?
Yes.
Oh, I don't know about that, how complete it will be. It is the philosophical underpinnings of force. I used for.
Okay. Maybe it's a clumsy. Is it response to threat?
It is response to threat, yes.
All right. Now let's talk about. You've already established that that's something that you teach police agencies. You teach civilians as well.
Yes.
Now, that use of force, does it always involve the firearm?
No,
Okay. So could it be something other than a firearm?
it can. There are a lot of different tools that can be used by individuals to defend themselves.
Okay. So it could be a weapon
Yes,
of some sort other than a firearm,
yes,
or some other object,
yes,
and it may be even a fist.
yes.
Okay. Now, let's talk about use of force. So there's use of force. There's a kind of a threat assessment involved in the use of force. Is that true, or do I have that wrong?
No, you're correct.
So tell me what that means. You know, without going into any sort of model or explanation, aside from what does threat assessment mean?
Threat assessment occurs with individuals who are situationally aware. Anytime that you are in any given location, you're monitoring for danger. It's a natural human instinct to constantly monitor for danger. And if something happens in an environment in which a danger signal is noted by an individual, they will begin the threat assessment to determine what level of threat that would be. and it would offer a variety of different cognitive features, in fact, even some physiological features, if the challenge perhaps turns into a specific threat.
Okay. And without commenting on what a proper response may or may not be, when you say certain cognitive, would you use cognitive?
Yeah, some cognitive features. I mean, things.
Tell me about some of those cognitive features.
Well, for example, strategy. Like if you feel that there's a threat in the environment, what is the strategic best thing to do at that particular moment? That is a rational determination of what is my appropriate response to the threat that I happen to perceive or the challenge that I happen to perceive. And those are different things, challenge and threat. If you, for example, are very close to someone who you think is a threat, a positive cognitive reaction would be to create more distance, for example, or it may be to raise your hands up to protect the vital areas of your body, including your head, your throat, accordingly. So those are features that are taught, they're learned. In some cases, they may even be slightly instinctual. I think we do draw these things from our instincts, and then we codify them in coursework.
And you said certain physiological features?
There are a lot of physiological features as a challenge evolves to a threat. And the basic distinction is when you have a challenge, the assumption is you have the proper coping mechanisms for dealing with it. And those coping mechanisms may be environmental, they may be weapons-oriented, they may be the way you talk to somebody, perhaps in a form of what's known as de-escalation. But when those features are overcome and the challenge evolves to where you no longer have the coping mechanisms, for example, the attack has started, and you're not able to avoid the attack, to run from it, to perhaps even fight it because maybe there's differences in size or difference in the availability of weapons or things like that, then that challenge becomes a threat. And when the threat occurs, there are physiological features that start to happen as part of our natural system for self-protection.
And so before we get there, let me go back so I can understand how it progresses. The situation progresses from situational awareness, which means, correct me if I'm wrong, that kind of what it sounds like. You're aware of where you're at, your surroundings.
Right, that's correct.
And somehow just being there with another individual or something else in the environment that could cause a threat.
That would be your threat assessment. When you identify a threat, of course, we are very visual creatures. Most of the information we gather from the environment comes from our vision. So as we're situationally aware, we're paying attention to different things in the environment that may be harmful to us. If we start to attend to a particular thing and identify it as a threat, then we go into threat assessment. For example,
how do we identify something as a threat with our situational awareness? What are some of the cues? What are some of the things that we should look for?
Well, sights and sounds, for sure. I mean, for example, if you step out into the street and you hear the rev of a motor, your threat assessment would perhaps be to get out of the street. So you can hear certain features in the environment, you can see certain features in the environment that would dictate to you that there is an appropriate response to try to avoid danger. For example, moving close to something. When a rattlesnake shakes its tail, it's usually good advice to step back away from that. So that would be a threat assessment, and it would be a reaction to that threat by trying to minimize the chance of harm.
Okay. And when you talk about a physiological aspect, the physiological aspect of this threat assessment, tell me what you mean by that.
I think a lot of times when you teach use of force in defensive tactics, there's a tendency to think that everything is rational, everything is cognitive, and we're capable of thinking about things as if we were sitting at a desk, perhaps learning about it. But in the real world, to use a cliche, there are other things that are happening. There are things that are happening physiologically, chemical and electrical signals that are reacting to your environment as well, things that you don't have control over, often referred to as the fight-flight syndrome. This syndrome changes the way you perceive things. It changes your abilities, your competencies. It can shunt blood from one part of your body to another part of your body. It changes the way you see. It can generate things like tunnel vision. It can even turn off your ears, something we call auditory exclusion.
And those are kind of artifacts of stress, and I'm going to talk to you a little bit when we talk to human factors, but those are the kind of things that we're talking about. And as I'm talking to you, I can understand that threat assessment kind of boils over into risk assessment. They go hand in hand. Do I have that right?
They do. So once you identify your threat and you start to make cognitive features about that, then you have to do a risk assessment to determine what your best course of action will be.
Okay. Now, when you're identifying a threat, you talked about environment. So, for instance, do you train that? And it almost sounds like we should know this, but certainly, do you train regarding the light available to assess what is a threat now?
Yes, again, being visual creatures like we are, light is critically important to being able to make an accurate determination of what a threat is.
And so when you say an accurate determination of what a threat is, does that mean, at least at this level, trying to determine what the appropriate response is?
Yes.
Now, so when we're talking about light and darkness, you said because we're visual. Tell me about that. Why is a dark situation potentially presents more of a threat if there's another individual that now is becoming a threat? How does that cause that to be more of an acute threat or more of a threat?
Well, at the most extreme with light conditions, if you can't see it, certainly it doesn't figure into your threat assessment. So if it's incredibly dark, for example, you may not see something that is very harmful, and you may not know to do anything about it. As the light improves, you may still have an impoverished view. You may not be able to see things clearly. But for example, somebody who uses a training firearm, it could be painted blue. You wouldn't be able to tell if you were, for example, a police officer pulling up on two people playing with blue firearms, whether or not they were actual firearms or not, because the blue color is only available to you when it's light outside. So as light starts to improve, so too does our acuity, our ability to actually determine what something is, what it means, and it will figure into our risk assessment, our threat assessment appropriately. We do have what are known as mistake of fact. These mistakes are usually when we either don't have enough time to see something or we're seeing something in an impoverished way. We don't have a full picture of it.
And that doesn't mean the person was wrong in what they were thinking, right?
No.
And let me ask you this. So we talked about dark, pitch black. That's an easy one. You can't see it. It's more of a dangerous situation, to use a layman's
That is
term.
correct.
As it gets a little more, as there becomes more light in the environment, if it's dim light, does that still affect one's ability to perceive danger and to properly assess the threat? Or to assess the threat?
It can. I mean, obviously in police work we have tools to make adjustments, for example, flashlights, but of course that's not always the case when you're dealing with, for example, a civilian set who may not run around with a flashlight. So we try to mitigate the problem as best that we can. But anytime you don't have a complete visual picture of something, it could be said that you don't fully understand it.
Okay, so a police officer has a flashlight. Are they taught, well, if you're not sure, if you can't really see or it's dim, go ahead and light them up if you can?
Yes.
Now, you talked about the idea of, using your senses to do this kind of risk assessment. What about hearing? How does that affect your ability to assess the threat or to perceive a threat?
Well, hearing is interesting because it's probably a earliest of our evolutionary features. We tend to hear things oftentimes before we see them. We can hear things at great distances and usually only see things as they get much closer to us. So our hearing tends to be a little bit more acute, especially when you're dealing with things like reaction time. There's been many studies that show that reaction time is faster when it's auditory.
Approach. And Dr. Bedard, could you slow down just a little
I'm
bit?
sorry.
You're probably killing the court reporter.
Okay. Matt?
Go ahead.
We were talking about how the sense of hearing could affect the perception reaction time, and so I don't want to know what studies said. I know that you have a great deal of experience in this field, that you have a great deal of education in this field, that you educate others in this field. So tell me, from your knowledge, how does that affect perception reaction time?
Well, of course, word choice matters. If you can't hear proper word choice, you might not understand a threat in the way that it was intended. There's tone, there's inflection, there's loudness that has to do a lot of times with threat assessment. It's often said that in threat assessment that all creatures will, when threatened, become bigger, they'll get louder, and they will turn colors. And of course, humans are no different. We tend to do that. We pull our shoulders back, we start to holler, and we oftentimes will turn red. So those threat assessments are part and parcel of the risk assessment. What do I do now? And so when you have somebody who's standing in the dark, for example, and perhaps there is some type of a problem with your ability to hear what they're saying, you can't fully understand the threat, and oftentimes these, what we refer to as dymatic threats, where somebody's hollering at you, for example, doesn't really hurt you, but it speaks volumes about what perhaps is coming next. And if you can't focus on those dymatic threats because you simply can't hear them, you will not be able to make an appropriate evaluation of what that threat is.
And what we're talking about now, up to now, that's something you teach. Is that something you teach in police academies?
Yes.
And is that something you instruct civilians on?
Yes.
Now, you talked about the auditory and the visual. When we talked about environment, because you said the first step is environment. And so environment obviously includes the senses that we're talking about. And does it also include the place that this takes place? And what I'm getting at is this. Is it part of threat assessment to take as a cue of a threat or a potential threat behavior that would be out of the ordinary in a certain situation or environment? For instance, if somebody came down the aisle, sat in the front row of court, and jumped up and started yelling, would that start your threat assessment of that individual?
Yes.
And why is that?
Because everything has a baseline. So, for example, if you walked into a church and somebody was jumping around and acting differently than the rest of the otherwise quiet church members, that would be a violation of the baseline. You would attend to that and try to figure out what that meant. To the contrary, if you walked into a club and everybody was really quiet, you would wonder what was going on under that circumstance. So baselines are contextual. And when you're dealing with the context of an environment, you're mindful of those baselines. And what calls your attention normally to things as part of your threat assessment is that something is out of the baseline.
Now, we talked about environment, so that's kind of bigger, macro. Let's micro it a little bit. Does it matter one's proximity to a threat?
Yes.
Okay, and tell me why that's important, how close you are.
Proximity, in terms of the angles that you stand at, for example, affording yourself an escape route, those are proximate decisions that have to be made as part of your threat assessment. But also the nature of how close you are to somebody, which is, I think, how you concluded your question to me, will matter because of reaction time.
And so do you look at kind of nonverbal cues to make that threat assessment?
Verbal and nonverbal, yes.
This is what I'm getting at. I see a lot of police reports, and the police officer will say, well, he was blading.
Right.
What does that mean?
Blading is a bit of a pugilistic or fighting posture that somebody might take by placing one leg back and leaving the other leg a little bit closer to you. This is typically done in fighting as a preparatory stance, and it also is to minimize target area.
Okay. And so that would be a threat, even though there have been no blows thrown.
Yes, that would be what we would call a pre-fight cue.
Okay. Now, what other cues are we looking for in that environment? So we have a close proximity. We have someplace that is not well lighted. We have some sort of auditory interference.
Excuse me, Judge, I'm going to object to the summing up of testimony. I think this is the second, if not the third time, so I'm going to object to it.
I mean, I can approach if you want. It's not, I could say that if this, that, and that, and that, then ask the question.
All right, I'm going to overrule.
All right.
No objection.
Do those cues, are they cumulative? In other words, the more you have, does it add up to make the situation more of a threat?
Yeah, we would call it the totality of the circumstances, and they are cumulative. When you start adding them together, they're more meaningful than when you take them individually.
So tell me, when you say totality of the circumstances, I kind of know what it means. Tell me what it means in the context of what you instruct police officers, soon-to-be police officers, and civilians. What do you mean by totality of the circumstances as it relates to this idea of threat assessment?
So it encompasses everything that you've talked about so far. What is your environment? For example, it's not a good idea to fight on a slippery floor or perhaps a gravelly floor. You want to have better traction, so you'd want to take note of that. If you're about to engage somebody, it has to do with the lighting conditions, whether or not you're capable of seeing. If you have a tool to your avail, for example, a flashlight, you would probably use that. If you don't, you may choose that this is not the best time to go down that dark alley. There are circumstances about vision. As I said, there may be a case of where an individual is partially hidden and you can't quite see what they're doing, and so that would figure into your threat assessment as well. And then there are also individual features, what we call subject factors, like, for example, how old are you and how capable of you are fighting? Are you bigger than the person? Do you have martial arts experience? Do you have a weapon on you? All of those kind of things would be taken into account when you're trying to examine whether or not this is merely a challenge for which you have the appropriate coping mechanisms, or it is a threat for which your coping mechanisms are now exceeded.
And when you say that, these things this is part of the totality of the circumstances. In other words, that applies to able-bodied people as well as people that are invalids.
Yes, they're just in a different place in their evaluation. I mean, depending on what, as I said, your individual features are, you would perceive things very differently. You could have two people standing shoulder to shoulder viewing the exact same thing and would assess that threat very differently.
And that's sort of on the risk assessment side that we're going to get to. Would you agree with me?
Yes.
They're definitely related, but it's more properly in that section.
Yes.
All right. Now, one of the things that's interesting that you talked about, well, if you're capable, if you know martial arts. Now, I know that you do. And so I know that I don't. And so if you got close to me and I perceived you as a threat, I would be very threatened. You not knowing me or whether I knew martial arts, you know martial arts, so you probably think you can handle yourself. What I'm asking you now is, if there's an individual that you don't know anything about them, how does that factor into this threat assessment? In other words, all these things we talked about, darkness, out of place behavior, close proximity. So if you don't know anything about this person, does that make this person less of a threat, more of a threat, or still a threat because of the totality?
I think more of a threat. I think, if the attack is on, now we're talking about threat assessment in the course of an advancing threat, you generally assume the worst. And you don't know, for example, if this person, whether they know martial arts or they don't, or they're bigger or smaller, might possess a firearm, which would, of course, be the great equalizer. So you would want to consider the worst case scenario. You'd want to watch the hands, for example, and make sure that they aren't reaching for things perhaps that are now concealed to you that can be taken out in an instant and cause great harm. So yes, for sure, the evaluation of all of those circumstances under threat are going to make you assume the very worst and to prepare for the very worst. Sometimes that preparation may be running away if you have an outlet. Other times it may be that you're forced to engage because there's nowhere else to go.
Okay. And you talked about martial arts, and I know your background in martial arts. So I guess you know the answer to this question. Can a fist cause
an injury worse than a bruise?
Oh, yes.
Can it cause a laceration?
Yes.
A cut, in other words, how about a broken bone?
Yes.
Can a fist kill?
Yes.
And does one necessarily have to be trained in martial arts to be able to inflict those sort of injuries on another person?
No.
The risk assessment, what does that mean?
Risk assessment is really trying to determine what the risks are regarding the actions you're about to take or that you feel that you've settled on. And so there are other things that we started to talk about that need to be taken into consideration. For example, maybe I decide to engage in a fight because I'm left with no other options. Can I take you? Am I capable of actually prevailing if the two of us were to engage in a fight? I'd want to look at how big you are. I'd want to look at how big I am. I'd want to take a look at perhaps your apparent knowledge of fighting versus what I know about myself. I'd want to think about things like injuries. If I have an existing injury, or sometimes the injuries are temporal. For example, let's say we start fighting and you throw me to the ground and I break my arm. I'm certainly not the same person that I was just a moment ago. Now I may choose that I'll disengage from the fight and run away because I don't have that same competency that I had just seconds before. So all of those features that are not only intact, like for example, your age, your size, but are also temporal, like for example, your fitness level and your injury level at the moment have to be weighed into the risk as to how you will proceed with the very next step.
So once you've determined, based on the totality of the circumstance that we talked about, that a threat is present, now we're doing a risk assessment, as I understand it, correct me if I'm wrong, we're doing a risk assessment to determine what the appropriate next step is.
Right, what your next course of action will be that will result in the best outcome for you.
Now, when you talked about, you gave that example about, well, you know martial arts, and so you're aware of what your capabilities are.
That's correct.
You also said something to the effect of, you also may know what your limitations are. For instance, yes, I know martial arts, but I wrecked my shoulder in the gym or something like that, so I know I have some weaknesses. So is that what's called self-efficacy?
Yes.
What does that mean?
Self-efficacy, is the belief that you are capable of handling a task or not, and to what degree you're capable of handling that task. So people have a certain feeling about themselves when they take on any task, not just fighting, but any task, whether you're going to climb the big mountain or you're going to go on the bicycle race or any other, for example, sporting event. There's always a level of self-efficacy that should be improved if you're going to engage. And if you're not capable of improving it, you are at a disadvantage.
Okay. And is that, I heard the term perceived limitations. What does that mean?
So everything is based on perception. Everything that I spoke about is based on what your calculus of, for example, the environment is, what your calculus of the person's abilities are, what your calculus of your own abilities are. Certainly no one has a crystal ball in this. No one knows how this is going to end. So what we do is we calculate what we think will give us the best advantage in any type of a competition. If that competition is for medals or that competition is for life or death, it is pretty much done the same way. If I'm going to engage in this, I want to make sure that the advantage goes to me. And so I want to look at the efficacy of myself to determine whether or not I'm up for the task.
Okay. And so now an individual is doing kind of a risk assessment on his own situation. That's something you teach in police academies?
Yes.
Okay, and to civilians?
Yes.
And what's the purpose of kind of, I don't want to say setting a formula, but of giving these criteria, because certainly they're flexible. Is that true? Do I have that right?
They're flexible, yes.
So why do you teach these things?
Well, it's a dangerous world. It's a violent world, and a lot of times people find themselves in very dangerous or violent situations, and if they aren't prepared for that, they can be terminal situations. It may be the last thing they ever do. So I think most self-defense instructors are not attempting to teach people how to fight or even when to fight, but what to do if they find themselves in a fight. So it's generally what we refer to as defensive tactics. It's defensive in nature.
So is it fair to say the closer a threat is to you, that you are in a more dangerous situation?
Yeah, I think distance is always the great equalizer when it comes to advantage. Even with a firearm, if you get far enough away, then you won't be shot. It's very hard to hit a target that's much smaller, for example, that's off in the distance. Certainly, as you get closer, if we put our weapons away, for example, and we start to use hands and feet, we certainly want to be outside of the range of those hands and feet so that we're not subject to the reaction time principle of being able to recognize a threat and be able to properly respond to it.
And so with a shorter distance, now it sounds to me like what you're telling me is that there are more options for the threat to cause harm. In other words, now the hands are an option if they're close enough, right?
Yes.
And we've already discussed that can cause serious bodily injury.
Objection, asked and answered.
Okay. Let's talk about reaction distance gap. What does that mean?
So basically what you just said, which is with reaction time principles, we know them to be about 0.25 seconds. The amount of space that you can cover in a given amount of time based on that constant is the baseline for so much of what we do in self-defense and defensive tactics. For example, in law enforcement, it takes time to draw a weapon out of a holster. You want to make sure that somebody is at an appropriate distance, if you're even going to attempt to do that, that you can actually get the weapon out before being completely consumed by that person because they've closed distance so rapidly. In other occasions, if it's a hand and fist fight, as I said, you want to make sure that you turn every action into a two-step process, not a one-step process. What I mean by that is if somebody throws a hand at you, you want them to have to shift their body close enough to cue you that that hand's coming, to give you the reaction time, because it's going to take about 0.25 seconds to even realize they've moved. At that point, you can assess that movement and you can incorporate the appropriate defensive response because you've given yourself enough time to do it. If you stand toe-to-toe and there is no forward movement, the first recognition of being hit is usually being hit.
Okay. And I know you talked a little bit about stress factors, and I know that your study, your dissertation had to do with that. Tell us, in a situation where there's a threat has been perceived, tell me how stress factors into that.
So again, it goes back to what your coping mechanisms are. If your coping mechanisms are not adequate to deal with that particular threat, your body will start to do things that are not within your charge. They will start to, as I said, excrete various hormones, stress hormones in your system, catecholamines we call them, that will change the way that you feel. It will change your perception. It will, in some cases, give you more endurance. It will oftentimes give you more strength. These things that I think laymen call adrenaline dumps. That's really an epinephrine or dump that is a chemical response to fear. It's usually motivated by a part of the brain that is out constantly monitoring for threats. And so those physiological changes will start to occur, and it'll oftentimes change your ability to do things like, for example, think.
Okay. And are there certain physical manifestations of stress?
Yes.
Could you tell me about some of them?
You're talking about acute stress, not
Yes.
chronic stress. I mean, chronic stress is a different
No, I mean acute stress.
area.
Yes.
Acute stress that is sudden, ongoing, and the expectation is that it will be over soon. Some of those things that will occur, and I'll keep it on danger. We'll stick with danger. Is that you will, for example, have a narrowing of vision, something we call tunnel vision.
Now, let's talk about that. What does that mean?
It means that your eyes actually start to close in. The acuity of your eyes start to see the threat acutely to the degree that you can't see anything around it. It's often been described by people who are in very stressful situations as looking through a paper towel holder. I think that's perhaps the best image of it. I know that there are circumstances where individuals have been so stressed they've described it as looking through a soda straw. So it's a problem, by the way, for threat assessment when your eye can no longer see things outside of that direct threat. And it has everything to do with the amount of arousal, is the word we use, that you're experiencing based on that threat. And so that would be one of the features.
And again, that impacts somebody's perception.
Yes.
And in terms of anything else such as narrowing of attention, what does that term mean?
Well, attention means, of course, when you are doing your threat assessment, you want to be as attentive to the environment as possible. You want to see all things. You want to be able to analyze what's important in the environment. You want to be able to gate out the unimportant things, the things that are not threatening to you, so that it's not distracting. It doesn't cost mental energy. It doesn't cost attentional resources, is what we call them. And once you can focus on the important things in your environment, then you become more acutely tuned into those things, but at a cost. And the cost is if something changes in the environment and you are already starting to experience tunnel vision, you may not see it depending on your level of arousal. So there's a fine balance between wanting to be very focused on the threat that you understand and the ability to vacillate things in the environment that might also be threatening to you, that you'll want to see in the event that they suddenly turn into perhaps the bigger threat.
Okay. And the term distortion as it relates to manifestation of stress, what does that mean?
So perceptual distortions means that you'll actually see things differently, you'll hear things differently, you'll feel things differently, you'll experience things differently. For example, you may experience slow motion timing in a very stressful situation. In some cases, you may experience that things are farther away than they seem. In other cases, you may experience that they're closer than they seem. So your brain kind of plays these tricks on you a little bit and gives you these distortions in perception that other people are not experiencing around you. And you'll see very different, for example, testimony that comes from individuals, the one who is actually under the threat versus the one who is merely observing the threat. They will explain that circumstance very differently.
And so that doesn't make it any less real to the person that's being threatened.
No, it's very real.
Now, to prepare for this case, you reviewed materials like reports, interviews, a videotape.
Yes.
Let me talk a little bit about that. On the videotape, you could see an event that appeared to be the throwing of popcorn and the firing of the firearm. You remember that?
Yeah, among other things, but yes.
That's fine. And then between the time that the popcorn bag was thrown towards Mr. Reeves' face and Mr. Reeves fires, a shot was approximately 0.72 seconds. You remember that?
Yes.
And so in looking at that sequence, let me ask you this. You've looked at the video with the timestamps, right?
Yes.
Okay. And have you formed an opinion as to whether or not Curtis Reeves discharged his firearm in response to Mr. Oulson throwing the bag of popcorn at him?
I did formulate an opinion.
And what is your opinion? Sorry?
I object.
Approach.
Dr. Bedard, do you have an opinion as to whether Curtis Reeves discharged his firearm on January 13th, 2014 in the movie theater in response to Mr. Oulson throwing a popcorn bag at him? Do you have an opinion as to that?
Yes,
And what is your opinion?
that's not why he discharged his firearm.
Nothing further at this time.
Thank you. Cross?
We have just 5 minutes to chat, Judge.
Yeah. Do you want me to, are you going to go outside, or you want me to?
No, I just need to scoot around here.
Okay,
Chat for a minute.
all right.
I had to make sure it was still afternoon. When did you start training police officers?
In 1987,
Okay, and that was where?
at the time, Lively Law Enforcement Academy.
Okay. And then subsequent with that was in service at the agencies you were at?
Well, as well as I continued on with what later became the Pat Thomas Law Enforcement Academy. I continue to teach there.
And where is that?
It is in the same location. It is actually the same building. It was just simply taken over by the Tallahassee Community College rather than the Lively Vocational School.
And when was that?
I'm sorry?
When was that?
Oh, God. 89, maybe, in the late 80s.
And the teaching that you did was at those particular universities that you previously discussed, along with the agencies that you were with?
You're talking about the earlier testimony? Yes, I've taught all over the world.
No, I'm talking about the earlier testimony when you began teaching.
When I began teaching, I began at the Lively Law Enforcement Academy, and I continued on without break as it transitioned to the Pat Thomas Law Enforcement Academy. I still teach there.
Okay. Thank you. No further questions?
All right. May this witness be released?
Yes, Your Honor, he's on standby. We're still
Okay.
seeking
All right.
Yes.
Dr. Bedard, you're free to go. If you get called back, you have to come, but I'm sure they'll give you plenty of notice.
Okay.
Thank you. Council approach? right, ladies and gentlemen, I don't know about you guys, maybe it's just Wednesday, but I feel more tired than if it was like 8 o'clock already. But it is 5:16, I believe, according to that clock, a perfect quitting time for this long day. So we will start up again tomorrow at 8:30, and we are in good shape all in all, as I indicated it for our finishing by the end of the week. So, all right. Remember my instructions during the recess, please. No independent research. Don't talk to anyone about the facts of the case. Don't talk about the facts of the case amongst yourselves or anyone else, of course, and don't watch the news. And have a great evening, and I'll see you in the morning. Thanks, everybody.
All rise, court is in recess.
Morning. Thank you, everybody. Have a good night.